Hearing master hearing. Item A9, rezoning PD 20-0374. This application is being continued by the applicant to the January 19th, 2021 zoning hearing master hearing. Item A10, rezoning PD 20-0382. This application is not awarded to be heard and has been continued to December 14th, 2020 zoning hearing master hearing. Item A11, rezoning PD 20-0389. This application has been continued by the applicant to the January 19th, 2021 zoning hearing master hearing. Item A12, RZ PD 20-0394. This application is not awarded to be heard and has been continued to December 14th, 2020 zoning hearing master hearing. Item A13, major mod application 20-0801. This application is being continued by staff to December 14th, 2020 zoning hearing master hearing. Item A14, major mod application 20-0898. This application is being continued by the applicant to December 14th, 2020 zoning hearing master hearing. Item A15, rezoning PD 20-0985. This application is being continued by the applicant to the December 14th, 2020 zoning hearing master hearing. Item A16, major mod application 20-1068. This application is continued by the applicant to the December 14th, 2020 zoning hearing master hearing. Item A17, RZ PD 20-1071. This application is continued by the applicant to the January 19th, 2021 zoning hearing master hearing. Item A18, RZ PD 20-1142. This application is out of order to be heard and has been continued to the December 14th, 2020 zoning hearing master hearing. Item A19, RZ PD 20-1148. This application has been continued by staff to the December 14th, 2020 zoning hearing master hearing. Item A20, RZ PD 20-1149. This application has been continued by the applicant to December 14th, 2020 zoning hearing master hearing. Item A21, rezoning standard 20-1171. This application is out of order to be heard and has been continued to the December 14th, 2020 zoning hearing master hearing. Item A22, RZ standard 20-1279. This application has been continued by the staff to the January 19th, 2021 zoning hearing master hearing. And item A23, RZ standard 20-1282. This application is out of order to be heard and has been continued to December 14th, 2020 zoning hearing master hearing. That concludes all withdrawals and continuances.
Okay, thank you for that, Brian. So ladies and gentlemen, with respect to our procedures tonight, and in regards to all the rezoning and modifications to zoning requests on the agenda, the Land Development Code requires that a public hearing be conducted by a hearing officer prior to a final decision by the Board of County Commissioners. The land use hearing officer does not make the final decision, but instead renders a recommendation to the board, who makes the final decision at their public meeting. The hearing tonight is generally going to be informal. Questioning will be confined as closely as possible to the scope of direct testimony. What that simply means is that you'll be talking directly to me. As the hearing officer, I'll call and question witnesses as necessary and appropriate, and I'll decide all questions on procedure. Irrelevant, immaterial, or unduly repetitious evidence is going to be excluded. Any part of the evidence may be received in written form. All of your testimony is going to be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but it won't be sufficient in itself to support a finding unless it would be admissible over objections in a civil action. So having said that, the basic procedure that we'll use tonight to conduct the hearing is as follows. After a brief introduction of each petition by staff, the applicant and any other witnesses can come forward, and they'll have up to 15 minutes to present the petition. At that point, I'll turn and ask for Development Services to provide a summary of their staff report and findings, and they'll have a period of about 5 minutes to do that. I'll then ask for the Planning Commission to give a statement of compliance or non-compliance with the comprehensive plan, and similarly, they'll have 5 minutes to do that. At that point, I'll ask for any proponents. Proponents are not a chance for the applicant to speak again. Instead, there are other parties who might be supporting the petition, and there'll be a time period of up to 15 minutes for everybody to speak as proponents. I'll then ask for any opposition in the audience. If there's opposition, a similar time segment of 15 minutes will be set aside. That includes everybody. So if there's more than one, and if you know each other, certainly get together and see if you can promote a primary speaker. And if not, we'll just simply divide it up based on the number of people I see that need to speak. So after that, I'll turn to county staff and the Planning Commission and ask for any changes based on the testimony that was heard. And lastly, the applicant will have the final opportunity for rebuttal for a period of 5 minutes. A couple of tips for you when you come forward to this podium that's directly in front of me. First, there's a microphone up there. So when you step up, pull the microphone down close to your mouth so we can make sure that everybody can hear you. And when you go to speak, name and address first. Name and address first. If for whatever reasons during the course of the hearing you need to sit down and I ask you to come back forward again, come back up. And when you go to speak, no need to repeat your address, but there's always the need to repeat your name. So say your name before you go to speak. And that's just simply so the record has a documentation of who's speaking at the time. Always speak clearly into the microphone. And when you're all done, go from the podium over to a sign-in sheet at the end of this desk to my right and sign in. And that will also document the fact that you provided testimony tonight. At this point, I'm going to ask for our Assistant County Attorney to provide you information about the legal requirements for oral argument and that govern your participation to be able to speak before the Board of County Commissioners.
Thank you, Mr. Scarola. My name is Cameron Clark. I'm an Assistant County Attorney. Tonight's public hearing is the first step of a two-step rezoning process. This hearing is the time for rezoning applicants and interested parties to present testimony and evidence. Any evidence presented tonight will become the complete factual record of each application, and no additional evidence can be introduced after the closing of each application. The second step of the rezoning process is a public meeting before the Board of County Commissioners, where the board will take a decision on each application heard tonight. Tonight's applications are scheduled to be heard by the board at its January 12th, 2021 land use meeting. When considering applications, the board will only review the record created at tonight's hearing and the recommendation that is made by the hearing master for each application. The hearing master will file a recommendation for each application heard tonight on December 9th. The Board of County Commissioners has established a policy that directs which rezoning and major modification applications are to be placed on the consent agenda of the board's land use meeting. Applications that propose to add density outside the urban service area and applications that would result in a failing level of service on the roadway are not qualified for placement on the consent agenda. Applications which do not have consistent recommendations of approval or denial are also not qualified to be placed on the consent agenda. Please be advised then that applicants and parties of record shall be required to submit a request for oral argument in order to address the board on these items. Any party of record wishing to address the board at its public meeting must execute and submit a request for oral argument form explaining why oral argument is necessary. Request for oral argument must be responsive to the hearing master's recommendation. Therefore, such request cannot be filed until after the hearing master has submitted their recommendation to the county on December 9th. Following this date, any party wishing to address the board at its public meeting will have 10 days to submit a request for oral argument to the clerk of the Board of County Commissioners. Therefore, for tonight's applications, if you wish to address the board at its January 12th land use meeting, you must file your request for oral argument between December 9th and the close of business on December 21st. While the board is not required to hear oral argument at its public meeting, the board can elect to hear oral argument from a party of record. A party of record is an individual who fits into at least one of the following four categories. First, someone who is present tonight and presents testimony or documentary evidence. Second, someone who is certified by the U.S. Postal Service as having been mailed notice of tonight's hearing. Third, someone who submitted documentary evidence to the master file at least 2 business days before tonight's hearing. Or fourth, someone who submitted documentary evidence by proxy at tonight's hearing. Should the board elect to hear oral argument, parties of record will be eligible to address the board if their requests for oral argument are responsive to the hearing master's recommendation, and if they clearly set forth why oral argument is necessary to address at least one of the 4 outstanding issues that are laid out in section 10.03.04E of the Land Development Code. If the board elects to hear oral argument, the content of the argument shall be limited to the content of the testimony and other evidence that is submitted verbally or in writing to the hearing master tonight. It's the role of the county attorney's office to ensure that only individuals who've met these requirements are allowed to speak before the board, and to ensure that no new evidence or testimony is introduced or allowed at the board's public meeting. For these reasons, please make sure that all information that you wish the board to consider at its public meeting is entered in the record tonight. Thank you.
Thank you, Mr. Clark. So ladies and gentlemen, and anybody listening that intends to give any testimony or evidence tonight, I'd like you to rise now with me and raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
I do.
All right, I think with that, Brian, we're ready for our first petition.
The first item is agenda item B1, rezoning PD 19-1344. This is a remand application. The request is rezoned from AS1 to plan development. Steve Beachy will provide a summary of staff report after a presentation by the applicant.
Good evening.
Good evening. William Malloy, 325 South Boulevard, Tampa, Florida. This case came to you some time ago with all recommendations of approval and consistency. When we got to the board, the commission remanded this case with the instructions to look at the county land immediately adjacent to the north and see if it could be possibly incorporated into the project.
Mr. Malloy, in that respect, can you, before you go on, can you let me know if anything else changed about this project in the interim?
Condition number 10 in the staff report, otherwise nothing.
All right, then I do want to make the general rule for this hearing tonight that we're going to be discussing the park and compatibility issues as it relates to the park.
Mhm.
But that's the extent of the hearing if nothing else has changed. And so go ahead, put that in mind.
Very good. Thank you. So we took that to its inevitable conclusion with county staff. We resolved some of the title issues that precluded the incorporation of the park previously. The park is platted land inside of a PD, inside of a DRI. So practically including it in the zoning, it was absolutely impossible. We did get to condition number 10, which stipulates that upon the appropriate public outreach and acceptance by the county of the terms and conditions, et cetera, if all that comes into place, we will develop the park with the county and maintain it going forward. So that condition is the sole change to our application.
Okay, I'm almost hesitant to ask this, but I do want to ask because I read the condition, and this is a piece of county-owned property, right?
Yes,
And you want the ability to be able to develop it as a park?
I believe that it's in the interest of this zoning to pursue the avenue of developing it as a park to the best of our abilities.
Okay, has it been discussed with the Parks Department?
We have vetted it with the Parks Department, Parks and Recreation. They are aware of it. They are neutral as to the possibility of developing it as a park.
Okay. In this condition, did you guys write the condition or have you vetted the condition out with staff?
I wrote it. I transmitted it right to Adam Gormley. And as far as I know, it's trickled down all the way to what you see in the staff report.
For instance, now keep in mind, if it's county-owned property,
Mhm.
in 10A discusses for the benefit of the project and the surrounding community. You want to take a look at that before I go on?
Well, I believe that is part of what we would see as the future process with this park. If the community at large, the surrounding community, is inclined to have us pursue this avenue, that is the benefit to them. If we have the public outreach meeting and there is no interest or negative interest, I believe it's a moot point.
To undertake the appropriate measures to engage the feasibility of constructing a public park for the benefit of the project and the surrounding community. It seems to me like the public park has to be for the benefit of the public only. It's public land.
I wouldn't disagree with you. And if that's a material objection to that condition as it's written, we're happy to change it. Again, these were written and drafted by us. So
Okay.
I think by the park, by nature, it is for the benefit of the public.
Okay. In Part C, however, ongoing maintenance and management of the park site shall be the responsibility of the homeowners association.
Correct.
Is that even possible?
Through what will be a very tiresome and laborious set of agreements, it is possible.
How could a private entity, unless there was a private-public partnership of some kind, how could a private entity be responsible for maintaining public lands?
I believe the avenue would be if not a 3P agreement, some kind of maintenance agreement with the county that the HOA will be responsible for making sure that the park is properly maintained. And I think what they were really contemplating in that was maintenance of the equipment and landscaping.
And has the county attorney's office seen this at all?
That I cannot directly speak to.
All right. And is it your opinion that this addresses whatever question was brought up on remand?
To be blunt, no.
Okay.
I think that the intent of the remand was to see if we could diffuse any of the density of the project. That's obviously, that's not possible. You can't take a county land and spread our density onto it. That's a non-starter. I think the commissioner wanted to see us maybe be able to say that we had a lower density, a higher size lot, but this was the outcome that was the only practical one at the time.
Okay. Anything else, Mr. Malloy?
No, we do have a PowerPoint presentation for the benefit of the board. It only restates what's part of the record. This is just kind of something extra for them. I'm not sure if Bill's.
I'm not going to help you out with the legal side of this. You got to decide whether how.
Yeah, I'm going to have Bill spin through it real quick,
Okay.
just so it's ironclad that it's on the record.
All right.
And Mr. Scroll, I think that's the best course of action. Just
William
to
Sullivan.
for the record. Thank you.
Hello, good evening.
Mr. Clark, could you repeat that?
Yes, I was just going to place into the record that I think that's the best course of action. If they want to be able to show the PowerPoint to the board, they're going to have to enter to the record tonight and ensure that Mr. Malloy is able to hand a physical copy, zip drive or thumb drive containing the PowerPoint presentation. Has to be handed in tonight.
This was submitted to this PowerPoint was submitted to the record in the optics about 2 weeks ago, a week and a half ago. Yes, sir.
All right.
So it's already in the record. I'm not bringing anything new that hasn't been submitted.
All right. Mr. Clark, any objection with that point?
No, that's fine. It means it's already part of the record, so it's good to go.
For the record, thank you.
Okay. Thank you.
I'll start again with my name because, yes, William Sullivan, Potomac Land Company, 1350 Orange Avenue, Suite 201, Winter Park, Florida, 32789. Let's keep going. How do you go to the next slide on this thing? Oh, here at the bottom, sorry. Oh, just scroll down. Oh, there we go. Okay, they just wanted to show a location map for the record. It's is located adjacent to Bloomingdale, and then it's located in the middle of the community that's here tonight to speak. It is also, we'll just go through the other slides. Okay, so here we go. It's zoned R. Its land use is R4. The surrounding areas to the north is R4. To the west is R4 and R2. To the east and south is R2. The zoning map is, it's presently AS1. It's in the middle of the urban service area.
So let me stop you for
yes.
a second. So in the beginning of this, I'm the one that directed that if this was a discussion about the park and what you've done.
We are about to get to the discussion of the park. Apologize. This is just for the record. This is just so we can.
I just want to make sure we don't rehearse.
No, we're not.
Rehash the old stuff.
We're not rehashing the old stuff. Okay, I'll just go through it. This is the urban service area. This is the PD to be thing. There's the site layouts of the typical lot line, which are, 75-foot minimum wide. Then the landscape buffer around the east and the landscape screening around the east and west side of the site. And then a landscape buffer to the south of the site. There's the concept plan that shows the park. Here's a plan of the park, which I think is kind of important. So one of the purposes of the park and one of the main purposes of the park is presently there's connectivity to the north into Bloomingdale to get down to Camino Elementary. Now, there may not be zone for Camino, but the kids right now are using this property, and the owner here can testify to that. The kids are using this trail. There's a trail through our property now. We want to continue to allow the kids to be able to get to school without having to get into cars. Even though they're not zoned for that area, parents can decide to send their kids there, and they do in Bloomingdale. Here's another look of the park. I can't really, my glasses fog up, but I can just go through it, is that we're going to have a trail which is on a 30-foot right-of-way to the north. Its right-of-way is only a pedestrian right-of-way. It's not a vehicular right-of-way. To the north, tying
Can you
into,
point that out?
where's a point? How do I point things out?
Oh, I don't know. If you don't have if it's not on the Elmo, I guess you can't do it.
Well, I can put it on a,
Describe it to me. Where is the line work that you're talking about?
okay, to the very northwest corner of this property, that's Bloomingdale. There's a road there, see it?
Yeah.
Okay, and then it goes, the trail will go through the existing, basically the existing trail the kids take now. And then where the existing trail goes all the way down, then it will go to the east and then it'll come through the park. Sorry about that.
All right.
And then there's a playground going to be in there, and then there's some other areas, and I apologize, but my vision is not that good. Hold on. And so that's, and the trail is being built to the multi-use trail typical section, which is in the county transportation technical manual. So we're using the exact materials and the way that the county wants it. I want to also, while we're talking about the trail, let me explain how it works with the maintenance of it. We are volunteering through HOA docs. We are volunteering to maintain it, not only build it for the county for a park, but then maintain it as part of our homeowners association. We believe it's a benefit to our residents as well as Bloomingdale, as well as all the other residents in the area. And so that's kind of what we're doing. So, and there's the potential park. It's a little bit better. Here we go. This is a closer up one. It shows the playground area, and then it shows a family fitness trail kind of a thing, and then maybe some, picnic tables up at the north and a small pavilion. It's just a concept, this is clearly a concept. Another thing, then we, getting off the trail, but to finish the presentation, we have the traffic analysis. And just so you know, we have spent a lot of time with county staff, specifically with, Billy did with Adam Gormley, and warming up to the idea of building a trail. When we originally, building a trail and a park, when we originally started this, there was a lot of opposition internally from going this direction. And the Commissioner White rightfully identified that if a commissioner pushes it, it could get done. So that's kind of where we are from that standpoint. The traffic flow shows, and then here's Bloomingdale. One of the problems with this whole area is that there was never connectivity to begin with, and it's kind of out there, and it would have been better if there was. A good example is the county at one point had a owned right-of-way to get out to Culbreth, but they sold that right-of-way in 2006, losing the opportunity for any connectivity out to Culbreth. So there's a lot of, and that it was not a very wide, it was only 30 feet, so that could have even been a pedestrian connectivity, but they gave it up. So this is like their last chance to have connectivity from Bloomingdale to the north to this community to the south. So it just brings community. And also, just so you know, we're still building the sidewalk. We're not deviating from building the sidewalk, which we had originally talked about doing. So now we're just adding additional connectivity. And there's the sidewalk improvements, which is the 3,100 feet. There's a connectivity map, compatibility. We had a community meeting on January 22nd, and then the people who attended the community meeting, and there ends the slide presentation.
Okay. Thank you for that.
Thank you.
Anything else, Mr. Malloy?
We reserve any time that we have left for the part of the rebuttal.
We'll just do a rebuttal.
Okay, that's fine.
All right. Thank you.
Mr. Sullivan?
Yes, I got to sign in, sorry.
All right. And then development services.
Good evening, Steve Beachy, Development Services. The application was remanded by the BOCC on August 11th to bring in the 11.8 acre county-owned parcel to the north of the subject site into the project to, as has been indicated, address better compatibility with the community plan. In response to the remand request, the applicant has chosen to move forward with the same plan, incorporating the condition that allows for the development of a park on the parcel referenced in the remand request. Development Services has previously supported the plan as presented, with the addition of a condition to include a park to the north of the subject parcel. Our recommendation remains unchanged. I'm available for any questions.
Mr. Beachy, do you know if it was passed by the county attorney's office at all with respect to the public-private deal that these conditions?
No, I do not. I'm not aware if it was discussed with the county attorney. It was discussed at the highest levels of our department. I know that. So that's what I can tell you.
All right, thanks for that. And then the planning commission.
Thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located in the residential 4 future land use category. It is in the urban service area and also located within the limits of the Brandon Community Plan. This case was remanded to the November 16th CHM to allow the applicant to engage Hillsborough County Real Estate and the Hillsborough County Parks Department on the feasibility of constructing a public park on the parcel located directly north of the subject property. If this agreement is made between the applicant and the real estate department, it will not affect the compatibility or the density of the site. Taking into consideration that the site is located within the urban service area, meets the Brandon Community Plan's vision and policy direction of the comprehensive plan, the request for residential units in this location would integrate well into the established development pattern. And based upon those considerations and the Planning Commission's previous testimony, Planning Commission staff finds the proposed planned development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions recommended by Development Services. Thank you.
Thank you for that. All right, is there anybody here tonight in support of this request? Anybody in support? Okay, seeing none, is there any opposition tonight? There's somebody in support. Good evening.
Hello, my name's Karen Sue Coggins Powell, 5949 Lockhart Road, Brooksville, Florida. Basically, I'm the trustee of the property, the owner, with my brother. I have some concerns about some of the things that were said in prior meetings by Ms. Chomsky. I'd like to have.
Well, so ma'am, this isn't an opportunity to rehash the old hearing. It really is about the addition of the park. The plan remains the same, about the addition of the park and compatibility. So I really, it's not the opportunity tonight to be able to do that.
Well, one of the things that was said is I am concerned about them continuing to try and use our property to walk on or get to school if it's not, because they have been trespassing on our property in the past.
Okay, that's okay. Go ahead.
Okay.
Yeah.
So I want it made clearly known that I do not want anybody on this property if our contract goes away. Okay.
Anything else, ma'am?
All right. I think that's it.
All right, thank you. All right, anybody else in support? Anybody else in support tonight? Okay, how many do we have in opposition that need to speak? We have, is it one virtual? None virtual? Okay, and if you're here tonight and need to speak in opposition, raise your hand. Yes, ma'am, opposition. I see one hand. Is there more in that direction? I don't.
They demand their time to meet.
Okay, so you're the primary speaker.
Yes.
Come on up, ma'am. Thank you. Good evening.
Let me pull this up here. Yeah. Does that work for you guys? Yes, ma'am. Okay. My name is Margaret Jamsky, and I live at 4406 Loma Vista Drive in Valrico, and I'm here as a representative of the Vallow Hills and Neighborhood Alliance. We're here because of a remand that was agreed upon, not to discuss a park, but to create infrastructure in a way of sewer and water to the county-owned parcel in order to save money for the developer in hopes he could still meet his profit margin while producing a larger lot.
Ma'am, is it your contention that that's what the remand is about?
Yes, sir. If I could read you what Commissioner White said, when I brought this email to his attention at the board, it was also in the meeting we had with you prior. After I showed him this slide, he said, I'll quote it, "I'm going to move to remand with the purpose of bringing applicable county staff to the table to talk about how that county-owned parcel could come into play and ultimately help the applicant and the community get to a place where we have better compatibility with the community plan." We'd like to make it clear, sir, we're not trying to stop the development.
Hold on. So I heard you. I heard that comment. I didn't hear water, sewer, anything in there.
Because we were talking about this email that suggests, is there a possibility to run water and sewer through that county-owned property? The developer has said that it's cost him so much money to bring it out to Lithia Pinecrest. And so we said, well, how about just using the sewer and water that's already there? That'll give you a quick connection and maybe save some money, and you wouldn't have to do the whole connection.
What does that have to do with compatibility?
The compatibility is what we're asking for, to have half-acre parcels on that property. That's a compatibility with a Brandon community plan that states we're in a garden state area. It should be at least a half-acre in size.
That was definitely a subject of the previous hearing. The issue of bringing in the park and compatibility is a separate issue.
We didn't ask for a park. That was Mr. Sullivan's, I guess, reaction to bringing the sewer and water through there. How a park ever came out of that, I have no idea.
And Commissioner White's statement that you just read, didn't it mention the park?
It says to use the property north of this parcel to help the applicant and the community get to a place where we have better compatibility with the community plan.
Okay.
And the community plan is that we reside in a space of garden estates that have at least half-acre size parcels.
Well, so other than the use of the park, what was it that you expected out of the park itself?
We don't expect anything. We all live on 1, 2, and 5 acre tracts. We don't really need a park. If we want a park, we go to Alderman Ford or Lithia Springs or wherever we want to go for a park. The park has nothing to do with us as far as we're concerned. We've never asked for a park.
Okay, go ahead.
Okay. We're not trying to stop the development of this land at all. We're only trying to ask that he would make it compatible to what surrounds it on all 3 sides. We have property rights as far as we believe that should maintain our chosen lifestyle. This neighborhood was formed in 1972. I think if you'll, I don't want to repeat anything, like you said, we don't have to go through that whole thing. But there's a few definitions I feel like have gotten lost. Compatibility. The county and the planning commission has told us several times it's not the same as, and we agree. Compatibility, according to the Land Development Code, says it refers to the sensitivity of development proposals in maintaining the character of existing development. We're the existing development. These 3 definitions here also are who we are. We're an established neighborhood, we're an existing development, and we're agriculture single-family development of AS1. For the record, these are statements from the optic system that the developer has used along with the county. 3 of them, the state. Given the rural and residential nature of the area, blah, 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 goes on further to say, the site is rural and isolated. And again, it's a primarily isolated site in a rural setting. And it seems that we all agree we're in a rural setting. It's only the policies and objectives that were followed up to this point that have brought us to this place. If those policies and objectives have been followed as prescribed, talk about the concentric circles coming out from the center of town, blah, 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 to meet up with the rural area, we probably wouldn't be here. Again, the Brandon Community Plan, you're well aware of it. The primary consideration should be compatibility with existing structures to ensure neighborhood preservation, protecting established neighborhoods, and the garden estate, single-family homes with lot sizes of at least a half acre. Again, the garden estate's definition. These are all things that come right out of the Land Development Code, the Brandon Community Plan, which is part of. According to the purpose and guide, the future land use element, or excuse me, the objective is it's a guide, a guide for development. This property is surrounded by R2 on 3 sides. The only congruent property that he's wanting to compare to are 5 small parcels to the northwest. They only total about 20,000 square feet. The rest of it surrounded, I broke down the percentages of at least 1 acre sites. That's a big difference to use a small congruent 5 pieces of property as the guide that we're following. As you can see on this big map we have here, because we feel like it shows a much better picture on the other side.
Are you going to submit this into the record?
Yes, sir.
Okay,
We have the slide, we have a picture in the slide, so it can be.
you do, okay.
We talk about the minimum density, but they leave out the last part where it says or the existing development patterns don't support those densities. If you look at that map, here's our neighborhood.
I need you to speak into the microphone, please.
You got to get in the microphone, man.
Can you show our neighborhood? There's our neighborhood. And the 5 properties we're comparing to is those little 5 properties right there that aren't even accessible to this property. That's a big impact on the surrounding area. On the other side shows a 1,000-foot radius that will be affected by having a smaller community in there in our agricultural farm animal owned area. It just is going to be a difficult transition. That's why we're asking for larger lots. Let me sit down. As we go on to the objective 16 is the neighborhood protection right. It talks about protecting existing neighborhoods and communities. It talks about reflecting the character of the surrounding area. And any density increase should be compatible with the existing surrounding development and maintain the character of the existing development. Also, the objective 18 talks about it again. How the plan didn't call for, the whole plan didn't mention anything, so we developed community plans and special area study just for this. Policy 18 of future land use says that these specific policies will apply. The LDC says the more restrictive requirement shall prevail. I'm not making these words up. These are coming out of the plan. Shall apply, will prevail. Those 2 policies alone should stand in our favor. Those are the words in the code that you guys made. Now, these are some pages right out of the community design neighborhood design component. I'm sure you recognize them. I'm not going to list them all because you know them, but every one of them talk about when you smash up to a lower density that you need to comply with it. Again, the concentric circles were not followed through. We came before the Planning Commission and the Board of County Commissioners to talk about our designator. At one time, a portion of our property, of our neighborhood was an R4 because we just were forgotten. When those lines were drawn, they didn't even know we were out there. And we can't fix that now, but we can correct the policies and to put them in place of what they should be. That's all we're asking. I won't go through all those because you know them. Something else we've talked about is the natural tree line. It clearly states where new development encroaches on existing strands of trees adjacent to the roadway, retain a viable strip of existing vegetation. We're told we can't do that because of the drainage situations. And I have a map of elevation. We're one of the highest points in Hillsborough County. We're at 62+ feet up there. We've got retention ponds in the school behind us, down to the property that I've never seen water and lived there 38 years. We're hoping with the suggestion of reducing the amount of retention ponds he has to have, and along with perhaps changing some of the entrances to this enclave. You see 3 of them here, when ultimately there's only one entrance and exit marked in yellow in and out of our neighborhood for 113 home sites. So between those 2 suggestions, we're hoping we could help Mr. Sullivan develop this land as he liked, but to give us the larger lots that we've asked for. Now, the 2 different district options that they can select are a PD and a PD specific. And we've talked about that the last time we were together. We really are concerned that this is a PD specific piece of property. Because if he files just a PD, he can come back later and ask for a modification and perhaps get more homes. We put a couple examples up here to show that that's exactly what happened. And those modifications were significantly increased, significantly, not just a few. And we're concerned about that. That's why we're asking that he file a PD specific or sit down and get the plans so they can't be changed. From the very beginning, we've only asked for 2 things, half-acre parcels and a natural tree line. We have farm animals. We're horseback riders. We have roosters crowing and chickens walking around and goats screeching. That's not something a neighborhood with that many homes are going to tolerate for very long. You can see by this map, we've been encroached upon to the north, northwest, to the bottom left and southwest corner. Had we known then what we know now, that probably wouldn't have happened and we wouldn't be here today. We know we can't change any of that. We're not asking to change that. We're just asking that you utilize the codes and policies put in place to protect our long existing neighborhood. The staff analysis even agrees that the existing developments and patterns don't support the densities. The majority lot sizes do not support those densities in that area around it. Both reports say there must be protection of the existing well-established neighborhoods such as ours. They both say that we do lie within the Garden Estates where those parcels are at least half-acre in size. And they both state that when there's a conflict between the plans, the more restrictive plan presides. We don't understand how it keeps getting approved. Even the FLU said there's going to be conflict because of the suburbs coming into the rural area, and that we could have a flexible alternative solution to the problems. So we offer this. Reduce the density, have half-acre parcels as deemed comparable or compatible in the Garden State District. Include a more natural Florida non-invasive vegetation, a natural tree line, a screening enhancements, not a wall of white fencing surrounding that enclave. Comparable easements on all sides of the parcel. And a night skies policy or something similar to help that the light pollution won't direct towards our farm animals and ourselves. And finally, the whole reason that we felt we were here for this remand, because we want to find out, can he save some money by putting that sewer and water line through that part of the county property? That was the whole thing was started over. This whole remand started over that. I don't know how we came to a county park over it. We don't need a county park. Well, I got a park in my backyard. And the rest of these slides here are just if we have to present them to the board. Those are the elevations we talked about. You can see a little red area there at 62 feet, and way down at Lithia Pinecrest is about 19. Those are some of the homes in our neighborhood. We're a well-established neighborhood. These are horseback riders. This is what we deal with now with people who don't understand how to drive around horseback riders. It's been an ongoing problem. Not to mention the school board that does not zone our neighborhood, nor the neighborhood north of the property. I've seen children in those woods. Well, I shouldn't say I've seen. I've heard them in those woods, usually late at night. The local teens from the other neighborhood, because most of the kids in our neighborhood get their little rear ends tarred if they go in there, and they know that. And we've gone in several times and asked them to leave. I've watched trucks go in there and dump garbage. And I have called the police, followed them to where they went, and had them come back and remove it. We're trying to help keep that piece of property clean for the owners. Thank you.
Thank you, ma'am. All right, anything from Development Services?
Well, Mr. Squirrel, I can confirm that the condition was sent to the county attorney's office, so they're aware of it. And also the Parks Department did review the condition and had no objections to the condition as presently
So
presented.
sent to both agencies, but
Yes.
you didn't get any objections.
No objections, correct.
All right. Thank you, Brian. Anything else from the planning commission?
No, sir, thank you.
Thank you. And then the applicant.
William Malloy again for the record.
So, Mr. Malloy, I fully recognize that we got outside the scope of my original discussion, but it's your opportunity to address any of those items. I felt like it was in the interest, to the extent that there was any component of that
Sure.
that might be related to an unclear remand.
No, understood. I think that we are, and I appreciate that. We're inclined to rest on what staff has determined, and obviously what we feel is our very good faith interpretation of the land development code and the comprehensive plan. I would state again for the record that 10,000 foot lots where this project is, we think is more than an appropriate bridge, buffer, transition, whatever term of art you want to apply to it. If you look northwest of this, you're looking at 40s and 35s and multifamily, and we think 10,000 is more than respectful of the existing neighborhood. I'm not inclined to parse what I saw as kind of the cherry pick sections of the code. And again, just relying on the general determination that this is a compatible project, and that's what the trained professionals downtown have come up with. I'm not sure if Bill had anything he wanted to add, but that's it for me. Thank you.
Okay, thank you.
I just wanted to, William Sullivan, I just wanted to state for the record that we were quoted that that our report showed that the property was rural and isolated. Well, that had to do with the wildlife, sir. So it has to do with the fact that it's a upland, an upland woodlands that's surrounded by, already developed property.
Okay. Is that it? All right, thanks for that. And with that, we'll close rezoning remand on 19-1344. At this point, I'm going to turn the hearing over for the 3 following remand cases to hearing officer Susan Finch.
Then is agenda item B2, major mod application 19-1462. The applicant is True Gardner or Gardner Brewer Martinez Montfort. The request is for a major modification of existing plan development. Israel Monsanto will provide staff presentation after presentation by the applicant.
Hi, good evening, Ms. Finch. Good to see you again. Tyler Hudson, 400 North Ashley Drive. We are here on remand of our own volition after your recommendation of approval. I'm just going to cut right to it. The staff report did an excellent job of crystallizing what the issue is. We had a labeling error. There was a 0.3 acre parcel or piece of our parcel towards the west that was labeled as a wetland. It is not a wetland. It is set aside for future mitigation. EPC has obtained a conservation easement over the property, but as we learned, until EPC actually furnishes the initial compliance letter, it is not yet wetland, and therefore not the property adjacent to it is not subject to the 30-foot setback requirement. The original site plan that we showed did comply with setbacks if it were a wetland, and now that it is no longer a wetland, we are adjusting the setbacks to reflect what code requires. I have 5 copies, which I'll enter into the record now, of correspondence between the EPC and Natural Resources confirming this, and that is the only change that that we have. I'm happy to answer any questions.
I just had one question, and that's based on a comment in the staff report that talks about under the remand summary that Mr. Monsanto wrote about this case. It says, according to Hillsborough County Environmental Protection Commission, the wetland construction process commences with an initial compliance letter, and that letter has not been received yet, which is what you just stated. And so the section says that EPC is still reviewing that area, as you stated. Is there any chance that they will find that this is a wetland, in your opinion?
I believe the intent that it is eventually going to be a wetland. I think but the issue is that there's an ongoing compliance period where the area is reviewed and evaluated. So for example, even though this is not currently a wetland, we are not taking advantage of this 0.3 acre parcel for density purposes. We're keeping it as a wetland for those purposes. But as to setback, since we need to go ahead and move forward with our building construction, not knowing when or if the wetland will be finalized by EPC, that's why we initiated the remand to come back to change the footprint of our building.
I see. And so it will be in recognition of that 30-foot setback? Is that correct?
No, ma'am, because right now it is not a wetland. The condition that was proposed by staff is that at the time of permitting, if it is a wetland at that point, if it's declared as such by the EPC, then we would need to meet that requirement. But as of now, it is not a wetland, and so that operative provision of the LDC simply doesn't apply. So the setbacks we show on the remand site plan comply with code.
I see.
Yes.
All right. But at some point, you anticipate that that will be a wetland and your building will adhere to that in the future when that's determined officially.
When it's that's right. Any reconstruction of that building, it's a little bit metaphysical, and this has certainly been a learning experience as far as when does a wetland actually become a wetland, and it turns out it's when EPC established it as such. And so again, that's why for density purposes, we are leaving it as is. It's not counting as uplands for those purposes. But for now, for the construction of our building, we propose to construct it in accordance with the land development code as it is. And if it's not a wetland by EPC's terms, at the time of permitting, then we do not need to comply with a 30-foot setback.
All right. I understand. Thank you so much.
Thank you.
Appreciate it. If you could please sign in with the clerk's office. Yep. Development Services, please.
Good evening. Israel Monsanto Development Services. The applicant requested a remand to a zoning hearing master hearing because according to the applicant, the site plan reviewed at the August 18th, 2020 ZHM, which is called the original ZHM site plan, contained a material factual error. That original site plan depicted an area towards the western edge of the site that was labeled as wetlands, which would have obligated the developer to comply with the 30-foot setback requirement in accordance with the Land Development Code, Section 40107B4. According to the Hillsborough County Environmental Protection Commission, the wetland construction process commences, as you stated, with an initial compliance letter, and that letter has not been received because the EPC is still reviewing that area. Also, accordingly, that section of the code I just referenced, 40107, is inapplicable at this time, and no 30-foot western setback is required. Therefore, the area labeled as a wetland in the original zoning hearing master plan is a mitigation floodplain compensation area today. That's why the applicant would like to amend the site plan to show the removal of the 30-foot western setback, since there is no functioning wetland to the west. And this change cannot be made couldn't be made between the August CHM hearing and the Board of County Commissioners, and that's why we are here in the remand. The site plan has been amended, removing the 30-foot building setback along the west, where the floodplain compensation mitigation area is labeled. Per recent communications with the APC, that wetland mitigation area southwest of the site has not been accepted as a functional wetland. Also, Natural Resources staff indicated that since the mitigation area is relatively new, there will be no required setback. The APC and Natural Resources review the updated site plan and does not object to the proposed changes. The project will require, though, final approval by the APC and Natural Resources at the time of preliminary site plan or construction plan review, and will be reviewed in accordance with Section 40107 of the Land Development Code. We have a new condition, 10.1, which was added stating this requirement. All other requests and conditions part of the original major modification application has remained unchanged, and no objections were received from other reviewing agencies as part of this remand. And I'm available if you have any questions.
Have any at this time, but thank you so much. Planning Commission, please.
Thank you, Melissa Leinhard, Planning Commission staff. The subject property is located in the residential 4, residential 20, and office commercial 20 future land use categories. It is in the urban service area and also within the limits of the Carrollwood Northdale Community Plan. The applicant requested a remand to the zoning hearing master meeting this evening because according to the applicant, the site plan reviewed at the August 18th ZHM hearing contained a material factual error. The site plan has been amended, removing the 30-foot building setback along the west. All other requests, part of the original major modification application, remain unchanged. And based upon those considerations and Planning Commission staff's previous testimony, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services. Thank you.
Thank you. I appreciate your testimony. All right. Is there anyone here in the building that would like to speak in support of this application? Anyone in support? Seeing no one, I understand we don't have anyone participating virtually. All right. Is there anyone in opposition to this application? All right. Seeing no one. County staff, anything further?
Nothing further.
Sir, do you have anything you'd like to add? All right. Then with that, we'll close major modification 19-1462 and go to the next case.
The next item is agenda item B3 is major mod application 20-0310. This is request is for a major modification to existing plan development. Steve Beachy will provide staff recommendation after presentation by the applicant.
All right.
While the applicant's coming up, I will note for the record that we received some clarification comments from the school board this morning regarding the review of the remand issues, because one of the remand issues having to do with the school capacity. That comment has been provided to you and the clerk for placement in the record.
Yes, I do have those revised comments. Good evening.
Good evening, Elise Batzel with Stearns Weaver Miller, 401 East Jackson. Before I begin my presentation, I just have a housekeeping matter. At the BOCC on December 12th, this matter was removed from the consent agenda by Commissioner Smith. The remand did occur without compliance with Board Rule 12 or Section 10.0304 of the Land Development Code. In fact, the board heard no testimony from staff, nor did it hear testimony from the applicant, nor did it give the applicant the opportunity to address any of the issues. All of these issues raised by the board were already examined and considered by you during the initial hearing. Opponents were afforded the opportunity to file oral argument at that time, and none of them did. Rather than hearing testimony, the ultimate motion was, and I quote, for a remand with the whole case open for review with no restrictions, and that we specifically contact all parties of record, ensure they understand how to navigate the system and the deadlines to come to speak with us, the BOCC, directly. The effect of that remand was to deprive the applicant of due process and the equal protections of the law. The county attorney will tell you that no such violation occurred, but under Florida law, if I don't put this on the record, then I have not preserved my client's rights to appeal. However, we are very practical and we understand that ultimately we would like to get this project approved. And so we are prepared to move forward tonight, but I wanted to put that on the record before we began.
Understood.
So before I do begin, I do have a packet of information for you.
Okay.
And Ms. Finch, this is Cameron Clark. Just to add to the comments that Ms. Batzel just made, we did review this issue. The Land Development Code does not impose any such requirement regarding remands. There's been no final disposition, obviously, of this application because the board has not taken any action on it at this time. I appreciate Ms. Batzel wanting to preserve this for the record, and as a letter, she stated that should the application eventually be denied, she wants to preserve this right, and that's all well and good, but you're able to hear this application tonight. Thank you.
Go ahead.
Thank you very much. If you could put thank you. This project is located west of Simmons Loop Road, which is approximately 700 feet southwest of St. Joseph's Hospital South. It is 147.63 acres. It is within the urban service area, and it is within the Riverview Community Planning Area. The current zoning is PD 061687, which was modified in 2019 by application 0317. As you can see from the slide, to the north, we have AR and RSC2, which is currently mobile homes, and ASC1, so various residential uses. To the east, AS1 and AR, again, various residential uses. To the south, PD 061147, which is a fully developed residential subdivision. And to the west, AR and PD, and we'll show a little better graphic later, there's also I-75 and mostly wetlands. The future land use of the subject parcel is SMU 6. The surrounding parcels include SMU 6 and further to the north, UMU 20 and CMU 12. This is where the hospital and the commercial activity center reside north of the property. So the existing entitlements are interesting. This is a PD from 2006. It was approved for 203 units, but it doesn't meet the requirements of the current comprehensive plan. It doesn't meet policy 1.2 and 1.3, which provide that projects within the urban service area should have a density of 4 dwelling units or greater unless there are environmentally sensitive areas. And the project should be of at least 75% of the allowable density. The current entitlements are also limited to single-family detached. And as you are aware, under 19.1, if you're greater than 20 acres, SMU 6 does require 2 different types of land uses. So the project overview and the modifications that we're proposing, yes, okay. We are adding 6 new points of external connectivity. We understand that the board is very concerned about connectivity, and we have lots of opportunity for additional connectivity. We're also modifying the internal layout and lot sizes. Much of this is due to change in the floodplain or floodway. Clark Lowmiller would correct me, I'm not sure which one it is. We've added community gathering spaces, which weren't in existence before. We've increased entitlements consistent with the policies for the minimum densities found in SMU 6, and consistent with your future land use plan, which is encouraging densities in these areas. We've also added a pocket of just over a 14-acre pocket that you'll see shaded out there on the plan. And there are a multitude of alternative uses that would be consistent with the 2-use policy of 19 in your future land use plan. So we are increasing the entitlements from SMU 6, under SMU 6, from 203 to 450. The comp plan does encourage density in this area. The internal layout, as you can see a little clearer here, was modified to take into account the environmentally sensitive areas to the west. The alternative land uses in our alternative land use pocket include a potential nursing home, an extended care facility, a potential charter school, which I'll go back and talk about a little bit more, a multifamily residential property, or townhomes. Again, 6 to 8 new points of connectivity, 6 at a minimum, but with certain uses, there may be up to 8. Staff and reviewed every single use, and we have different alternative connectivity points. For example, the charter school, as you can see, has slightly different connection points and connectivity than a nursing home or the extended care or the other types of residential entitlements. Connectivity, unfortunately, to the west and the south is limited by the floodway and I-75. From a compatibility standpoint, the site is located in the developing suburban area within the urban service area. The proposed rezoning allows development comparable to the approved uses, even if they're not all built, in the surrounding areas. The Planning Commission did provide in their staff report that it's consistent with the existing development pattern found within this area, and that the request would encourage development that complements the surrounding character of the area. I won't go through these because they are in your staff report and you've heard this before, but we're consistent with many, many provisions of the comprehensive plan. I wanted to talk just a little bit about a few things that the board suggested in their remand. The first, of course, was to reacquaint the zoning hearing master with the site, which we've done. Staff has done an amazing job at really giving you a very full transportation report addressing the remand. But most importantly, staff estimates that the trip reduction on existing roadways, which are a result of the completion of the flyover project and gate dancer extension, that gate dancer extension is what we have to provide and build as part of this project, would reduce various segments as listed on the slide, all the way up to 24.9% on 19th Avenue West, 19th Avenue Northeast, west of I-75. Is James Ratliff on the line? Would he be available to answer a question?
Yes, if you want to
I can wait for rebuttal if
How
you
about we handle
prefer.
it this way? We'll get through the whole presentation.
worries.
And then if you'd like to
Happy to do that.
cross-examine or something, you're
Sure.
more than welcome to do that.
With respect to the charter school option, there was a concern voiced at the board about transportation issues related to the charter school. We have always had in this rezoning condition 8, which requires that before the charter school option may move forward and be constructed, we have to come back through the special use review. So all of those things would be looked at by staff once again through the public hearing process at that time. I understand that you have some modified comments from the school board. I haven't seen those. I do have comments from 1113. At that point in time, Amber Dickerson with the Hillsborough County School Board mentioned that our rezoning reviews accurately outline the information that we're required to submit to the county for adequate school capacity per the interlocal agreement. Therefore, we are not planning on changing our review at this time. As you know, if there is inadequate capacity, under the interlocal agreement and under the Florida statutes, there is the opportunity to enter into a proportionate share mitigation development agreement under which development could proceed and we would pay our mitigation payment. In addition, those processes are typically provided for development in communities where there's reduced capacity. We can answer any more questions about that you have, and if there's additional information from the school board that I haven't been provided with.
No, the only thing I was provided today was exactly what you just read into the record. That's the
Okay.
only additional information that I have.
Thank you so much. In conclusion, planning staff and the planning commission have found this project consistent and compatible. The board transportation issues have been very well addressed by staff. The board school capacity issues have been responded to by the Hillsborough County School Board, and we would request once again your recommendation to the BOCC.
My only question to you, just
Yes.
for the record, is to ask if the project you're presenting tonight is identical to the project that was previously submitted and heard.
Yes, it's identical.
Thank you so much.
Thank you.
All right, we'll go to development services, please.
Good evening, Steve Beachy, Development Services. This application was remanded by the BOCC at the August 11 land use hearing for the purpose of allowing more discussion regarding the timing of density increases and infrastructure improvements in such a heavily congested area of the county. Concerns for lack of school capacity in the area were also raised. In addition, the board members indicated that the concerns raised by the public needed to be fully addressed and wanted to give the public an opportunity to provide oral argument, especially due to the limitations caused by the ongoing pandemic. In response to the concerns raised over transportation infrastructure, the transportation section has provided more detail in a revised report. However, the recommendation and proposed conditions remain unchanged. The school board has indicated the information provided in their initial review was accurate, and I am not aware of any additional information that the school board provided other than what has been presented by Ms. Betzel. In response to the remand request, the applicant has chosen to move forward with the same plan. Development Services has previously supported the plan as presented, and our testimony regarding compatibility of the proposed plan with the surrounding community is in the record. Development Services recommendation remains unchanged. And I will turn this over to James Ratliff if he wants to speak or if you want to address specific questions to him.
You leave Mr. Beachy, and I do want to talk to Mr. Ratliff as well. So if you could just hold tight for a moment. To address the commissioner's questions when this was pulled from the consent agenda, I just want to go through a couple of things to make sure we highlight that for the record. The first is the opportunity for the public to speak and the opportunity to file for oral argument. So can you or Mr. Clark or Mr. Grady tell us again for the record, what is that deadline for filing for oral argument?
The oral argument filing deadline.
Brian, this is
The oral argument filing deadline is close of business on December 21st, 2020.
So December 21st, close of business 2020 is when the deadline is for filing for oral argument, and that would be the opportunity to speak to the Board of County Commissioners. All right, Mr. Beachy, next, I wanted to go over the school piece of it. while I have you. And I understand, I've read the comments, the original comment that was filed by the school district, and I've also read the email that was submitted into the record tonight. The school board states, or the school district states, that it's school capacity and not school concurrency at this level of the review. Is that correct?
I'm not looking at the exact, at that email right now. I can pull it up, but if you're asking me if that's what they, yeah, can you repeat your question?
Question pertains to the actual agency comment that they filed from the original hearing. And it says, this is a review. I'm reading from their school district comment. This is a review for school capacity only and is not, and not is in capital letters, a determination of school concurrency. Is that typically what they file on any?
Yes.
I can respond to that, yes.
Thank you, Mr. Grady.
That's, again, that's the standard comment they provide, where they provide information on current capacity, and they're correct that during the next, if the zoning were approved and they go through and they're in for plating, then there's a concurrency review where they have to demonstrate at that point, through that concurrency review, there's the capacity through that review.
So
yes.
at the plating stage, if they don't pass school concurrency, what happens?
Then they don't.
Then the project doesn't proceed? All right,
Until they address concurrency.
Thank you very much. I appreciate it. And then, Mr. Beachy, let me just make sure. That was it. All right. Now, Mr. Ratliff, I'd like to turn to you for the transportation part of the directive for the remand.
Hello. Yes. I'd be happy to give a little overview of our of the revised portion of our staff report, or we can simply go into questions, whatever your pleasure is.
I have read your revised agency comments, which I found to be very thorough. So if you just want to give a summary of that, that would be appreciated.
Sure. So essentially, one thing we did was we just went kind of area by area and tried to address the BOCC concerns and the citizens' concerns that we heard at the hearing. And it may not be as clear in the report, but essentially there was no change to our recommendation. We are still recommending approval with conditions. Nothing else has changed from that standpoint, except the new information added was in that section titled Considerations for Remand. With regard to the Big Bend Road and interchange issues, we did put additional information regarding the projects, the status of those projects, and the timing of those capital improvement projects on appended to the staff report. Something that's not included, but just happened today, was at the BOCC meeting today. They did award the construction, I believe, for the I-75 flyover, or the Paseo Alamo Beach Boulevard Extension flyover bridge project that was awarded today. So that is marching forward. One of the things that we did address in there is that together with that project, one of the key findings and the reasons why DOT has chipped in more than $5 million towards that project is that project, together with the Gate Dancer extension through the case that we're talking about tonight, is a critical part to how we create the network that relieves traffic off of Big Bend. So tried to kind of provide that information and show that data for you. And also,
as a part of that point, could you address the letter that was provided by the hospital?
So certainly, yeah, the hospital did address concerns regarding, I believe it was kind of, tied to the amount of traffic on Big Bend. And so we thought it was important to point out that that traffic reduction on Big Bend won't be realized to the same extent if this north-south connection, the Gate Dancer extension, doesn't happen. There are other safety benefits as well from additional connectivity. So for example, anybody in Waterset right now that goes to the hospital, the ambulance has to currently route up to Big Bend Road and over to the hospital. Or they would have to drive, over to 41 to the west, and then either up to Big Bend or down to 19, then all the way up around 301. So this flyover bridge, together with the Gate Dancer extension, will provide a critical, kind of back door, if you will, to the hospital that will allow ambulances from those and other types of trips as well. But from that project from the Belmont project and other areas to get to the hospital without ever having to go on Big Bend. So we thought it was really important to highlight that the importance of that connection in providing access to the hospital and relieving.
Is it your testimony then that those projects in combination increase the public safety of not only the hospital, but also this project as well and those residents in the community?
Certainly. I mean, to the extent that you're providing a shorter path for ambulances to get to the hospital, absolutely, that provides a public safety benefit. Also, from the standpoint of being able to remove cars that would otherwise have to go on Big Bend Road, that certainly, provides a safety benefit to Big Bend Road as well.
This is the extent of my questions. If you have additional comments, feel free to do that.
I don't. They just last but not least was just pointing out that again, we put additional information on the record about the design exceptions and tried to provide some additional graphics to maybe provide some additional clarity about exactly what was being proposed and what was happening within the right of way. And if you have any other questions, just please feel free to reach out.
Thank you so much. I believe Ms. Batsa will have some additional questions for you shortly, so hold tight. All right, now we'll go to the Planning Commission, please.
Thank you. Melissa Leinhard, Planning Commission staff. The subject property is located in the suburban mixed use 6 future land use category. It is in the urban service area, and it is also located within the limits of the Riverview Community Plan and the South Shore Area-Wide Systems Plan. At their October 13th meeting, the Board of County Commissioners voted to remand this case back to this meeting tonight to allow for more input from the school board to evaluate if the amount of density being proposed affects school capacity. Additionally, this case was remanded to consider traffic impacts on Simmons Loop. Taking into consideration that the site is located in the urban service area, meets the overall vision of the Riverview Community Plan and the policy direction of the comprehensive plan, the overall request for residential units in this location would integrate well with the established development pattern. Based upon these considerations, and the Planning Commission's previous testimony, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services. Thank you.
All right, if I could just ask you, the commissioner that sent this case back for remand had a question about making sure that the density was proportionate in terms of time to the infrastructure. Are there comprehensive plan policies that address that timing issue?
Yes, ma'am. Thank you. There are very general policies in the beginning of the future land use element that address timing of.
Melissa, we're having some problems with your audio.
Is this better?
No, it's not coming through clear. It's coming through digitized. You may have to back out, come rejoin.
Okay. Madam Hearing Officer, it looks like I might have to leave the meeting and come back on. Can you come back to me?
All right, then we'll move to anyone who would like to speak in support. Is there anyone in the room that would like to speak in support of this application? Seeing no one, I don't believe we have anyone virtually. All right. Seeing none, then is there anyone in opposition to this application? Anyone in the room? All right, how many hands do we have? 2? Okay. And let me just ask, there's no one virtually, is that correct? All right. So 15 minutes. So if you both want to come up, it's 15 minutes total. If you want to divide the time up, don't feel free to take as much or as little as you'd like, but we are going to cap it at 15 minutes. You'd have to be on the microphone. You can't yell from the audience, but feel free to come up and give me your name. Okay, ma'am, if you could hold for just 1 minute, it appears the Planning Commission can participate again. Ms. Lienhard.
Thank you so much. Can everyone hear me now? Is it better?
Yes, ma'am.
Okay, thank you very much. So Melissa Leinhard, Planning Commission. As I was saying before, there are objectives and policies within the future land use element of the comprehensive plan that address the timing of growth. Specifically, it talks about managing the timing of new development to coordinate, infrastructure, transportation, transit services, other public services like school and recreational facilities and that sort of thing. And so the future land use element of the comprehensive plan does lay the groundwork for that. But it is really the various agencies countywide that implement the technical component of the timing of growth. So while we have these overarching issues, we rely on places like the school district to answer those questions and say whether they have capacity at this time or not. Same for transportation and all the other subjects.
In terms of your overall finding, you found this project compatible with the comprehensive plan and those policies. Is that correct?
Yes, ma'am. Yes.
Thank
I did
you so
not
much.
go
I
through
appreciate
all of my
All right,
previous
now we'll go back
testimony.
to those who would like to speak in opposition to this application. If you want to come forward. And while you are coming up, just so you know, we are going to start the clock when you begin at 15 minutes. For both total. Good evening. If you could give us your name and address, please.
Tom Auda, 6727 Simmons Loop.
Thank you so much.
And we were a little late getting to the meeting due to traffic, but missed the 5 minutes. So I'm, when you were explaining the rules, so hopefully I'm within the rules like we were in the other, the meeting where we actually spoke before. I don't know. So all of those same objections, obviously, we still feel very much so. But, I mean, I'm fine with, the planning of the additional roads and safety for the hospitals, this, that, and the other. But there is a lot of congestion that will be on Simmons Loop. And since we are in what they had proposed of, in the area that was the AS1, our the property values I know for my house, our house will not be enhanced when you've got an $800,000 3-acre lot with the house, and you start putting $300,000 homes and you've got a $500,000 differential. This is not going to positively impact us, and it's not going to positively impact the other homes on Simmons Ranch Court or in the AS1 that are on over an acre lot or thereabouts. Some are 2, some are less, that are also relatively custom homes as opposed to cookie cutter homes that are 4 to an acre. So I don't have the stats like they were said before to support that. That's just common sense. But by the same token, I haven't seen any stats presented by anybody else that would prove me wrong. So I would say that. Traffic and congestion also, I know that they're making plans and this, that, and the other, but it decreases the response times. I know what they're saying, and that's a safety, problem, not to mention that it would be the entrance is almost to this new development, whether it's 0310 or 0311, which is not maybe exactly what we're talking about, but they're all connected as far as we're concerned. And we would have the same statements in connection with 11 versus as 10 as well. But so, with the property values and the, the lot sizes and stuff, and as far as like what the lady in the previous major modification was saying before, consistency of planning. At some point, like 12 years ago, Big Bend wasn't a traffic problem. This was a very rural area, and the complexities and encroachments and this, that, and the other make it very, very different. So now it's considered urban where it was very rural before. And so is that consistent? Did that take into consideration what we were, as the AS1? I'm not a lawyer, so I don't know the different rules of what is urban, what is not, but most of it is farmland or a ranch, or was. And then there's high density housing. That may not be, in my opinion, very consistent with what we were as, before. And I'd ask that you not ignore the prior residents when you're going forward into making your decision as to whether or not this is to go forward or not. Then the others, like an environmental impact. And this is small scale versus large scale. So when you look at the small, sections that are being improved and going from a cattle ranch or a farm or nothing into high density housing, all this traffic, all of the road infrastructure and everything else, the sewer lines and everything that goes into that. Okay, maybe say on a small scale, there's not a lot of impact, but on the broad scale, if you take something over the last 100 years, look what's happened to New York City, Chicago, Tampa. If you go from 100 years ago to today, you say, wow, that's a big substantial difference. So, I mean, there is the impact. And so that's what I'm saying, just on a microcosm of where we are, it's kind of, there is an impact, and there's certainly going to be an impact to our lives. Now this, give me a little leeway, because this is trying to put in kind of what is legal. Certain things can be legal, but can be really a bad idea. It's just like the Titanic sailed with more than legal amount of lifeboats, and we all know how that turned out. So sometimes the experts get it wrong. So all I'm saying is, whether it's traffic, whether it's safety, whether it's impact on us, there can be a lot of things that the experts get wrong, even though they're well-intended. Thank you.
Thank you, sir. If you could sign in, please. Do you have documents you want to submit into the record? Did you have documents you wanted to submit? If you do. Oh, okay. All right. Good evening. Oh, absolutely.
Good evening. My name is Beverly Auda. I live at 6727 Simmons Loop, right across from this major modification, and on Simmons Loop and on the corner of Simmons Ranch Court. I want to discuss how this is not in harmony with what the old plat that we were told the modification was. We're fine with having a housing development across the street from us. We were told it was going to be 3/4 to a full acre lots. There was even talk about a golf course. This is not at all what they're talking about doing. The biggest problem that we have with this is the amount of people and the amount of traffic it's going to entail with all these people coming in. The roadway on Simmons Loop is not captured on a regulated roadway report. There is no service report. We have not been shown that. For some reason, they've decided not to include that in their presentation. The fact that Gate Dancer Road would continue, I understand that. That would be a plus. I'm not saying it wouldn't. And with the overpass, that would be fine. But the amount of people in the homes, the amount of people that they're wanting to put in a school, I don't have the report right here, how many people would be, like, I think it was, they're going, I don't have the exact number. The amount of people that would be going back and forth to school, students-wise. And then I forgot my book. I got to go back. The amount of traffic for teachers. It's just mind-boggling. They have 7,500 daily trips added in this area. Charter school would add 3,330 trips per day. But that, if it's a charter school, that's going to be tax exempt. So that gives you problems too. I did call and look at the schools. I have a friend that is in the school district there. The junior high is very full. The high school, I've got numbers on the high school, that's very full as well. There are just so many neighborhoods in Riverview that have started like 200,000, 150,000 to 200,000 on up, but it doesn't go to the quality homes. It doesn't go to the homes that maybe the doctors that work out of St. Joseph South would want to be, being able to do a custom home. And with this COVID, I've got friends that are in real estate. Talked to 2 realtors recently. They said the smaller homes are not going for sale as quickly because people want more space. They need a home office. These are things that are nice to have. Space outside so you're not right on top of each other. These are all things that we have to consider. COVID has really taken up so much of the time away from getting all of the individuals over here. I must admit, I really didn't want to come with the COVID numbers at the way they are here in Hillsborough. Biggest thing with the homes in our area is we wanted to have nicer homes and have more diversity in Riverview, because I can't tell you where that bigger neighborhood with more land and more homes with, more open space inside is. It's just not captured. The amount of noise from just what we have right now is incredible. If you add a nursing home down the street, they'll have ambulances going from the nursing home to the hospital. Speaking of that, we have 2 firefighters that live right next door on either side of us. There's so many traffic accidents out there right now. I've got to call into the fire department and they haven't gotten back in touch with me. But there is so many information about the number of runs for the ambulance, and also fire trucks have to go as well, just in case people are stuck in their cars. But between traffic accidents, trying to get people to the hospital, it's just incredible. I do have video of traffic, different times of the day. I also have a call into one of the deputies. He's been getting calls from neighbors that want to have speeding, slowed down on Simmons Loop. He's out there just about every morning when I go take my dog outside for a walk. And he's, it's motorcycle cops right next door. And so firefighter goes and gives him a cup of coffee when he's like, yeah, I got quite a few. He had like 2 or 3 pulled over just last week. So it's just, we bought it as a rural setting because there's farmland, and it was just a really nice place to build, a nest. We have, 4,000 square feet in a house, 3,000 in a RV garage and office. And, this is not what we wanted to spend our money on if, we're going to have gridlock. And I really think that, I think it was Stacy White, he said that we need to really work on making sure that everything is thought through, and that the timing of these bridges and the other roads that are going to be completed and the passovers and everything is going to be taken care of before this neighborhood goes in over there, and also the school, and also maybe a retirement home, because this is not in harmony or compatibility. Everything is so different. We have septic tank. Everybody else has sewers. It just isn't, it just isn't incompatible with what we thought we were moving into. And I really hope the board considers this. And I know that the Simmons family, they all have property down on, within, I would say, a half mile of me, whether it be on Simmons Ranch Court or one of the other roads. So the Simmons family is very disappointed in how all this is going on, but they didn't want to be here. I think a lot of it has to do with COVID, the neighbors and that sort of thing. So thank you for your time.
Thank you. If you could please sign in. And while you're signing in, I just want to make sure that we reiterate the oral argument deadline. You have to file for oral argument by Mr. Grady. Again, I apologize. December
21st.
December 21st. There's a form. Do we have that form here available?
Yep.
Hey, hang on a minute, we can't talk.
We can get their contact information.
Okay, so we now have your contact information and the county can supply you with the oral argument form, but it must be filed on time for you to have the opportunity to speak to the Board of County Commissioners.
By the way, we were never given any sort of letter or phone call or anything about this meeting tonight.
All right, thank you so much for your testimony. All right, then with that, sir.
Actually, one more. This is Tom Auda again, and I'm sorry. We can go through all this again because I know that 0311 is going to be, next. Do you want us to say the same thing again or just go on?
Yes, they are two independent hearings, and so we're going to go all through this again. So
good enough.
Might get comfortable there. All right, so with that, then we'll close opposition testimony because I don't see anyone else in the remaining minute of time. All right, then we'll go back to county staff. Do you have anything you'd like to add?
Nothing further.
All right, then it is the applicant's time for rebuttal. If you would like to speak with Mr. Ratliff, he's available if you would like. Good evening.
Good evening, Steve Henry, Links and Associates, 5023 West Laurel, Tampa 33607. Just want to address a couple things on the traffic that was mentioned here. And I think Mr. Ratliff's report speaks to it in volumes as to the impact of this road, what this road is going to do to the adjacent roadways, also what it's going to do for the hospital, for the circulation for the area. So I understand their concern with the increase in.
All right.
Sorry. Anyway, what I was saying was that, what Mr. Ratliff has said as far as the transportation system in the area, that the roads that are going to be built with this project will help the overall transportation system, help the access for the hospital, help Big Bend Road. So it actually is a benefit. I understand the concern of the residents here, but the reality is in the global thing, from a traffic standpoint, this project will help as indicated in the staff report. Thank you.
Thank you. Appreciate it. You please sign in.
Just want to address a couple of, I'm sorry, Elise Batzel, Stearns Weaver Miller again. I just wanted to address a couple of points that the Audas mentioned. First, they were concerned about the development reducing their property value. There are many studies that show that when development comes in, property values increase. We outlined a memorandum of law about lay testimony and lay speculation about potential problems such as unfavorable impacts, traffic issues, and property values, and that doesn't substantiate competent substantial evidence that's in your record. So I would just reiterate those comments. The Audas were also concerned that the development will create negative environmental impacts. Again, this is speculation, and it's really offered without facts or evidence. The applicant actually worked with EPC to modify the site plan to further reduce the impacts to the floodway and floodplain to provide more protection from these areas than was provided in the original rezoning. A copy of the EPC comments reflecting this are part of your rezoning record, again, constituting substantial competent evidence tonight. EPC states in their comments that resubmittal is not necessary at this rezoning stage. Obviously, if the plan changes at any point in time and there are going to be greater impacts, then we'd have to go back through the approval. I wanted to just correct for the record one thing about school concurrency. It's at the time of preliminary plat that we determine school concurrency. So when you ask the question about capacity versus concurrency, capacity can change. If we don't build for a year or we don't build for 2 years, school capacity change every year on the 40-day count. So that means that this is just a snapshot in time of this is what your capacity is as of today. And whether we move forward with the project will depend on what the capacity is at the time that we submit preliminary plat. At that point in time, we would have the option, at least if the county and the school board continue to operate as they do today, to enter into a proportional share mitigation agreement. And at that time, it becomes our responsibility to contractually obligate ourselves to pay a certain amount. It's somewhere between $25,000 and $30,000 per seat. That's promulgated by the Florida Department of Education. And we have to enter into an agreement to actually pay that amount prior to beginning construction. So I just wanted to clarify that for the record.
Thank you.
With respect to lot sizes, would it be okay if I spoke to Melissa Leinhart just a moment and ask her a couple of issues?
Yes,
questions?
Under cross-examination, it's certainly your right to do that.
Thank you. Melissa?
Yes, ma'am.
There was a contention made that the lot sizes were not compatible. And I know I have heard some comprehensive plan policy that talks about to be compatible, it doesn't necessarily mean the same. Could you tell us what that policy says for the record, if you happen to remember it?
Yes, let me bring up the report just now. So the future land use element policy 1.4 is the one that talks about compatibility is defined as the characteristics of different uses or activities or design which allow them to be located near or adjacent to each other in harmony. Some elements affecting compatibility include the following: height, scale, mass, and bulk of structures, pedestrian or vehicular traffic, circulation, access, and parking impacts, landscaping, lighting, noise, odor, and architecture. Compatibility does not mean the same as, rather it refers to the sensitivity of development proposals and maintaining the character of existing development. And we did list that policy in our staff report, and it should be part of the record.
And that was the basis for your finding of consistency? One of the basis for your finding of consistency?
Yes, it sure was.
Thank you very much.
Thank you.
Just with respect to a couple of the other issues regarding accidents on the road and speeding, I mean, obviously there are laws in place for speeding, and it wouldn't be appropriate at the rezoning level to sort of address speeding issues. However, when you have an improved transportation network, logic would bring the fact that you have many alternative transportation ways to transport, and hopefully our law enforcement can be called out if there are speeding problems in this area. And I think Mr. Ratliff actually covered very well. Your questions actually covered what I was going to ask, so I don't have any further questions at this time.
Okay.
Do you have questions of us or any of our consultants at this time, Madam Hearing Officer?
I've asked the questions I had.
Thank you very much.
Thank you for your testimony. I appreciate it. Then with that, we'll close major modification 20-0310 and go to the next case.
The next item is agenda item B4, major mod application 20-0311. This is a major modification to existing plan development. Steve Beachy will provide staff recommendation after presentation by the applicant.
You're up again.
Thank you. Elise Batzel, Stearns Weaver Miller, 401 East Jackson. This is major modification 20-0311. The property is 70.3 acres southwest of Simmons Loop Road, 1 mile southwest of St. Joseph's Hospital South. This is just directly to the south of the project that you just reviewed. It is located in the urban service area and is part of the Riverview Community Planning Area as well. The current zoning is 06-1147. It also had a PRS in 2019, 0314. As you can see from the graphic, there's a pretty significant development to the south, which is existing. That's PD 04-0558. To the east is an existing approved PD, which is also suburban scale, single family development. To the north is 061687, which is the original zoning for the project that was just heard, which does provide over 300 suburban single-family lots. To the west, as we indicated in the last hearing, is the floodway, Little Bullfrog Creek. The subject parcel is SMU 6, and as you can see, SMU 6 is all the way around it on all four sides. The existing entitlements here are 216 units. Again, it does not meet all the policies of the comprehensive plan 1.2 or 1.3, which urges a density of 4 dwelling units or greater and urges densities of at least 75% of the allowable density. Again, this project is also limited to single family detached dwelling units, so it does not currently meet 19.1, which requires a mix of uses for PDs greater than 20 acres. With respect to this project, the request is to modify the lot layouts, modify lot sizes, increase permitted units to 315 single-family detached. This is consistent with the SMU 6 policies. You can also see here in blue, this modifies the internal road network, again, to accommodate changes in the floodplain. We've also added as a second use here, you'll see a 7-acre park. This is going to be open to the public as a second use within the community. We have agreed to provide directional signages and other community park amenities. With respect to the connectivity to the east in red, this actually aligns with a point of connectivity along the eastern property boundary to an adjacent PD. So we've aligned that so that from a grid network, it's more consistent. We are asking for no variations. Again, we've spoken about Gate Dancer Road, but for purposes of this hearing, Gate Dancer Road will be extended from the northern boundary of the property to the southern boundary of the property. The connectivity to the east will tie into Gate Dancer Road. There is limited connectivity to the west and to the south. To the west, I-75 and Little Bullfrog Creek are directly adjacent to the west. And to the south, we have this fully developed suburban single-family residential development, which impede connectivity in those directions. The site is located within a suburban area in the urban service area. All of those areas in blue are either existing or approved suburban single-family dwelling unit entitlements. The proposed rezoning would allow development comparable to the approved uses and the existing uses in this area. The PD to the east is actually approved for single-family, multifamily, and commercial entitlements that could be developed with up to 628 units. Planning Commission has found this compatible with the existing development pattern found within the surrounding areas. Again, I won't go over all of these comprehensive plan policies because they're in the staff report. But we do, the Planning Commission staff report does go through them very thoroughly. The board remand on this was a little more specific to transportation and school concurrency issues or school capacity issues. Again, the revised transportation analysis provides a very good explanation of the improvements, not only in the general area, but the improvement that will occur with the extension of Gate Dancer Road. Staff estimates certain trip reductions on different segments in the surrounding area based on these proposed projects, which include our extension of Gate Dancer. Anywhere from 5.7% reduction in trips on Big Bend between I-75 and US 301, up to as much as 24.9% reduction on that section of 19th Avenue Northeast, which is west of 75. With respect to school capacity, the correspondence from Amber Dickerson to Steve Beachy that you do have in the record dated yesterday states that our rezoning reviews accurately outline the information that we are required to submit to the county for adequate school capacity pursuant to the interlocal agreement. Therefore, we are not planning on changing our review at this time. As I mentioned during the last hearing, this is school capacity, this is not school concurrency. And so it's a snapshot in time that occurs at the time that we submit our rezoning, but no one's going to know what the school capacity issues are at the time we actually go in for preliminary plat. That could be a year, it could be 2 years, it could be further down the line. At that point in time, the school board will look at the project and determine what the capacity is at that time. And should the school board, the developer, and the county decide to pursue an agreement, we would, underneath the Florida statutes and the interlocal agreement, potentially have the ability to enter into a proportionate share mitigation development agreement at that time. At that time, we would have to pay the school seat cost, which is a cost that's promulgated by the state of Florida, where if there isn't sufficient capacity under a prop share, the developer has to actually pay to the school board the cost to construct a whole person's worth of infrastructure for that student. Planning Commission staff and planning staff have found this project consistent with a comprehensive plan, compatible with the existing and proposed suburban developments in the area. Given the comprehensive plan policies of the SMU 6 category, the proposal is actually more consistent than the comprehensive plan than what is existing today. And again, we would recommend your approval to the BOCC. We're here to answer any questions, and we will see you again on rebuttal.
I just have one question.
Yes, ma'am.
To verify for the record that this project is identical to what was originally submitted. You haven't changed the proposal in any way?
No, ma'am.
All right, thank you so much. I appreciate it. Development Services, please.
Steve Beachy, Development Services. This application was remanded by the BOCC at the October 13, 2020 land use hearing for essentially the same reasons: the timing of the density and infrastructure, school capacity issues, and the board mentioned that it was similar reasons for both cases to be remanded. Transportation section and the school board have, as we have noted, have not essentially changed their comments. In response to the remand request, the applicant has chosen to move forward with the same plan, and Development Services has previously supported the plan as presented, and our testimony regarding compatibility of the proposed plan with the surrounding community is in the record. Development Services recommendation remains unchanged. That concludes my
I
comments.
neglected to say this in the last hearing, but in the staff report, there's just a date error in the first sentence of the project narrative. It says
yes,
that the application was remanded by the BOCC. In your staff report, that both reports say August 11th, and you just testified that it is August 13th. It's a
correct
minor point. I just wanted to point it out for the record. And to just verify the school district's comments that Ms. Batzel alluded to, that you received, that they do not want to change their comments based on the remand. Is that correct?
That's correct. They sent the same email for both applications.
Okay. And if we could now just address their comment about oral argument, if just to verify for the record, what is the deadline, Mr. Grady, for if someone wanted to speak to the Board of County Commissioners?
The oral argument deadline is December 21st, 2020.
December 21st, 2020. All right, thank you so much. Now we'll go to the Planning Commission.
Thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located in the suburban mixed-use 6 future land use category. It is in the urban service area, and the subject property is located within the limits of the Riverview Community Plan and the South Shore Area-Wide Systems Plan. At their October 13th, 2020 meeting, the Hillsborough County Board of County Commissioners voted to remand this case back to the November 16th zoning hearing master meeting to allow for more input from the school board to evaluate if the amount of density being proposed affects school capacity. Additionally, this case was remanded to consider the traffic impacts on Simmons Loop Road. Taking into consideration our previous testimony and that the site is located within the urban service area, meets the overall vision of the Riverview Community Plan and policy direction within the comprehensive plan, the overall request for residential units in this location would integrate well with the established development pattern. Based upon those considerations and Planning Commission's previous testimony, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services.
All right, thank you so much. If we could, before we go to testimony in support and opposition, Mr. Ratliff, I neglected to call on you during the Development Services Department staff presentation. So if you could testify regarding your additional comments that were based on the direction from the board and the remand, I'd appreciate it.
Certainly. A little bit like Groundhog Day, right? For the record, James Ratliff, Transportation Review Section within Development Services. The staff report is largely unchanged. The only thing that was added to the staff report was the section called Considerations for Remand. Within that, we outlined issues that we heard raised by citizens and the Board of County Commissioners. I think it's important just to note, as Steve, I think, mentioned, that our findings did not change. We're still recommending approval subject to the conditions in the report. There were several areas that we did look at. First and foremost, I would say concerns regarding hospital-related traffic and hospital access. There was a letter from an opposition from I believe it was the president of the St. Joseph's Hospital, who expressed concerns regarding traffic on Big Bend and at the interchange. And so what we did was provide a variety of information that I think it's really important to look at, not just in terms of the trips that this project is adding from development of this project, but also the infrastructure they're building, the amount of trips that will be relieved from Big Bend Road. And that data comes from the grant application that we put together for the I-75 flyover bridge of the Apollo Beach Boulevard, Paseo Almar Boulevard extension. And just for the record, again, that project was actually awarded by the BOCC at today's meeting, so that will be marching forward. But as a part of that SIGP application, which is the Florida Department of Transportation's County Incentive Grant Program, and essentially what they do is they award grants to counties who for projects that have positive benefits on the strategic intermodal system. Big Bend Road west of I-75 is a SIS connector roadway. And so FDOT decided to chip in over $5 million towards that project because we were able to demonstrate that the Apollo Beach Flyover Bridge, together with the Gate Dancer extension, which goes through the project, which is the subject of tonight's hearing, helps to relieve additional trips and a significant amount of trips by 2040 from Big Bend Road. It also provides other benefits towards the safety of access regarding the hospital. So today, if somebody in Waterset or Apollo Beach proper, if you will, kind of west of 41, needs to go to the hospital, the ambulance would have to go either up Waterset Boulevard or up 41 and get on Big Bend to go over to the hospital. Without this road and this project, that would stay the same. So what the road that's the developer is going to be building as a part of this project, and I do want to point out, just a quick aside, the existing condition that requires them to build that road and have that road in place before any residential is built, I believe is still is carrying forward and is remaining as a condition of approval. So that road will have to be in place prior to to the associated impacts from their residential development. But essentially, what that road connection does is allow ambulances and employees and people visiting the hospital another way of getting to the hospital without having to go on Big Bend Road. So there's a lot of different benefits that are that can be realized from the roadway that the developer would build with this project. There are a couple of other things that we did look at regarding just the safety considerations and the design exceptions that were approved, and provided some additional graphics to hopefully demonstrate the constraints a little bit better and exactly what improvements are being proposed. Lastly, I did just want to mention that, and I'm sure we'll hear again from citizens, we heard at the last hearing, there was a discussion of speed issues on Simmons Loop. I will tell you that speeding along collector roadways is a factor. Well, there's a number of factors that can go into speeding, but a large one is that when roadways are not utilized to their, or when they're underutilized, essentially it's easy for roads to speed. So it may seem counterintuitive, but adding traffic to the road will actually decrease the opportunities for speeding and can make roads safer. So, and when looking at it from that specific issue. So with that, happy to answer any additional questions you have. That concludes.
Thank you. I just want to, based on your comment about the road improvement being in place prior to the residential development, could you help me and point me to that zoning condition?
Certainly. Let me, and I'm hoping I can put my finger on it quickly. It may not be in my staff report because it was
And
not.
I'm not looking at your staff report, I'm looking at the Development Services staff report
Okay,
and the recommended conditions at the end.
let me get that pulled up.
As well.
And I'm not sure the applicant might be able to answer that more quickly than I can, but sorry, it takes a minute to download things from the remote.
Addresses construction of the roadway.
And Madam Hearing Officer, I'll look for that, and if you want to circle back to me, we can do it that way as well. Or again, it's still downloading, so I apologize. It's going to take just a.
Mr. Grady, when you do pull it up, it's condition 15 and there's a 15.1 as well. Then that completes that. We went through the Planning Commission, so we'll call for anyone that would like to speak in support. Anyone in favor in the room would like to speak in support of the project? We don't have anyone virtually. Thank you. All right, we'll call for anyone that would like to speak in opposition. I believe we also don't have anyone in virtually. So yes, if you would like to come forward. Start by giving us your name and address. You have a total of 15 minutes. Good evening. Again.
Good evening again. Tom Auda, 6727 Simmons Loop. And yep, little like Groundhog Day, like the one individual said. But to address exactly what he was saying, it's like, and I agree about the lack of speeding can happen, but lack of speeding doesn't really happen in a traffic jam or in gridlock. You're still going slow because it's gridlock. Basically, the same thing that I said with the 0310, I will say for this because the two are, connected. And with the other, aspect of the developments and the infrastructure plan, and I do believe that the infrastructure plan is great, especially the flyover going to the hospital and gate dancer going to the hospital, saving lives is wonderful, and I agree. However, there's thousands upon thousands upon thousands of additional people, not just with this modification or other developments that are going to be going east of 301 and also going to have to be traveling in and through this area. So just kind of put that into consideration as well. So I guess for the record, just for, since you said they're all the different, I'll do more bullet points, I guess, more than anything else to save time. And that is for the traffic, congestion and safety. And I still think that when the construction continues, whether it's east of 301 and this, that, and the other, we're still going to have gridlock. Property values, again, I'm going to say, and I would maybe agree with Ms. Bassel, no one's going to buy a house in the middle of nowhere. But when you have other development, and certainly we have development around the Riverview area now, but if you're not putting in consistent with those houses, I cannot see how that's going to improve the value. And if she's got any statistics that would prove me wrong or prove her point of, I would love to see them. Again, urban versus rural. We were there first, not that, apparently we'd like for the developer, or not the developers, but the BOCC to take that into consideration. And again, the legal ideas and the environmental impact. Yeah, okay, you got to look at the broad scheme of things and over the last 100 years. But basically everything I said, plus whatever new nuances of anything in this with 0310 are the same objections.
Thank you so much. If you could please sign in.
Ms. Finch?
Yes, ma'am.
This is Cameron Clark. May I speak for a second?
Go ahead, Mr. Clark.
Yeah, I just want to note for the record, since 310 and 311 are different applications, Mr. Auda should make sure that if there's anything in the record that he stated for 310 that he wants to be in 311, I think it would be best if he expressly stated it rather than just referring to it, because these applications will be voted on up or down separately. So I would recommend if there's something else he wants to say, then he should add it now. Otherwise, he can, of course, stop if he wishes to.
Saying, just to verify, because they are separate, that if you wanted to say anything particular to this case and not reference the other case, just to make sure that the record is clean.
Okay, I was trying to save time and everybody's
Yes,
patience.
I appreciate it. If you could just give us your name just for the record.
Tom Auda, 6727 Simmons Loop. Good Lord. Okay. Traffic. The infrastructure we feel, even though may be necessary for the current infrastructure to relieve, will still not take into consideration this development and any other developments that are going to completely gridlock this current area because it's already in a lot of ways overdeveloped. Property values. Our house is not consistent with what is being proposed, and our house has been there since '06. And the Simmons Ranch development, which is considered as their plat AS1, has larger lots and more custom homes that will have negative impact with property values with what is being proposed with the smaller lot, 4 to an acre, and more cookie cutter houses that are not of consistent quality with what we're living in now. Urban versus rural. Things have changed over the last several years. We were very, very rural, and Big Bend was not even an issue 10, 12 years ago. With the traffic it is today, yes, some things are needed. We're not going to reverse the development that's already, gone on. But by the same token, we ask that you take into consideration the fact that we were here, this was developed, and this is a major modification to a development that was approved that we were aware of when we moved into, but not the major modification. This changes things. Again, things may be legal, but they can still be a very bad idea. I gave the example of the Titanic that was sailing with more than the legal number of lifeboats to be safe. And we all know how, no, they sailed with more than the legal number, but not enough for all the passengers. So we know how that turned out. Environmental impact, getting all this. In the large scheme of things, I know that they have talked about how they've tried to improve and this, that, and the other, but the environmental impact that's going to happen as far as noise, light noise and sound is going to destroy our peaceful little section in Riverview. So, and like I said, the lack of speeding can be considered gridlock as well. So I think that wraps it up.
Thank you for that clarification. I appreciate it. Yes, ma'am.
Beverly Auda, 6727 Simmons Loop. I guess my biggest question is why the hurry? Traffic is terrible. It is one of the worst areas in all of Hillsborough. I believe that was stated by one of the commissioners, that it is almost like Big Bend and 301. That whole area is like the #1 traffic problem. Getting on to 75 North is a nightmare. Big Bend and Simmons Loop, turning left. Most of the time you sit through 3 lights, and I'm not exaggerating. I've got it on video. different times of the day. The thing that we should do is get the traffic pattern established even with Simmons Loop. It would be a terrible traffic problem to have a school or a retirement home, another in addition neighborhood with lots more homes. If they would wait until the flyover to Apollo Beach is complete, the Big Bend widening to 6 lanes is complete, the new entrance to 75 North, plus 2 turn lanes off of Simmons Loop onto Big Bend Road. These are the things that really need to be complete before they really consider both this school project and the housing addition from this and the meeting that we had just a minute ago for the other planning for the more density in the neighborhood right across the street from us. Again, we need diversity for these doctors and nurses and staff that work there. Having a little bit more space is not a bad thing. If the CEO of St. Joseph's, contacts you and says, whoa, this is a potential safety issue on August 13th, you better think hard and strong about that. That's a big deal. It was to us. We're like, yeah. I tried to contact the school board. I'm brand new. I'm a year here. I found a phone number. I call it. It's been disconnected. The next phone number, 813-272-4128, says it's been forwarded to this number and there's no voicemail available. So I've been trying to call those 2 numbers with no avail. So I didn't really get all the answers to my school questions, but I do know that East Bay School, high school, is 21 to student to teacher ratio. And people are moving to Florida every day. There's a huge amount of people that are moving. And, I don't know what their Hillsborough community plan was updated in 2019, but I sure would like to know, since we moved in 2019 in October. But this was not what the plan was, as far as we know. The ambulance response time, I am going to be getting something back from the captain of the fire department. First responder safety report type of thing, and comments from paramedics that live near it. We're a very friendly area, and they've commented that this is just really a hard place to live. It's gridlock. So I just want to say you really need to reconsider doing this in such a hurry. We really need to make sure this traffic is under control and that you consider the neighbors that have been there. A lot of them have been there for years, and people that have just put in probably the most money into the neighborhood, we just found out. So within a month of moving in. So thank you.
Thank you for your testimony. I appreciate it. All right, seeing no one else in opposition, we'll close that portion of the testimony. Mr. Ratliff, Mr. Grady, do we have an answer on that transportation timing condition?
Yes, hello. For the record, James Ratliff, Transportation Review Section. I was actually thinking of the zoning application for 2310. So within 2310, there was a condition that states, and it was slightly tweaked, but it was the same, and it states, no building permit shall be issued until the construction of this segment of the new north-south road has been completed. Now, I looked, and there does not appear to be a corresponding condition that was ever existing within this application 20-311. So I'll, let the applicant, do whatever they want to do with that, if anything. So, but at the end of the day, I was apologizing. I was misremembering. It's actually the other application that had that restriction, not this particular application.
And while I have you, if you could just respond to Mrs. Auda's reference to the letter that was written by the president of the hospital asking for a delay pending the improvements. If you could just address that issue and her assertion that it's a public safety issue.
Well, from our staff report, what we tried to do was look at it holistically. So certainly this project is putting additional trips on the road. However, they're also facilitating infrastructure improvements, constructing infrastructure improvements that are a part of reducing a significant number of trips from Big Bend Road itself. There will be additional traffic placed on Simmons Loop, and in my staff report, I talk about how that's always been anticipated. It's on the corridor preservation plan as a important future roadway. And within the hospital zoning, we had actually built in a condition that states that their primary access to the hospital has to be signalized when such a signal is warranted. So there are provisions within the hospital project zoning that provide for safe and efficient access to the hospital, both today but continuing into the future.
In terms of the public safety portion of her testimony, and as well as the letter in opposition from the hospital, is it again your testimony that these improvements in combination will increase the safety of that area, not only the hospital but the surrounding residents? Is that correct?
That is correct.
Thank you so much. All right, then we'll back to Mr. Grady. Did you have anything else you wanted to add?
Nothing further.
All right, then we'll go to Ms. Batzel, who has 5 minutes for rebuttal.
Thank you. Elise Batzel, Stearns Weaver Miller on the record. Just a couple brief points. We are looking for that condition because it was our understanding that that condition was consistent. Give us just a moment if you would.
I would. And if it turns out that Mr. Ratliff's testimony is that they're different, if it turns out, would you be amenable to adding that timing restriction? If you thought it was the same, you would be amenable to adding that to this zoning such that no residential development can be built until you've completed that improvement?
I'll finish rebuttal and then I'll talk to my client if you don't mind.
I appreciate it.
Absolutely. Mrs. Alda mentioned school traffic. She was concerned about school traffic coming out of this development. The school is not proposed for this development. It's proposed for the last hearing, 20-0310. With respect to rural development, I heard Mr. Alda speak a lot about the rural nature of this area. This area is within the urban service area. Your Planning Commission staff and your Development Services staff has each characterized this area as suburban, not rural. I do understand that they moved in 2019, and it has been changing over the course of the last 10 years, but it is suburban today. The Planning Commission also says in their staff report that this project is compatible with the existing residential densities of the area and serves as an appropriate example of infill development. This is exactly what the comprehensive plan contemplates within the urban service area. One of the things that Mrs. Alda said that I wanted James to clarify was, and James, if you happen to be available.
Yes.
I just wanted you to clarify on the record that your staff report contemplates and accounts for the trips generated from this project as well as what's existing on the right-of-way or the surrounding roadways, correct?
Correct. The recommendation did take into account existing background trips plus project traffic.
Thank you very much. Again, as outlined in our memorandum of law, lay speculation about the potential problems. That includes unfavorable impacts, potential traffic issues, property values, and even sound. Those things have been found by Florida courts not to constitute substantial competent evidence. Again, for the record, we did work with EPC to modify this site plan. This site plan particularly had a very large change in the floodplain. And so we did work and resubmit our plan from the initial plan that was submitted as part of this rezoning to what you see today to account for those changes. And EPC initially was concerned about the placement of lots. We actually satisfied EPC with this revised site plan to take into account the environmentally sensitive areas. If you'll give us just a moment to talk about the condition, I'll be right back with you. Also, may I submit materials to the record? I neglected to do that
Yeah,
earlier.
sure. Absolutely.
So we can offer a new condition. It mirrors with some slight changes, the condition that we had in 20-0310. And it would read as follows. Consistent with the Hillsborough County Corridor Preservation Plan, comma, the developer shall construct a new north-south road, i.e. the extension of Gate Dancer Road, close parentheses, as a two-lane undivided collector roadway, as shown on the site development plan, period. Improvements shall extend from Belmont to the northern property boundary of Simmons Village South. So this would take those improvements from the northern boundary of the property line to the southern boundary of the property line through the property. And we can talk with Brian to come up with, to review this language.
But was there I'm just asking because even though it's at the former hearing for 310, was there a timing mechanism on that relative to
It was
construction?
worded differently. So rather than try to rewrite something, we just thought this was clearer.
But the intent of the prior condition was to add a timing mechanism such that that improvement was in place before.
Yeah.
That's correct.
And let me
Mr.
add.
Luce, if you could give us your name, please.
Yeah, Steve Luce with Eisenhower Property Group, and add to that same condition that no building permit shall be issued.
Thank you.
Until the construction of this new segment is completed.
Right, and so you're amenable to adding
Right.
that provision. Thank you. I appreciate that. All right, so Mr. Grady, then that will be worked out now that the applicant has committed to that on the record as a part of this.
If they've agreed to basically adding that same time mechanism, I think we can work on the wording of describing the extended improvements, because I'm not sure why they changed the wording of how where the area had to be improved. That's in the existing conditions. So
Right. But
I think the main thing is to get the timing mechanism included into that so we can address that.
We're committing to that timing mechanism.
Thank you for that. I appreciate it.
Thank you.
Does that complete your rebuttal testimony?
It does. We're available to answer any questions.
I don't have anything additional, but I appreciate it. All right, so with that, we'll close major modification 20-0311. And we're going to take a 5-minute break. At this point, Mr. Hearing Officer Scarola will take off the hearing, but we're going to do a 5-minute break and then come back. Thank you.
Okay, I'd like to bring our hearing back to order. Brian, I think we're ready for our next petition. Okay. All right, we're going to bring our hearing back to order. And Mr. Grady, can we have our next petition?
The next item on the agenda is C1. It's rezoning standard 20-1078. The applicant is Jerome Perano. The request is rezoned from AS1 to Business Professional Office. License Brown will provide staff recommendation after presentation by the applicant.
Okay, and the applicant, please. This is 20-1078. Yes, sir. Come on up. Name and address, please.
Jerome Perano, 2701 North Essex Court, 33602.
Yes, sir. Go right ahead.
Yeah, I didn't have anything really formal to present, just that that particular street, 82nd Street, there's only, I think, one home left, AS1, besides mine. There's several commercial properties, and that's why we submitted the application as such.
Okay. Thank you, sir.
Thank you.
All right. Development services.
Good evening, Isis Brown, Development Services. The request is for a 0.95 acre parcel rezoning from agricultural single family AS1 to proposed business professional office. There are no variances or variations to the code. The proposed site is consistent with its use. The surrounding areas are the surrounding areas is urban mixed use, light industrial, low density urban residential, and the property, the subject property is has a future land use of commercial mixed use. Based on the conditions listed, the staff recommends approval of the request from AS1 to BPO.
All right, thank you for that. Appreciate it. And the Planning Commission, please.
Thank you. Melissa Lionheart, Planning Commission staff. The subject property is located in the Community Mixed Use 12 Future Land Use category. It is in the urban service area and also within the limits of the Greater Palm River Community Plan. The proposed rezoning to Business Professional Office would allow for uses that are compatible with the surrounding development pattern. Office uses are permitted within the CMU 12 Future Land Use category. This category is intended for urban intensity and density of uses, with development occurring as the provision and timing of transportation, public facilities that are necessary to support these intensities and densities are made available. Currently, PD 14-0608 is located to the north and northwest of the subject site and is currently approved for manufacturing and commercial intensive uses. A large lot with manufacturing zoning is located immediately to the east of the site as well. Across South 82nd Street to the west are two planned developments. The first one, PD 040694, allows for BPO uses, office, showroom, research, development uses, warehouse uses, a contractor's office, and indoor repair services. The other PD is PD 15-1141, and that is approved for commercial retail uses with cultural and institutional uses as well. Currently, the uses that are allowed in the surrounding area are BPO uses and also uses that are more intensive. The proposed zoning on the subject property would be consistent and compatible with the surrounding area while serving as a buffer to the single family lot immediately south of the subject site. The proposed zoning fulfills the intent of Objective 16 and policies 16.1, 16.2, and 16.3 of the future land use element, which include policy direction on compatibility. The proposal is also consistent with the Greater Palm River Community Plan. This plan encourages and supports new infill and redevelopment that's compatible with existing community development patterns, that also maintains and enhances the community's unique character and sense of place. The proposed BPO zoning promotes office infill development, complements nearby uses, and contributes to maintaining and enhancing the Greater Palm River Community Plan. Based upon those considerations, Planning Commission staff finds the proposed rezoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Right, then, thank you for that. Anybody here tonight in support of the request? Seeing none, is there any opposition to the request? Nope. Anything else from the applicant, sir?
I have one letter. Jerome Perano, 33602, 2701 North Essex. I have one letter in favor. I'll leave it here.
Submit that in the record. Yes, sir.
All right, thank you.
Anything else, sir?
That's it.
All right. With that, we'll close rezoning 20-1078. Brian?
The next item is agenda item C2, rezoning standard 20-1170. The applicant is Jonathan Weisman. The request is to rezone from agricultural single-family conventional 1 to RC9 with restrictions. Chris Grandin-Leonard will provide staff recommendation after presentation by the applicant.
Okay, and the applicant? Good evening, sir.
Good evening. My name is Jonathan Wiseman. I'm interested in rezoning a current 0.6 acre lot that's zoned agricultural to 3 residential lots. There's a current home that sits on the property. And the thinking was that we wanted to keep it consistent with the surrounding residential zoning in the area. This particular piece was somewhat of an anomaly in the agricultural zoning, and we brought it in front of the zoning department to try to achieve that goal of adding 2 additional houses on this lot, oversized lot, I should say.
Anything else, sir?
No, sir.
All right, thank you for your presentation.
Thank you.
All right. Step right over here and sign in, sir. Okay, development services.
Good evening, Chris Grandlenar, Development Services. The request is to rezone a 0.68 acre parcel from ASC 1 agricultural single family conventional to RSC 9R residential single family conventional restricted. The parcel is located 45 feet northeast of the intersection of Valrico Lake Road and Booth Drive. The applicant has indicated the purpose of the rezoning is to allow for development of the site as a single family subdivision. The applicant is proposing to restrict the number of lots in the subdivision to 3, 2 lots with a minimum lot width of 70 feet and 1 lot with 60 feet minimum lot width. The applicant has also proposed to restrict the 3 lots to only allow access from Booth Drive. The adjacent parcel to the north is a single family dwelling zone RSC4. To the east is another single family dwelling zone RSC4. To the south, across Valrico Lake Road, are single-family home zone PD. To the west, across Booth Drive, is a single-family dwelling zoned ASC1. Also, an RSC9 zone subdivision is being developed directly southwest of the subject property. The surrounding uses in the area consist entirely of single-family lots. Moreover, the proposed limitations on number of lots and lot width furthers compatibility. Therefore, the rezoning of the subject parcel from our ASC1 to RSC9R restricted would be consistent with the existing zoning pattern of the area. Based on the above, staff finds the request approvable with the following restrictions. The subdivision restricted to 3 lots. 2 lots have a number 2. 2 lots have a minimum lot width of 70 feet and 1 lot shall have a minimum lot width of 60 feet. And number 3, all 3 lots will only have access from Booth Drive. There are no agency objections. I'll be glad to answer any questions you may have.
Not just yet, but thank you for the testimony. And the Planning Commission.
Thank you. Melissa Leinhard, Planning Commission staff. The subject property is located in the residential 6 future land use category. It is in the urban service area, and the subject property is not located within the limits of a community plan. The subject property is surrounded predominantly by single-family residential lots. Given the site's acreage, the minimum allowed density in this future land use category is 3 units, while the maximum allowable density is 4 units. According to the restrictions, the applicant has agreed to restrict the zoning to 3 residential lots. The proposed rezoning would allow for development that is comparable to the residential development pattern in the surrounding area. The rezoning would maximize the efficiency of the subject site and facilitate low-density residential development, which is allowed under the residential 6 future land use category. The subject site is also located in the urban service area, where policy direction says that more than 80% of the new growth is directed there. Overall, the rezoning would allow for development that is consistent with goals, objectives, and policies of the future land use element of the comprehensive plan, and is also compatible with the existing development pattern found in the surrounding area. Planning Commission staff finds the request would encourage development that complements the surrounding character of the area. And based upon those considerations, Planning Commission staff finds the proposed rezoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
All right, thank you for the testimony. Is there anybody here tonight in support of this request? Yeah, I think we had some registered in opposition. How many total do we have?
Alan Kodesky.
Do we have Andre McCarroll and Linda McCarroll signed up for this? Are you logged in? Andre or Linda McCarroll, are you there? Okay, going on to the next person will be Alan Kodesky.
Yeah. So how many are actually going to speak? Do we know? Okay.
Alan Kodesky.
Sir, did you need to speak as well? Yeah. Okay, give us a minute. Yeah, how long do you think you need? Okay. Go right ahead.
Go ahead, Alan.
Okay, I'm a bit confused. The home that's in question that we're talking about now at 1502 Valrico Lake Road is a home that's been up for rent many, many times since I've lived here in the neighborhood, 17 years. I actually live on Booth Drive right down the street. And it's been rented ever since I've been here with new tenants every year. And lately, the latest tenants that moved in were looking to open a daycare center there. They fenced it. They put toys in the yard and as such to make a daycare center. And they even have a sign, just not a big sign, but like a banner attached to their fence with the name of the daycare center. So I was on the conception that this hearing was as they're trying to get approval to open a daycare center at the entrance to our neighborhood in a completely residential community. From what I'm hearing in the beginning of this hearing was that that is not what the issue is. So I need some clarity on that, please.
In short, sir, this is an existing ASC 1 zone property, and the applicant is requesting to rezone to RSC 9, both residential districts. The reported request is in an attempt to do a 3-lot subdivision of the property. So it is not about a daycare, but I'll still welcome your comments if you have any. It's a residential request.
Okay. That was what I thought the hearing was for, because whoever's taken over that house or rented that home was looking to open a daycare. So I thought they were having to get the appropriate zoning to open a daycare facility on the corner of our neighborhood, which is a 100% residential area with no businesses probably within a year. But if this hearing is about subdividing the land to build 3 homes on it, then I really don't have a say in that matter.
I appreciate the comments, though.
Can you state your name for the record, sir?
Alan Kodesky, 1520 Booth Drive, Valrico, 33594.
We actually have one more person in opposition. Okay.
Kevin McKnight, are you there?
Yes, I'm here. Can you hear me?
Yes, we can. Go ahead.
Okay, I'm Kevin McKnight. I live at 1450 Booth Drive. It's northwest across the street from the property in question. I have a question regarding the staff report. I hope it's appropriate right now, but in section 1.3, there's a reference to South 16th Avenue considered a substandard road. And I'm assuming that was meant to say Booth Drive is a substandard road. I wonder if anyone could respond to that, because it does say the developer will be asked to improve that road. I'd be curious as to what those improvements.
Sir, give us just a minute. I think staff's going to look that up for you.
Okay. Section 1.3, evaluation of existing and planned public facilities.
Was it South 16th Avenue? What was that?
Yeah, within the report, it's in section 1.3, it's right in the middle of that second paragraph. It says South 16th Avenue is considered a substandard road, and then goes on to say the developer will be required to improve it.
Yes, that was the comments made by our transportation section.
Yeah, I have no idea what South 16th Avenue is. There's no such road around here. I'm thinking they meant to say Booth Drive.
Booth Drive is.
Give me 1 second at this point. Do we have anybody here from transportation section?
Yes, this is James Ratliff with Transportation Review Section.
So the comment, do you have the staff report handy, James? Do you know where we're talking about?
Yeah, I was just pulling up. This is for, let's see, I want to make sure I'm looking at the right one. 2011-70, is that correct?
Right.
And it's paragraph 4, which refers to South 16th Avenue, of which there doesn't appear to be.
And this is this within, this is case item number 20-1170, is that correct?
I just reviewed the agency comments from transportation. There's no reference to 16th, so I think this is a typo or there's a mistake on a report, because again.
Okay.
So.
Can we find out what road was intended to be addressed?
Yeah, I can, hold on a second.
Actually, James might be able to answer that.
Yes, I'm here.
Are you still with me?
I'm here.
I'm here.
I didn't hear you, James, but I assume you can hear me, it looks like.
Yes.
Okay, so James, paragraph 1.3 of the staff report refers to South 16th Avenue. It appears that you didn't write that, but can you tell us from your report which road is considered a substandard road?
Yes, I believe it was Valrico Lake Road. I'm just pulling up Sophia's Road. Yes, Valrico Lake Road is a substandard road. However, it's important to note that by policy, the county engineer, projects that generate fewer than 10 peak hour trips are not required to make improvements to substandard roads, provided that they meet minimum fire safety standards. So I do want to put that clarification on the record.
Okay. Mr. Scroll will correct the staff report, didn't make the correct reference.
All right. So back to the gentleman that was appearing in opposition. Sir, it was intended to be Valrico Lake Road, and you're welcome to go ahead and continue with your testimony.
Okay, so I would ask then, what are the improvements to Valrico Lake Road that are referenced there? It says the developer would be asked to make those improvements. That's kind of unclear.
Again, those are comments made by transportation. That's from the transportation department.
Well, so I was giving you a little bit of latitude here because you made a good point about what turned out to be a scrivener's mistake, but it is contained in a report that's on the record. James, I don't know if you need to add anything about that if you heard the testimony.
Yeah, for the record, James Ratliff, Transportation Review Section. Because of the small nature of this project, there would be no improvements that would be required. So we were simply noting that the road is substandard, but that because it is of exceedingly low trip generation, essentially almost de minimis, there would be no improvements that are required.
James, I think the issue here is that Mr. McKnight rightly points out that I think the paragraph may have other errors in it. It says the developer will be required to improve Valrico Lake Road to current county standards unless otherwise approved through the section 60402B administrative variance process. Was that never a part of your reports?
No, the transportation report that is in optics that I'm looking at under the section site access analysis and connectivity. talks about the current policy that although it is substandard, there would be no improvements that are required. So I think that may have been a copy and paste error from zoning staff's report, but that from what I can tell, looking at our staff report, that was not contained in the transportation staff.
Thank you, Mr. Ratliff. Mr. McKnight, back to you, sir. So there is a transportation staff report that has the correct information. It looks like there were some Scrivener errors in the staff report. But you are right, that wasn't an improvement. So go ahead, Mr. McKnight.
Okay, so it sounds like no improvements to the road. The only other objection I have is why go to RSC 9 when RSC 6 would probably be more appropriate? Would restrict, I believe, to just 3 or 4 lots, where RSC 9 would allow more, regardless of what's being proposed. Why not zone it accordingly? So, and I just think RSC 9 is really not in keeping with the neighborhood. There's larger homes all around. Those that are smaller are in planned developments nearby where there were curbs and sidewalks and formal entrances and other improvements made. And that's not the case here.
Mr. McKnight?
I'm sorry?
It for you, sir?
Is that it, sir?
That's it for me. Yep.
Could I just add, Booth Drive, why are the driveways
Ma'am,
going to go on?
go ahead and say your name before you speak.
Oh, sorry. Deborah McKnight. Why are the driveways going to go on Booth Drive? Is there a reason for that? Because Booth Drive is a very narrow road.
Okay. I'm going to I'll let you put your question on the record, but it's not really a question and answer period. It's your opportunity to give comments. And if there's staff that can address that, I'm sure they will later. So, but let me know if you have any other comments.
I just have one more, and it's just with the narrowness of the road. If with these 3 lots, then, if they have a party or anything, they have to park on other people's lawns or, because the road's too narrow to, park on and get around.
Thank you, ma'am. Thank you, sir. Yes, sir, in the back.
Thank you.
My name is Keith LaPlante, LaPlant. I live at 1509 Booth Drive. And I just am up here to speak in opposition to this zoning. The property in question, the house that's right in the middle of the property, I'm not sure how you're gonna get 2 other houses around it. All the lots on Booth Drive are 0.3 acres or bigger. If I do my math right, these lots will be 0.226 per acre. I don't think zoning it for 3 homes is in the best interest of our neighborhood. Thank you.
Okay, thank you for your comments, sir. Anybody else in opposition? Okay, seeing none. Any comments from Development Services?
Just a couple of comments in response to the questions by some of the opposition about going to the RSC 6. The minimum lot width under RSC 6 is 70 feet. Therefore, as noted, the applicant wants one of the lots to be 60 feet wide. Therefore, again, they could not accommodate under the RSC 6. The 2 of the lot widths would be consistent with the RSC 6, but the 3rd lot would not be consistent with that since it's a proposed 60-foot wide lot. And my understanding, and transportation can confirm this, but given the Valrico Road and the proximity of Booth Drive and the Valrico Road intersection, there's not sufficient spacing there and appropriateness to have an access point on the Valrico Road for a lot. Therefore, that's why access to Booth is the appropriate.
Brian, I understand that this isn't a subdivision approval. It is a rezoning request. And the subdivision approval may have other constraints in it that may make it infeasible. But do you know if there's any consideration given to whether the lot on the corner would actually work, given that there'll be 2 front setbacks? I think that goes to the gentleman's the last speaker's question. Do you know if there's any consideration given to that?
I'm not aware, I'm not sure if that was looked at. I'm not aware if that was. Yeah.
All right. Anything else from the planning commission?
No, thank you.
Thanks. And then the applicant. Sir? It's your chance for any rebuttal. You had some opposition testimony there.
I appreciate everybody's time, and I think it'll be a lovely development for the community, and we will definitely take everyone's issues into consideration. But given the space and the space in between the properties, I think that there will be no issues and too much of density for the local community.
And your name for the record?
My name is Jonathan Wiseman.
All right, thank you, sir. And with that, we're going to close rezoning 20-1170.
The next item on the agenda is again item C3, rezoning standard 20-1269. The request is rezoned from RSC6 to RSC6 with a mobile home overlay. Isis Brown will provide staff recommendation to presentation by the applicant.
Good evening.
Good evening. My name is Carrie Reynoso, the representative application for 14654 Montaigne Avenue, Dover, Florida 33527. I'm trying to rezone the property from RSC6 to a RSC6MH mobile home. I do have the place to put a dwelling unit, but instead of building a home, I wanted to put a mobile home back there. So I talked to Lori and planning development. She said that's what I would have to do, rezone the parcel where we are at. I don't think it's going to be a bad idea. I've talked to all the neighbors. They're, on it. They're fine with it. All the properties on my one side are RSC 6 mobile home, MH. Across the street from me, right on the corner of Petty and Montaigne, there is a Fresh Start mobile home park. That is a mobile home park. It is a migrant mobile home park. So with rezoning my property, I think it'll be beneficial to the community to have a steady person that will be one of my family members living in that property, well, in the dwelling unit behind me. And it's also a good impact in the community to have revenue coming into the stores. We have a new dollar store. We have a new Family Dollar. We have other little community stores, Hispanic based, that do live off of that. They thrive off of the money that we put in. So the Fresh Start Mobile Home Park, that's by diagonal from me, as soon as I walk out of my driveway, they're not fully there every year. They leave in March, they don't come until September. So I think it's very beneficial to the community to go ahead and rezone my property. The property beside me, that is 083336. It's a parasol property. It's very small. You cannot put a home there. So there's really no competition. I've talked to the guys behind me. Everybody's on board. Other than that, I just think it would be the best position to do a mobile home overlay if that was what we wanted. I was going to do a medical hardship, but I don't want to put the money in if I can just rezone into a mobile home, the RSC 6 mobile home property.
All right, ma'am. Thank you for your testimony.
Thank you.
Okay. And development services.
Isis Brown, Development Services. The request in this case is for a 1.02 acre parcel to rezone from residential single-family conventional RSC 6 to residential single-family conventional RSC 6 mobile home overlay district. In this case, as the applicant stated, the surrounding areas all have that mobile home overlay to them. So it's just getting that particular lot getting that particular lot consistent with the area to the north, property is zoned RSC 6MH. To the east and west, it's also RSC 6MH. And as mentioned, the planned development, which is a mobile home, which is PD 03-0101 to the south, that's also a mobile home park. Based on the above consideration, staff proposes that the proposed RSC 6MH zoning district is approved. Thank you. I'm available for any questions.
Don't have any, but thank you for the testimony. And the Planning Commission, please.
Thank you, Melissa Leinhard, Planning Commission staff. The subject property is located in the residential 4 future land use category. It is in the rural area and it is not located within the limits of a community plan. Future land use element objective 16 and its accompanying policies require the protection of existing neighborhoods through various mechanisms. Future land use policy 16.2 specifically states that gradual transitions between intensities are necessary as new developments are proposed and developed. In this case, Planning Commission staff has determined that a rezoning to residential single-family conventional 6 with a mobile home overlay would provide for a transition between the residential single-family homes and the mobile homes, allowing for a creation of complementary uses. As a result, this use is compatible with the surrounding area and meets the intent of future land use policy 16.10. Hillsborough County's elderly population is expected to increase in the future, and consideration should take into account those needs of people who still live on their own. Future land use objective 20 and its accompanying policy 20.3 encourages new development and redevelopment of residential housing for special targeted groups of people, and additionally identifies manufactured housing as a suitable use for affordable housing. Since the planned development with a single-family residential dwelling and mobile homes occurred directly to the south of this subject property, this rezoning proposal to RSC 6MH would be compatible with the surrounding single-family residential character of the area. The proposed use of manufactured housing on the site is encouraged by the comprehensive plan as a viable means to provide affordable housing. Looking at the community design component in the future land use element, this rezoning proposal is further supported with objective 12.1, which recognizes an existing community and the need of compatibility with any new development. Furthermore, policy 12-1.3 clarifies that new development in existing lower density communities utilize the planned development process of rezoning to fully address impacts on the community. Based upon those considerations, Planning Commission staff finds the proposed rezoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
All right, and thank you for that. Is there anybody here today in support of the request? In support? Seeing none, in support? Okay. Doesn't need to speak. Anybody here today in opposition to the request? Okay, seeing none. Anything else from the applicant? All right, thanks. With that, we're going to close rezoning 20-1269.
The next item, agenda item C4, rezoning standard 20-1271. The applicant is Cherry Hallback, and the request is rezone from AS1 to office residential. Kevy DeFrank will provide staff recommendation after presentation by the applicant.
All right, and the applicant, please. This is 20-1271.
Yes, my name is Cherry Hallback, 1404 Holloman Road, Plant City, Florida. I submitted an application to change my home current use from agricultural residential to office residential in order to operate a nurse registry that sends out certified nursing assistants and home health aides into the elderly home to provide baths, do grocery shopping, and we also provide wound care such as wound care, skilled nursing, home infusion, etc. To give a little history of the property, I was born and raised on this street. It's in the Billsville community, and I've lived out here all my life. My dad deeded me off this property, and we built a home. I built a home, rather, that sits on 1.5 acres It's a 3-bedroom, 2-bath. Fast forward, I once had this home zoned as an assisted living facility in 2016, but due to the pandemic and the low census count, had to close that. And I got received a contingency home base permit from Hillsborough County on July 2nd to operate the nurse registry. My goal is to change it where I can actually have a full office here and have paid staff in order to expand our services in the Bealsville community to the elderly and the disabled persons, and also nearby communities. I've also, how it is compatible along with the policy of 22.2, it's compatible because it would not require any modification to the building whatsoever, thereby keeping this home-like environment in the community. And the homes are still yet, far apart. And the nurse registry is operated virtually. Even those that we hire, we do virtual interviews. No one comes into the office, here, and especially during the COVID and the pandemic. And also with the customers that we serve, they would not be visiting here at the office. So thereby there would be no disturbance as far as noise or increase of traffic foreseen. And the rezoning will be, best fit the need of the nurse registry in order to serve the Hillsborough County residents. And then secondly, the policy 22.8, I had submitted requested a waiver in reference to that as far as being close to the intersection or highway. Because there is no need, we would not be having customers or recruiting candidates coming to the office, just only those that would be scheduling, and that would be like about 3 to 5 office staff. And we do scheduling as far as visits to the homes. And what risk that it imposes, it really won't impose any risk. It will keep the nature and harmony within the community. We would not need no increased parking. As far as deliveries, we don't have any deliveries other than I will have maybe once per month from Amazon, some personal protective equipment, but that's pretty much it. And the reason, especially now, it will help in the community and benefit the community, especially with the rise of the COVID and the providing care in the home for the elderly, so they won't have to go to the stores, because we do the grocery shopping for them as needed, and keeping them safe. And that's all I have at this time.
Thank you. Thank you for your testimony. And Development Services.
Good evening, everyone. Kevin DeFrank with Development Services. As Ms. Hallback, the applicant stated, the request is to rezone one parcel totaling approximately 1.66 acres from the existing AS1 zoning district to the proposed OR zoning district to specifically allow for a nurse registry office. And the site is located in an area comprised of low-density rural, residential, and agricultural uses. Half of the general areas within the Res 1 flu category that can potentially permit commercial office and multi-purpose uses that meet the locational criteria, and the other half of the general areas within the agricultural mining flu category that can potentially permit the identical uses that meet the locational criteria. Also, the overall areas within the rural service area with no publicly owned and operated potable water and wastewater facilities available. And the site is adjacent to the property zoned AR, AS1, and PD, but within the general area, there is one other property zone, CN. Based on those considerations, staff finds the proposed OR zoning district incompatible with the existing zoning districts and development pattern in the area. And therefore, staff finds the request not supportable. Thank you, and I'm available for questions.
Don't have any right now, but thank you for that. And the Planning Commission.
Thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located in the residential 1 future land use category. It is in the rural area, and the subject property is not located within the limits of a community plan. The applicant is requesting to rezone the subject site from agricultural single family 1 to office residential. Regarding the rural area, objective 4 of the future land use element provides for the rural area long-term agricultural uses and large lot and low density rural residential uses. The established standard is that no more than 20% of all the population growth within the county is to occur within the rural area. This is to prevent the encroachment of suburban or urban development. Any new development within the rural community is to be permitted in a limited manner as infill, but not permitted to expand into areas that are designated with lower land use designations. It is expected that those non-residential uses within the rural area be established along major transportation routes and centered at intersections. Objective 16 and its accompanying policies in the future land use element require the protection of existing neighborhoods through various mechanisms. Specifically, policy 16.2 states that gradual transition of intensities between uses shall be provided for as new development is proposed and approved through the use of professional site planning, buffering, and screening techniques and control of specific land uses. In this case, Planning Commission staff has determined that a rezoning to office residential would not provide for a transition between the surrounding residential single-family homes and the neighborhood, allowing for a creation of complementary uses. As a result, the proposed use is not compatible with the surrounding area and does not meet the intent of this policy. Regarding future land use objective 22, along with future land use policy 22.7 and 22.8, the site does not meet commercial locational criteria and a waiver has been submitted by the applicant. The proposed office residential use does not meet the character of the surrounding neighboring area, and staff does not recommend approval of the submitted waiver. With the community design component in the future land use element, several policies apply to this request. It is not supported by objective 12-1, which recognizes an existing community and the need of compatibility for any new development. Policy 12-1.3 clarifies that new development in existing lower density communities should utilize the planned development process for rezoning to fully address impacts on the community. Based upon those considerations, Planning Commission staff finds the proposed rezoning inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Melissa, do you have your report handy in front of you?
Yes, I do.
Bottom of page 5.
Yes, sir. I noticed there was a typo with commercial neighborhood.
Figured you probably knew, but can you address that one? Just can you do a staff report change?
Absolutely, we will do that and submit that for the record.
So,
I do believe the original application was for a CN use, hence the mistake, but we will correct that for the record. Thank you.
Really, thanks again. Is there anybody here today in support of this request? Seeing none. Is there any opposition to the request? Nope. Okay, and the applicant has an opportunity for a final rebuttal.
Yes. Since I was born in this community, I have been contacted by some that was all in support of it. And listening to Miss Melissa, this is existing property and existing development. It's not new development. And I do feel that it still yet would be compatible here in this area because it will not require any modification to the home and keeping it home-like environment.
Ma'am?
Is there anything else, ma'am?
No, that's it.
All right, thank you.
Please state your name for the record.
Terry Hallback.
All right, thank you, Ms. Hallback. And with that, we're going to close rezoning 20-1271. The next item is agenda item C5, rezoning standard 20-1274. The applicant is Robin Real Estate Incorporated. The request is rezoned from commercial neighborhood to commercial intensive. Chris Grandel-Leonard will provide staff recommendation after presentation by the applicant.
Good evening, Mr. Scarola. My name is Jeremy Couch, 17937 Hunting Bow Circle, Lutz 33558. The proposed request for rezoning tonight is a 0.62 acre parcel on the northeast corner of Nebraska and 129th. The change is from CN to CI. The applicant owns approximately 10 acres north and east of this parcel, contiguous to the parcel. The current request is for CI zoning. CI is consistent with the future land use of OC20. Surrounding uses to the south include a labor pool, smoke shop, body shop. Uses to the west of Nebraska include a welding shop, auto paint, and auto sales. Uses to the north and east are the applicants, and they have CI uses and M uses. As stated, these uses are all compatible with the CI category. There were no comments or objections by any reviewers. I did not know of any neighborhood opposition, and staff has recommended approval. We request the same from you. Thank you.
Thank you, Mr. Couch. And Development Services.
Good evening, Chris Grandel-Leonard again, Development Services. The request is to rezone a 0.62 acre parcel from CN commercial neighborhood to CI commercial intensive. There's an existing office on the site. The parcel is located 55 feet northeast of the intersection of East 129th Avenue and North Nebraska Avenue. The applicant has indicated the purpose of the rezoning is to expand the allowable uses for future development with the adjacent parcel that is also owned by the applicant. The adjacent property to the north and the east is owned by the applicant and is used for a scooter rental company and a warehouse. The parcel is zoned CN commercial neighborhood and M manufacturing at the northern section and CI commercial intensive at the eastern section. To the south across east 129th Avenue is a commercial strip mall, zone CN commercial neighborhood. To the west across north Nebraska is a welding supply store, zone PD, and an auto repair shop, zoned CG, commercial general. The surrounding uses in the area consist mostly of commercial and manufacturing, and CI parcel is directly to the east, which is owned by the applicant. Therefore, the rezoning of the subject parcel from CN to CI would be consistent with the existing zoning pattern of the area. Based on the above considerations, staff finds the requested CI zoning district compatible with the existing zoning and development pattern in the area. There are no agency objections. Staff finds the request approvable. I'll be glad to answer any questions you may have.
I think I'm good, but thank you for the testimony. And the Planning Commission.
Thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located in the Office Commercial 20 Future Land Use category. It is in the urban service area and also within the limits of the University Area Community Plan. The proposed rezoning to CI would allow development that is similar to the existing commercial uses nearby fronting North Nebraska Avenue and meets the intent of Future Land Use Element Policy 1.4 with regard to compatibility. With regard to policies 22.1 and 22.2 of the Future Land Use Element, the rezoning application seeks to intensify a portion of the property from CN zoning to CI zoning that is compatible with the surrounding properties. The proposed zoning district would allow uses that are compatible and complementary to the surrounding commercial uses. With regard to this community design component in the future land use element, this rezoning will meet the commercial character by using similar commercial design standards in scale and design. It is appropriate for any new commercial zoning to locate at activity centers and commercial redevelopment areas such as this location. Additionally, this redevelopment is in character with the surrounding community and is consistent with Goal 9 and the accompanying policies of the community design component. The proposed rezoning will allow for the redevelopment of the site, which is compatible with the surrounding mix of uses, and provide greater flexibility in the use of land and density and intensity for future development, while also ensuring the use of neighborhood compatibility. This rezoning is compatible with the University Area Community Plan vision. Based upon those considerations, Planning Commission staff finds the proposed rezoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
All right, thank you. Anybody here tonight in support of this request? Nope. Any opposition to the request? Seeing none. Anything else from Mr. Couch?
No, sir. Thank you so much.
All right, after that, we'll close rezoning 20-1274. Ryan?
The next item on the agenda is agenda item D1. It's rezoning PD 20-10154. The applicant is W.C. Smith. The request is rezoned from AS1, ASC1, and PD to a plan development. Israel Monsanto will provide staff recommendation after presentation by the applicant.
Good evening.
Good evening, Mr. Scarola. For the record, Michael Horner, 14502 North Dale Mabry Highway, Tampa, Florida, 33618, and I have been sworn. With me tonight, Mr. Scarola is my client, Mr. W.C. Bubba Smith and his wife Amanda. Mr. Smith will speak briefly at the conclusion of this presentation. Also, I believe virtually we have Mr. Matt Norman, who is the engineer with Boggs Engineering, who did the site plan on this project. He'll speak after me. Allison, could I get 10 minutes, please? Just give me a buzz at 10. Thank you very much. Mr. Squirrel, we appreciate working with staff. We do have split recommendations tonight, so I have to get into a little bit of the weeds and the testimony and the facts on this case. We do appreciate Mr. Monsanto's efforts and staff. We have worked diligently with them and pleased to be here this evening before you with recommendation for approval, although we still have an inconsistent finding from the Planning Commission. This is 3.45 acres at the south portion of US 92, just east of Moores Lake, which is Dover Road, south of US Highway 92. US 92 is an arterial highway in this area. We have two split zoning districts. We have ASC1 and AS1, and we're seeking a PD, plan development rezoning, for an engine repair shop and accessory open storage. This is in the rural service area. Mr. Squirrel, I should note before we get into the Res 1 and locational criteria issues, there is a companion comp plan amendment, CPA 1906. This was set to be heard this year. It has been bumped because we continued several times on this case. Pamela Jo Hatley had this initial case filing, but had to recuse herself. She was just recently appointed as zoning hearing master, as you know. So I took over this case in late August, July, August. That CPA hearing actually was heard by the Planning Commission in October of 2019. So hard to believe, almost over a year ago. That comp plan amendment was heard, and we're seeking the SMU 6. As you know, we can't do open storage in Res 1. So it's predicated upon the comp plan being approved to SMU 6, and of course, the Board of County Commissioners approving both the comp plan and the PD rezoning. I would note that at that comp plan hearing, the Planning Commission overturned the Planning Commission staff recommendation to not support that comp plan amendment to SMU 6. And I'm going to file, I think we have 29 letters that supported that SMU 6 from the surrounding neighborhood, and they continue to support this case. It's rather interesting that we have absolutely no opposition.
Mr. Horner,
Yes, sir.
one thing maybe didn't understand. Planning Commission Board did what with the SMU 6?
They approved the request to SMU as a recommendation to be brought forward to the Board of County Commissioners in
And
January.
when was that?
October 14th, 2019.
Okay.
Yeah.
You have that, did they produce any sort of report with the approval?
I have the text
transcript
in terms of the actual report filing for the CPA. I do not have the resolution. It is on the public record, CPA 1906. We should have copied that, quite honestly, but it's of record and it was approved in October of 19.
Yeah.
So the Board of County Commissioners on January 12th is going to hear both this PD and the SMU 6 comp plan amendment. And so in terms of the history, Mr. Scrolla, my client purchased this property in 2017, 3.45 acres. He went into a construction of a house, beautiful single-family house, which is on the eastern side. This is the property that's L-shaped. Constructed a new single-family house in 2018, approximately 3,000 square feet. And he also constructed a pole barn.
Can you point to it again? It wasn't open.
I'm sorry.
Yep.
So here's 92.
Yeah.
This is the single-family house.
Talking to the microphone.
This is the single-family house that was constructed.
Okay.
And this is a pole barn structure.
All right, thank you.
My client relocated from rural areas in Tennessee where there were no zoning districts, no comp plan. He didn't know what a comp plan or a zoning district was. Suffice to say, we're not going to go back in time and argue what happened. We are here because he has been cited for a structure. He thought it was permitted. We filed into the record the genesis for that belief, but I'm not arguing that citation is active. Code enforcement has been most gracious, understands we are in this process.
Which structure were you referring to?
The pole barn.
Okay.
Yeah, the pole barn structure. So that was under citation, as well as the open storage. We can't have open storage in Res 1, as you know, and ASC 1 does not allow either the repair facility or the accessory open storage. I can assure you, Mr. Scroll, my client would not have spent $500,000 plus if he felt he would have to take it all down. He expended substantial sums of money, both in the acquisition, construction of both the house and the pole barn structure. When you go out there, you will see what I'm referring to. This plan takes all of those nonconformities and conforms them to a site plan that we believe is functional, that addresses the concerns, and has the entire support of the surrounding neighborhood. Ironically, the Northeast single-family lot owner who resides here just acquired that. The prior owner went ahead and constructed a minimum 6-foot metal fencing all the way around. That's a requirement that my client had to do. The property owner went ahead and did that, and then later decided to sell. And the new owner, who my client just met just a couple months ago, also owns a trucking business and is more than pleased that my client does truck repair. This is truck engine repair. Mr. Scroll, this is not the cabs or the rigs. This is not brakes or anything else. It's solely diesel engine repair. He is a certified diesel mechanic. He is well respected, certified. People come to him, and he is now offering those services to the trucking industry, which, as you know, during the COVID times, we are relying on the trucking industry more than ever for goods and services. So the proposed plan, as Scroll, represents both residential and non-residential uses. Again, a close-up, and I think staff's report is effective. This is the pole barn structure. This is a little skewed in terms of the scale and the format. My client's residential house is here. So this is the non-residential area, and then this is the residential parcel that we just call the residential tract. 2.4 acres is the non-residential, commercial tract, if you will. The residential portion with a new house is 1.04 acres. This pole barn structure is closed on all sides except the east that directly faces my client's residence. It's about 4,800 square feet. Has parking maneuvering in front. It has approximately 3 to 4 bays, depending how big these actual cabs are when they're pulled in. There are also 2 accessory open storage areas, Mr. Scarola. One is on this north area, and then a south area here. You can see these vehicles. The north area has 2 trailers for parts and supplies and a container that's on site, and the south has no structures, but accommodates a staging area for those cabs being repaired. The hours we agreed to restrict to Monday through Friday, 8 to 5, no weekends, no evenings. The client is a family man. He does not want any businesses operating near him on the weekends, and he shuts down at 5 o'clock. So no one goes there after 5 or on the weekends. We also filed design variation. Mrs. Scroll, it's made part of the record. As you know, for open storage and a CI type use, the requirement is to have a concrete wall, 30-foot type C buffer. My client has reached out to the neighbors and nobody wants a concrete wall out there. Beyond the expense of it, it would just make this area, I think, read as an institutional, and nobody wants that. My client is asking for a 8-foot PVC or metal fencing that would wrap around this site, including the open storage area, including screening to the north, going behind the pole barn structure. This is a EPC wetland area. The entire southwest quadrant is an EPC jurisdictional wetland. We would be outside that 30-foot setback. This is the south property line, and we would extend it beyond this storage area and go just about to the western side of the residential house where they have the drain field and septic tank.
Far be it for me to overcomplicate, but what about the 30-foot wetland setback?
We made it. We will meet it, yes.
Okay.
So no encroachment, no mitigation, EPC of record, no objections from them at all. So we're good on that. My client has also agreed to extend on the eastern side. So the screening from north to south is visible, but we cannot agree to the gate because he gets a lot of part supplies, and to open and close that gate on a routine basis will be very difficult. So we asked Mr. Monsanto to allow that gate opening. So this screening, the 8-foot screening, would stop on both sides of the proposed 24-foot commercial drive. This is the pole barn structure, Mr. Scarola. It's in the report. I have 50 pictures, but I thought these pictures were as good as any of mine. You can see it's got a pitch. You can see it has bays in the front. Those bays face east, and east is where my client's single-family house is. Staging of the vehicles are to the south. And then we have the containers and the 2 part supply areas on the northern side. We tried to move those closer, quite honestly, but we would impact some trees. My client did not want to take down these trees just to accommodate the container trailers. Sorry. So my client has to construct, it's not a commercial business. He has to meet commercial development site review. He is bringing in a paved 24-foot wide commercial drive. We had a sidewalk on the eastern side, but to meet the buffer requirements, we advised staff we would meet 30-foot type C buffer everywhere with a design variation for the 8-foot high PVC or metal fence on all sides where we delineated in the last graphic. This is a proposed parking lot. It's going to be paved along with the commercial access drive. We restore this buffer on the eastern side to the 30 feet. The only area, Mrs. Scarola, in design variation that staff's included in their report is the area in front of the pole barn structure. We asked for this area to reduce to 20 feet, and staff calls that out very clearly, just to allow maneuverability so it doesn't pinch that area in front of the bays of the pole structure. Single family house obviously stays where it is. This screening fence goes all the way across here in the south open storage area. Septic tank drain field is here. You go out to the site today, you will see my clients have already initiated the planting of the trees and the buffering all through here, and all through here on the eastern side. We've also committed to landscaping and the sea buffer all the way in the western side as well. I believe there's a graphic typo that says termination to B. It's actually C for the entire western side that's called out in staff's report. This was the prior plan, Mrs. Scroll, just for comparative purposes. Again, the sidewalk was going to be on the eastern side. We had a conflict with that 30-foot buffer. It ranged because it varies from about 32 to about 21. So we could not agree to that entire construction of the sidewalk on the eastern side. We have flipped that sidewalk on the west side of this drive. So this is the old plan. On the new plan, you can see we've taken that sidewalk here that encroached in the buffer. Now we're moving it on the eastern side that goes right to this parking lot that'll be paved. Let's leave that up for the moment.
And that's for ADA access?
Yes. Couldn't waive it, can't file any relief to it. Mr. Ratliff said that's what's going to have to be done. Boggs Engineering related. My client is not happy. He's going to have to lay out a significant amount of money to conform this. That's the price of doing business in Florida versus the rural mountains of Tennessee. So that SMU 6 is pending. Staff, is that 10 minutes?
30 seconds.
30 seconds. Okay, thank you very much. So we have a number of uses in the surrounding area. Yes, we do not have any CI open storage directly next to this site. And that's why my client sat down at Israel and we said, we will screen the heck out of this so that no one visibly sees this open storage. And the pole barn structure on the western side has no impact. There's no doorways, there's no noise, there's no odor. He doesn't do any body work, doesn't paint. He simply has repairs. That's it. And standing on US 92, extending south, there is such a grade, you can't even see the pole barn structure or any of the trucks.
It's graded downward?
It's grading to the south, right? So it's a substantial change in grade. So if you drive by, I missed it twice, then my GPS indicated that was the address, and you go down that drive, and then that's where it opens up to his pole barn structure, as well as the open storage. Mrs. Scarola, this is not an easy case. My client has invested his entire life savings into this effort. He knows he made a mistake. He's a humble man. We are where we are, and I told him we have to do everything possible to conform. It's not going to be cheap. It's not going to take a quick review. It's going to be an extensive site review process. That is going to continue on past the rezoning if the zoning gets approved. If the board decides not to approve the SMU 6, our PD rezoning stops and we can't go forward. So a lot is riding on this request. I'm going to file a number of, go ahead.
Was there discussion of use in the SMU 6 review by the Planning Commission board?
Absolutely.
Okay,
Yeah.
so they knew what it was about.
In fact, every single letter of these 29 letters.
In the 29 letters, are all the surrounding property owners in?
It's both north and south. There's only a couple property owners on the south side.
About the west?
There's one property owner. He wants to do commercial. He's got the wetland, no objection. My client's talked to him numerous times.
Did he sign or he just didn't do anything?
The one to the west did not sign, but never appeared. All of those letters, in fact, the letter states, if I can read that in the record, I'm aware of Mr. Smith's engine repair shop operation at his property. We do not object to this use.
Okay.
Mr. Smith's engine repair shop operation has no adverse impacts on my property.
And then the east side?
I'm sorry?
The east side? How about the east side?
East side is the property owner that actually is the trucker that is happy. Mr. Smith is the
Well, the
truck
question is
mechanic.
simply, do you have a letter from him?
I don't believe he signed, but he has no objections. You will not find any objections of record, either virtual or in writing, on this case.
So in short, you've got, is it 29?
29.
And that includes north and south, but not east and west, but they're not opposed on either east and
Correct.
west. Okay.
Correct. All right, so I'm going to close, leave time for Mr. Norman to just briefly address the site review plan. Then I'd like my client to make a brief statement.
You've got 2 minutes and 40 seconds.
Like I
left.
said, I'm going to stop now. Matt, you got 60 seconds. Thank you.
Thank you.
Hi, everyone. My name is Matthew Norman. As Mr. Horner indicated, I'm with Boggs Engineering. I'm one of the engineers there who's tasked with helping Mr. Smith bring his site up to County Land Development Code standards. In order to do this, we are going to widen the driveway coming into his property to 24 feet wide, which is the commercial minimum driveway width. We are going to be adding the public sidewalk within US 92 right-of-way per Land Development Code, adding a private sidewalk to connect the public sidewalk to his repair shop area. We will also be adding a stormwater management pond to properly treat and attenuate any runoff from the improvements based on county, SwiftMud, EPC standards. All EPC buffers are maintained. And then obviously we'll be adding the buffer fencing and any required landscaping to the plans as well in order to bring the site up to compliance. Thank you.
Mr. Scroll, I'm going to close. At this point, I'm going to call my client up on the rebuttal portion, if that's all right.
That's fine, but at some point, I assume you're going to address the planning commission position.
I'm going to have to hold that for rebuttal unless I do have any additional time. All right, I'm going to have to hold that for rebuttal. I will certainly take issue with the planning commission's findings.
All right, thank you.
Thank you.
Mr. Horner. All right, and development services.
Good evening, Israel Monsanto Development Services. As stated by the applicant agents, the request tonight is to rezone the parcel to allow the continuation of a truck repair shop business on the same lot where the owner resides. According to the application, single-family home was constructed in 2018. The repair shop was also constructed in the same year. Per the narrative, before purchasing the property, the owner met with county staff to inquire whether a shop and residence were permitted uses, and from this conversation with zoning, the owner understood that if the two parcels were joined together, he could have both his home and a shop on the property for commercial purposes. And in May 2018, the owner got approval for an electrical permit for a personal workshop as indicated in county permit records. Commercial engine repair shop and open storage then started operating in the subject site. Unlike a workshop or garage utilized for personal work and accessory to a residential use, commercial repair shops require site development review and approval, as well as building permits. Commercial uses are not permitted in the current zoning, and in June 2018, code enforcement issued a notice of violation and informed the applicant that the property was not zoned to allow the engine repair shop. As the applicant stated, the current repair shop business with associated open storage is not consistent with the future land use of Res 1, and there is a CPA 1906 for a map change from the Res 1 to SMU 6 suburban mixed use, which received approval by the Planning Commission. Per the submitted site plan, this PD will consist of a non-residential part occupied by a repair shop building with associated parking and outside storage areas, and a residential part occupied by an existing residential single-family home. Maximum FAR proposed is 0.046, which is below the maximum permitted by the proposed SMU 6. The shop will have a maximum number of 4 repair bays, and all work will be performed indoors. The non-residential part is limited to repair of trucks with no muffler, bodywork, spray painting, tire replacement, or use of any pneumatic impact tools. In addition to the 50-foot front setback required by the ASC zoning, the applicant proposes to add 30 feet of buffer along US Highway 92. And existing vegetation will remain as a screening to the outdoor storage from US Highway 92. The site will maintain a single access of the road subject to FDOT review and approval. Hours of operation will be from 8 to 5 as indicated by the applicant, with no weekend activity on the non-residential part. The 2 open storage areas being proposed in the non-residential part, and one is along the north, adjacent to the parking lot and restricted to 2 trailers and a 20-foot container used by storage by the applicant, and the other open storage will be on the south side of the non-residential part. A PD variation, as indicated by the applicant, has been requested. Per the code, outdoor storage requires 30 foot of buffer with type C screening. The screening consists of 3 elements. 1, evergreen shade trees landscaping. Second, a 6-foot masonry wall and 3 long, low-growth evergreen plants, ground cover or rock mulch. The non-residential plot will comply with a 30-foot buffer in the majority of its boundary, in addition to the required landscaping and lawn requirements. However, the applicant is requesting the use of an 8-foot high PVC or metal privacy fence instead of the 6-foot high masonry wall. The site plan shows the alternative screening along the northwest and south of the non-residential parcel, and additionally, the screening will run along the south property line of the residential parcel, at least up to a distance of about 85 feet. The enhanced fencing will exceed current 6-foot high requirements and place where off-site view lines may potentially be visible. The applicant is also requesting to reduce the 30-foot buffer along that portion of the East PD boundary adjacent to the driveway to 20 feet. This reduction is only to allow maneuverability in front of the repair garage at the corner of the abutting property to the northeast. The buffer has been planted with trees and currently exists west and south of the residential lot to the north and the east of the subject storage use, and will be further expanded upon approval of this PD to the other areas. Staff has reviewed the variation justification submitted by the applicant. The proposed fencing, 8 feet high and made of PVC or metal, will reduce visibility of the open storage areas from the outside, given its increased height compared to a 6-foot high wall, therefore reducing visual impacts from the site to surrounding parcels. Also, existing a natural vegetation along the north and the right-of-way would add to the screening of the site from the road. The applicant will maintain the required landscaping consistent with code requirements. Additionally, the required 30-foot buffer along the north and adjacent to the parcels to the west and south will be maintained. As the applicant stated, the buffer will be reduced to 20 feet, and staff doesn't object to this reduction in that specific area. It will have the screening per code in that area as well. Planning Commission staff finds the proposed rezoning inconsistent. In the report, Planning Commission staff acknowledged that the applicant has made a true attempt at mitigating impacts to the surrounding development pattern by providing additional buffering and screening. However, the application does not meet the full intent of the goals and strategies as indicated in the staff report. Adjacent zoning districts consist of agricultural and residential uses today along US Highway 92. However, sites west of Moores Lake Road along both the north and the south are approved today for commercial uses. PD02 1387 at the southwest corner of the intersection is approved for more than 23,000 square feet of non-residential uses, including mini warehouses, convenience stores with gas sales, and office uses. There is also a PD on the northwest corner, which is 900127, approved for RV sales, servicing, and major repair. And this PD also has open storage approved. Other sites in the vicinity are to the east are zoned commercial general and commercial neighborhood. Although the future land use along the south of the US Highway 92 today has a residential 1 classification, commercial development is currently found on the south side of this corridor. Extensive setbacks and buffers would restrict outdoor storage for this site near the road to the north, and also the required landscape screening per the code will be in place along the north PD line, in addition to existing vegetation. Buffer and screening for adjacent properties per code will also be in place to west, south, and east. Alternative solid screening consisting of a 8-foot high fence would meet the intent of the code by properly reducing visual impacts from adjacent properties. In terms of intensity, the repair shop building will be limited in size, and all repair works will be conducted indoors. Intensity of proposed use will be below the maximum FAR of 0.25 per the proposed SMU 6 future land use. Restrictions to the type of work performed on site, such as the muffler repairs, bodywork painting, will further limit the negative impacts to nearby sites. If the concurrent CPA 1906 application with these rezonings are approved, development of the site will be subject to development plan, site development plan review and approval for stormwater, wetlands, and natural resources regulations. In conclusion, Development Services staff finds that the proposed non-residential use with restrictions and screening is compatible with the emerging non-residential development pattern in the area. Other non-residential uses are currently approved along US Highway 92, northwest and east. The applicant has made efforts to compensate impacts to adjacent agricultural and residential areas through the physical and natural screening of the site. buffer areas, limited intensity, hours of operation, restrictions. The location and screen of the repair shop building central to the site and away from the road would reduce negative impacts from public right-of-ways. The open storage areas are being placed a minimum of 80 feet from the road, and existing building will maintain its current footprints. No objections were received from other reviewing agencies, and based on all these considerations, Development Services staff recommends approval with conditions. And I'm available if you have any questions, Mr. Scarola.
Okay, thank you, Mr. Monsanto. Appreciate the testimony. And Planning Commission, please.
Thank you. Melissa Leinhardt, Planning Commission staff. The site is in the rural area and is not located within the limits of a community plan. An amendment is in process requesting a comprehensive plan map change from residential 1 to suburban mixed use 6. This comprehensive plan amendment was heard at the October 14th, 2019 Planning Commission meeting and was found consistent at that meeting. The comprehensive plan amendment is scheduled to be heard at the January 12th, 2021 Board of County Commissioners meeting. And this rezoning is subject to the Board of County Commissioners approval of the comprehensive plan amendment, which is number 19-06. Though the Planning Commission approved the suburban mixed use 6 future land use category on the subject site, the predominant area remains residential 1 and residential 2 on the future land use map. This is reflected by the large lot residential pattern and the agricultural uses in the general area. Properties in the vicinity of the site are zoned agricultural single family 1 and agricultural single family conventional 1 and agricultural rural. Given the intensity of auto repair, the proposed use will not integrate well with the surrounding development pattern and would be an intrusion into the existing residential community, which is in direct conflict with policy 16.3 of the future land use element. Additionally, this proposal does not provide for a transition in land use as described in future land use policy 22.5. Auto repair in this location would erode the logical land use transition that is currently in place, permitting a more intense use away from the intersection of Moores Lake Road and US 92. The applicant is requesting a planned development to allow for the continued operation of an auto repair shop with associated open storage and an existing single-family home. The site is located within the rural area of unincorporated Hillsborough County, specifically on the south side of US 92, east of Moores Lake Road. The proposed rezoning would legitimize an auto repair use and activities that would not be compatible with the established residential and agricultural development pattern found along this portion of US Highway 92. This highway and the immediate area has two different characteristics. The development pattern along the south side of US 92 is predominantly residential with a few scattered non-residential uses and is predominantly designated as residential 1. None of the non-residential uses along the south and the immediate vicinity are as intense as what is being proposed by the applicant. However, the north side of US 92 is more intense in nature and is developed with an RV sales center and light commercial uses. This is due to the fact that there is a cluster of suburban mixed-use 6 future land use category, which overall provides for more intense uses. Future land use element policy 1.4 defines compatibility as the characteristics of different uses or activities or design which allow them to be located near or adjacent to each other in harmony. Elements affecting compatibility include the following: height, scale, mass, and bulk of structures, pedestrian or vehicular traffic, circulation, access and parking impacts, landscaping, lighting, noise, odor, and architecture. Given the operational characteristics of an auto repair use, it has the potential to cause unmitigated noise. The orientation of the bays facing east is the direction of the single-family residential, therefore not allowing the different uses of the area to be in harmony with one another due to the potential noise, which would be inconsistent with policy direction. Additionally, the community design component in the future land use element contains policy direction about designing developments that relate to the predominant character of the surroundings. It further states that new developments should recognize the existing community and be designed in a way that is compatible with the character of the area. Allowing auto repair in a predominantly residential area would be out of character with the surrounding development pattern. When requesting non-residential uses, developments are required to meet commercial locational criteria or to request an exception to the criteria. Locational criteria is based on the land use category of the property, excuse me, and the classification of the intersection of roadways as shown on the adopted 2040 Highway Cost Affordable Long Range Transportation Plan. In this instance, the site would not meet the distance requirements of 300 feet for locational criteria within the residential 1 future land use category, and a waiver would be needed. However, with the suburban mixed use 6 classification, the site would meet the distance requirement of 600 feet and can be considered for non-residential uses and would not need a waiver. Although the site can be considered for non-residential uses within the SMU 6 future land use category, policy 22.7 of the future land use element states as follows: considerations involving land use compatibility, adequacy, and availability of public services, environmental impacts, adopted levels of service of affected roadways, and other policies of the comprehensive plan and zoning regulations would carry more weight than the locational criteria in the approval of a potential commercial use in an activity center. The locational criteria would only designate locations that could be considered and in no way guarantees the approval of a particular non-residential use in a possible activity center. This site is subject to the approval of the Board of County Commissioners' decision of the requested future land use designation change to SMU6, which may affect the locational criteria. The applicant has made a true attempt at mitigating impacts on the surrounding development pattern by providing additional buffering and screening. However, the application does not meet the full intent of the goals and strategies regarding compatibility and land use transitions. Overall, Planning Commission staff has concerns with allowing intensive uses directly adjacent to residential single family and believes that the request is too intensive for the existing rural development pattern. The proposed rezoning would facilitate commercial encroachment into the existing residential area, undermining the intent of the rural area of unincorporated Hillsborough County. Based upon these considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you for that. Is there anybody here tonight in support of this request? Seeing none, is there any opposition to the request? All right, Mr. Horner.
Allison, 4 minutes, please. Mr. Scroll, I'll be brief. Michael Horner again for the record. We appreciate the Planning Commission's response. I am not surprised by that response. That was a response on the CPA request, so we knew if they were not going to support the CPA, they were not going to support the PD. Got it. The policy 1.4 that I would draw your attention to is the exact same policy that Ms. Lionheart addressed. They've modified that definition of compatibility now. Before, it simply said not the same as. Now they refined that to state some elements affecting compatibility include the following: height, scale, mass, bulk of structures, pedestrian or vehicular traffic, circulation, access, parking impacts, landscaping, lighting, noise, odor, and architecture. Mr. Scroll, I would suggest to you that none of those issues are incompatible with the surrounding land uses. In terms of scale, 4,000 square feet, 3,000 square foot house. In terms of noise, there really is no noise that is generated from this use. Those engines are not run. They are started, diagnosed, and repaired. That's a quiet repair service. In terms of parking impacts, we are mitigating all the parking on site by a brand new parking lot. Landscaping, we are far exceeding the requirements and meeting the type C all the way around the site. Lighting, we have no additional lighting. Odor, there is no odor emanating from this proposed use. Architecture, single-family house is a single-family house, and the pole barn structure, there are numerous pole barn structures in that community. We would suggest that we understand why the Planning Commission found it inconsistent. We are not abutting CI or SMU6, but we are clearly compatible in terms of their definition of compatibility in height, scale, architecture, massing, and bulk of structures, et cetera. This is the site, Mrs. Sproul. Directly east, this is northeast, so essentially catty corner from where the repair bays are. This is the abutting 8-foot, 6 to 8-foot fence that is constructed on both the north and eastern side, north of the house, east of the access drive coming in. These are the vehicles. These are all cabs, and that's part of the storage area for the staging. This is a busy place, Mr. Scrolla. My client is going to have to be corralled under the site review filing because he's going to have to compress and address and screen and then build that 24 access drive with sidewalks, with parking. He closes at 5, no weekends. My client has done everything asked of him and more on this. For that reason, those same policy guidelines were the basis for their denial to the Planning Commission, which overturned the staff's recommendation of inconsistency.
Mr. Horner, can you tell me a little bit about, or comment on the proposal does not provide for transition in land use for policy 22.5?
I understand. I laid out that we do not have CI in front. I would only suggest to you that we are oriented internally. So that interface along the west is 8-foot screening, landscaping, pervious, swale, and the rear of a pole barn structure. All of that is consistent with existing land use relationships in that part of the community. The open storage area that we have in the south, that is going to be all fenced and screened, and no one can see that, and it's a passive use for storage only. My client lives in this house. My client is 100 feet to the east. He is the recipient of any and all impacts, and I can assure you he would not want to reside if he did not find it compatible or if he was in conflict with his very own use. He does not want to have that incompatibility as well.
Can you tell me quickly a comment on policy 22.7 with regards to, hey, it meets locational criteria, but that's not all you have to do because considerations involving land use compatibility, adequacy.
I would suggest that we, as the Planning Commission noted, we do meet commercial locational criteria. It would meet it under the SMU 6. We don't meet it in the Res 1. So,
well, the point isn't that. It's even if you meet the locational criteria, policy 22.7 states considerations involving land use compatibility, adequacy, and availability of public services, et cetera, carry more weight than the locational criteria. I paraphrase, but essentially that's what it says.
Again, the needs of the residents, my clients and neighborhood serving use, because there are truckers that live in that area that bring their trucks to his business to be repaired.
Okay, we'll take a quick comment.
Mr. Smith, 30 seconds, please.
Name and address, sir.
My name's W.C. Smith, 13437 East US Highway 92, Dover, 33527.
Thank
you. Came here 11 years ago from Tennessee, was in the profession as a truck mechanic there, had a shop, wanted warmer weather. Found this property with several parcels. I was able to acquire it, but beforehand, I met with the people living around it, told them my intentions. They all seemed supportive. I then purchased it. Learned to marry it together. I could create my shop and my home. My mistake, sorry to add to y'all's work, but I've spent a fortune, and it sounds like I'm gonna spend another if you approve it. But we keep working, and we keep providing for the community. I just wanted to simplify things and work from home. I don't like being in town. I'm a country boy at heart. We support and help a lot in the community, and we keep a lot of people working. I just want to keep doing it, but I want to do it legally. I don't want to have to look over my shoulder and wonder, what I'm doing wrong.
Thank you for your comments.
Yes,
sir. All right. Anything else, Mr. Horner?
Yes, sir. Thank you for your time.
Okay.
Yes, sir.
With that, we'll close PD 20-154.
The next item is agenda item D2, rezoning PD 20-0330. The applicant is Potomac Land Company. The requester is rezoned from AR to plan development. I'll provide staff recommendation after presentation by the applicant.
Good evening.
Good evening, Sean Cashin, 13825 ICOP Boulevard, Clearwater, Florida. We have a brief PowerPoint presentation for you tonight. That is the name of the project, Summers K, the rezoning number. The project location, it's a 13.9 acre tract located on the east side of Harney Road, approximately a third mile southwest of Tom Folsom Harney Road intersection. We are proposing to rezone from agricultural rural AR to PD. The PD zoning proposes a single-family subdivision with 47 lots. Future land use. I'm trying to go back here. This is going forward. Okay. Operator, sorry about that. Future land use is R4. The 47 proposed lots equates to 3.39 units per acre density, meeting the 75% allowable based on the 4 units per acre for sites within the urban service area per policy 1.2. We have R1 to the east, R4 north and south, and we have R12 that's a little bit further to the west, on the west side of Harney Road. Current zoning is AR. We have an existing Oak Ranch development to the north, which is a 28-unit PD. That's PD 14-0237. ASC 1 to the east, a smaller PD to the south, along with a AR zoning. There is also an approximate 12-unit mobile home park. It's located to the southeast of the site and to the southwest of the site for PD 180277. That is approved for an almost a 40,000 square foot mini storage. There are various office warehouses uses to the west, actually in the west side of Harney Road. And then further to the east, you have the RMC 12 zoning. We are in the urban service area. That is our general site plan. We are proposing 6,000 square foot lots with a minimum lot width of 50 feet, with the 10-foot landscape buffer proposed along both roadway frontages to the east and the west. And also a 10-foot buffer is proposed where our lots abut to the north and to the south. The landscape buffer will consist of a 6-foot high fence with 3-inch caliper trees every 40 feet. Also, I just want to mention the drainage will be in accordance with Hillsborough County stormwater regulations, and this is a volume sensitive area, and we will adhere to that criteria. Typical lot layout, 6,000 square foot lots, minimum lot width 50 feet. There is the vertical landscape screening, 6-foot high fence, 3-inch caliper trees to the north and the south. And also I might mention to the south where we have the roadway that was shown on the general site plan, we're also going to have a 3-foot wide tract adjacent to the roadway with the same type of buffer. There's a concept plan showing 47 lots. Actually, it's renumbered. It's actually 46 lots. Traffic, I'll just go to this one right here. We abut Harney Road, which is to the west. That is a arterial road. And we have Tom Folsom Road, which is a collector road to the east of the site. All right, let me catch up here, sorry. Roadway design variances and exceptions, administrative variance for Tom Folsom Road roadway spacing, a design exception also for Tom Folsom Road in lieu of meeting roadway standards. We are proposing a 670-foot sidewalk extension, which is on the next slide, that will go up to the north to connect to Folsom Elementary School. We also had administrative variance for the Harney Road driveway connection. There's a sidewalk improvements that shows the sidewalk along the frontage on the east side with Tom Folsom Road and the approximate 670-foot sidewalk extension that will connect into the existing sidewalk, providing access to Folsom Elementary School. Connectivity map. We are connected to the existing Oak Ranch development to the north by way of Oak Ranch Heritage Road, Tom Folsom to the east. Main access is to Harney Road to the west. Then we also have a proposed stub out to the southeast as shown. In closing, this is an infill development that will adhere to the surrounding development pattern of 2 to 5 units per acre to the north and part of the south, and adjacent to the south and west to higher intensive uses of warehouse and open and mini storage. And the future best use of this property is for a single family development. This PD zoning design allows for an efficient lot layout and to comply with the land development code requirements for stormwater, drainage, and buffering. That concludes my part of the presentation, and my client, Bill Sullivan, will come up here and say a few words as well. Thank you.
Okay, thank you. Yes, sir.
Hi, William Sullivan, 1350 Orange Avenue, Suite 201, Winter Park, Florida, 32789, Potomac Land Company. I just wanted to start for the first, when he began moving back a few slides, as he said there was buffering to the north, and then it's screening. It's not buffering. The county has changed the terminology of this screening, just to clarify. So let's go with the community outreach. We met with the community on more than one occasion. First, we had a meeting, a community meeting attending on March 2nd. We had a second scheduled for March 18th, and that's when COVID hit and everything shut down. We subsequently held a Zoom meeting with Oak Ranch community on September 3rd of this year. And at that time, before the meeting with Oak Ranch, we had reached out to the individuals in Oak Ranch along our northern boundary, individually met with them to find out if there were any more concerns before we moved forward. We did discover one. We did not have an entrance out to Tom Folsom from our project at the time in the plan. We then added it. It added 2 extra months to the plan time. That's why we're back here instead of 2 months ago, just getting through the process. But we did add that. In return for us adding the additional entrance, the Oak Ranch Homeowners Association provided a letter of recommendation for the community. And so that we have their letter of recommendation, and it's behind you. And so, it's part of the package. And hold on here, let's go back forward. I wanted to show you a little bit on the compatibility. I think this shows it best. Our artists have showed how it will look when it's built. And as you can see, you're going to have a mini storage over to the southwest of us, which isn't on the map because it's not built, but will be into the the southwest of us. And then also to the north of us, the community, and then the trailers to the south of us as well. And then across the street is, kind of an intensive, there's a commercial strip directly across the street. One thing we did do that was quite important when we designed this community is we took into account that we were next to the urban service area. We were at the edge of the urban service area. And so we built 2 ponds directly on Tom Folsom, and we have a 100-foot setback from Tom Folsom in our conditions. So we took into account, and then also we wanted to preserve, there's a large oak tree right there. If you can see the way the entrance is kind of meanders in, it's to accentuate about 125-year-old oak tree that's, I believe, if my recollection is about 60 some odd inches or 70 inches. It's really nice, impressive oak tree. And we wanted to accentuate it as you're coming in. Additionally, if you might have noticed, the community is called Summers K, and that's in honor of the former owner, who is Kay Summers, and she passed away a few years ago. And so, yes, we met with everyone and, kind of did everything we could. That concludes our portion of the.
All right, thank you for that.
Thank you.
And Development Services.
Yes, ma'am, sign.
Brian Grady, Hillsborough County Development Services. As noted, the applicant is requesting to rezone on approximately 13.88 acre parcel from agricultural rural to planned development for 47 single-family homes. The minimum lot size is 6,000 square feet. The applicant did a very thorough job in their presentation outlining issues regarding connectivity and it's the mixed-use development pattern in the area, addressing compatibility, which is also outlined in our staff report. I will note that one thing to add is that this area lies within the subbasin of the Hillsborough River watershed that is defined as being volume sensitive or a closed basin. Projects proposed in this area would be required to meet some of the most restrictive design criteria, 100-year design event versus a 25-year design event, while also demonstrating the adverse impacts to adjoining properties. Staff, based on the mix of uses as outlined in the applicant's presentation, our staff report does find the request consistent and compatible with the surrounding area. I will note that, the applicant mentioned that there enhanced screening along the southern and northern boundaries. That's not specifically referenced in the conditions, so we will amend the conditions to include those details for that screening graphic that they provided in their presentation, which is on their site plan and in their submittal. This didn't get reflected in the staff report, so we'll make sure to include that just to memorialize those commitments to the screening as outlined in our staff report. But again, staff does find this request approval and I'm available for questions.
Okay, Brian, thank you. No, I don't have any questions. And the Planning Commission, please.
Thank you, Melissa Leinhardt, Planning Commission staff. The subject property is located in the residential 4 future land use category. It is in the urban service area and also within the limits of the Thonotosassa Community Plan. The applicant is requesting to rezone the subject property from AR, which is agricultural rural, to a planned development to allow for the construction of 47 single-family dwellings on 6,000 square foot lots. The subject property is surrounded by a variety of uses. Light industrial uses are located to the west and south. To the southwest and north are several single-family residential neighborhoods. There's also multifamily residential to the west and agricultural uses to the east and south. The request is compatible with the general development pattern of the surrounding area and therefore meets the intent of future land use policy 1.4. While the subject property is located within the urban service area, it is adjacent to the urban service area boundary, as Tom Folsom Road serves as the dividing line between the urban service area and the rural area. Surrounding the subject property is a variety of residential lot sizes. There are rural sized lots, ½ acre to an acre to the south, while there are urban and suburban sized lots that are 6,000 to 8,000 square feet lots to the northwest and south. The proposal to develop single family dwellings on 6,000 square foot lots is compatible with the existing residential density of the area and serves as an appropriate example of infill development. The site plan for the planned development demonstrates adequate connectivity to adjacent neighborhoods and properties consistent with policy direction. There is vehicular and pedestrian access to the west to Harney Road, to the north to Oak Ranch Heritage Place, and a stub out has been provided to the southern boundary for potential future access. At the request of the neighborhood property owners, the applicant added a direct connection to Tom Folsom Road from the subject site. This additional access is consistent with policy direction regarding connectivity. A diversity of housing types and lot sizes is emphasized by policy 1-1.1 of the community design component in the future land use element. The proposal meets goal 8, objective 8 of the design element or design component by preserving the character of the surrounding area. The proposal meets compatibility requirements as defined in goal 12 and objective 12 of the design component. Particular policy 12-1.3 that requires new residential development in low density residential areas to be developed according to the planned development process. The proposed rezoning is providing lot sizes that are consistent with the Thonotosassa Community Plan, as the community plan promotes a variety of housing types and styles. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services. Thank you.
Melissa. Is there anybody here tonight in support of this request? Seeing none, is there any opposition to the request? Anything else from the applicant? Nope. With that, we're going to close PD 20-330. Thank you.
Next item is agenda item B3, rezoning plan development 20-0392. The request is rezoned from AS1 to plan development. Michelle Heinrich will provide staff recommendation after presentation by the applicant. Good evening.
Good evening, Matt Campo, 1725 East Fifth Avenue, Tampa, Florida. Here on behalf of the applicant. This particular application is just put that around there. 3.42 acre parcel. And with this graphic, I just wanted to point out, this is like a remnant parcel adjacent to Andover Village, which is the subdivision on the north and west side. South side is their stormwater pond. This is Nixon Road, and across the street is Canella Elementary. So it's kind of a remnant parcel. Little history on this for this past year is that it originally went for multifamily. Went through the Planning Commission to get a land use change, which was approved by the Planning Commission, denied by the Board of County Commissioners. Staff, or I should say staff, neighbors in the comments that they provided was, the pattern was we want single family. So that's back what we have that today. That's what we're bringing to you. Essentially, this particular project is a private gated 13 lot community. It has lots of 50-foot in size and larger. There's a variation of some of the sizes between 50 and 60, areas ranging in the 5,000 to 6,000 square foot range. That is pretty consistent with the Andover Village lots that are on our north and west side, which are also in that same size pattern, but actually maybe a little bit smaller. This is just a graphic from one of their plats, and this, again, is the parcel. You can see the lots on these two sides.
Can you talk into the microphone, please?
Oh, sorry. These two parcel lines are abutted by the same lot geometry as what we are proposing. Just demonstrating the compatibility and consistency with what's on our two frontages there. The actual project itself, I'm going to show you our site plan. Stormwater in the center. This was another one of the concerns.
Please speak into the mic.
This is one of the other concerns of the particular neighbors was they were concerned with the pond being on the perimeter adjacent to their property. So when we actually did the design for this particular approach, it was different than the the townhomes. Townhomes, we are abutting the parcel. So we put it more in the center, trying to accommodate some of the feedback that we got during the initial phase of the project. The parcel is ASC1. RM4 zoning, so the 13 lots is consistent with, RM4 land use, which is the 13 lots is consistent with that density. The stormwater in the center would be obviously consistent with Hillsborough County criteria. We do have 10-foot buffers on the north, on the west, and on the south side. And then a fence would be on the east side, abutting Canella. I'm going to bring up Matt Way, our traffic consultant, as well, to speak a little bit about the traffic. There it goes.
Good evening. Matt Way, 238 East Davis Boulevard, Tampa, Florida. I'm just going to briefly talk about transportation. So Hillsborough County's 2019 level of service report indicates that Nixon Road operates at 40% of its capacity. It's a level of service C. The multifamily use will generate 9 trips in and 5 trips out during the PM peak hour. It's a very few number of trips.
With the multifamily use?
Sorry, single family. I apologize.
All right.
Yep. The county has a roadway sidewalk improvement project at CIP 69638-007 currently in process. Under this rezoning, there's a condition to complete a pedestrian safety study to analyze pedestrian crosswalk access and to provide a new crosswalk with high emphasis markings, and flashing beacons for the school. Canella Elementary's capacity is currently at 69% utilization, and the applicant agrees with the proposed conditions, and staff has no objections.
Like the mystery, you know, you got to get it the right angle
I
there.
think you want it to go, yeah.
There we go, okay. So I was going to point out, one of the final items that I wanted to mention after Matt went was about the access. This was again, another concern that came up during the planning commission hearings that we had. This is the actual main driveway for Canella. And one of the concerns was pedestrian safety, especially student safety. So as he mentioned, you know, the conditions include an analysis and an actual commitment to do a crosswalk. This particular driveway is also what the project driveway is aligned with. So with those components, doing the alignment and then working in the safety study, as well as an actual crosswalk, you know, the intent is obviously to mitigate any concerns with safety for the school. So available for questions after if you'd like.
All right, thank you for the testimony. And Development Services.
Good evening, Michelle Heinrich, Development Services. As you saw, this is a rezoning of 3.42 acres from AS1 to PD to allow for 13 single-family lots, and that does result in a density of 3.8 units per acre. The property is in the Res 4 future land use category, which is a suburban land use category maximizing density at 4 units per acre. The site is also in the greater Carrollwood-Northdale community plan area and in the urban service area. No PD variations have been requested as part of this PD. As you saw on the applicant's site plan, the proposal is comparable to our RSC4 development standards. While the lot sizes and lot widths are slightly smaller than those found in RSC4, at lot sizes of 6,350 and lot widths of about 63 feet. The setbacks and the maximum building height of the RSC4 zoning district are the same. To mitigate for those smaller lot sizes than permitted in RSC4, the applicant is proposing buffering and screening along all PD boundaries, which is not currently required. Our compatibility analysis found that the area is developed with residential at suburban levels of density. As you saw, the Andover subdivision is located to the north, west, and south. That subdivision is developed with lots of about 5,000 square feet, 50 feet in width, which is smaller than what is proposed in this PD. And the stormwater subdivision pond is located to the southwest and to the south. Canella Elementary School is to the east. It is separated by Nixon Road. And as you saw, the project's access will align with the school's southern access point. The site is located on the west side of Nixon Road. The number of units does not warrant any site access improvements to the site, such as turn lanes. One access point to Nixon Road is proposed, and there are no opportunities for additional roadway connections to the north, west, and south due to existing development. Given the site's proximity to the elementary school, the project has been reviewed by Public Works traffic operations staff who have not identified any safety concerns. The applicant has proffered to construct a high-emphasis crosswalk to ensure safe walking conditions. Nixon Road is a substandard road, and an administrative waiver has been found to be approvable by the county engineer. We did not receive any objections from reviewing staff, and Planning Commission is finding this project consistent, and therefore we do recommend approval subject to conditions. I'm available if you have any questions. Thank you.
And the Planning Commission, please.
Thank you. Melissa Leinhard, Planning Commission staff. The subject property is located in the residential 4 future land use category. It is in the urban service area and also within the limits of the Greater Carrollwood Northdale Community Plan. The applicant is requesting approval of a planned development to permit the development of 13 single-family residential dwellings with 5,000 square foot lots. The proposed rezoning provides growth in the urban service area and meets the minimum density required by policy 1.2 with 13 single-family units. The proposed lots are compatible with the existing lot sizes in the surrounding area and therefore meets the compatibility requirements of policy 1.4 of the future land use element, which states that compatibility does not mean the same as, rather, it refers to the sensitivity of development proposals in maintaining the character of existing development. Objective 16 and its accompanying policies, 16.2, 16.3, 16.7, and 16.10, emphasize the protection of existing neighborhoods through various buffering and mitigation measures and the importance of connectivity and overall compatibility with the surrounding area. The proposed development is compatible with the surrounding land uses. The homes that surround the subject site to the north, west, and south, located in the Andover subdivision, are developed with residential single-family conventional 9 standards, and the proposal is to develop these homes with RSC 9 standards for lot sizes and residential single-family conventional 4 setback standards for greater buffering, and will help to mitigate any negative effects of the development on the existing community. The proposed subdivision will also provide for an efficient system of internal circulation that includes pedestrian sidewalks and provides a single gated access from Nixon Road. The applicant will also provide a pedestrian connection to the school across Nixon Road. The proposal therefore meets the intent of Objective 16 and its accompanying policies, as well as connectivity policy direction in the community design component of the comprehensive plan. The request is also consistent with the Greater Carrollwood Northdale Community Plan. Goal 2 of the Culture Community Design Objective has strategies that seek to preserve the suburban nature of existing residential areas. By providing a residential plan development that is similar in residential character and size to the surrounding neighborhood, the proposed rezoning meets the intent of this goal. Goal 5 of the transportation walkability objective of the community plan includes strategies that prioritize pedestrian accessibility with a focus on providing direct access between development projects and nearby amenities. By providing pedestrian connectivity to the school across Nixon Road, the proposal meets the intent of these strategies in the Greater Carrollwood Northdale Community Plan. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the Future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, and that is based on the conditions proposed by Development Services. Thank you.
All right, thank you, Melissa. All right, is there anybody in the audience today in support of this request? Nope, seeing none. Is there any opposition to the request? Anything else from the applicant? Nope. All right, with that, we'll close rezoning PD 2392. The next item is agenda item D4, rezoning PD 20-0690. The applicant's Homes by West Bay LLC. The request is rezoned from agricultural rural to planned development. Israel Monsanto will provide staff recommendation after presentation by the applicant. I will note that revised staff report has been handed out. The revision to condition 3.1 dealing with minimum width for driveways going from 18 feet to 16 feet. That's a change to the condition. All right, thank you.
Good evening. Cami Corbett with the law firm of Hill Ward Henderson representing the applicant. I have not been sworn, nor have all the members of our team.
Okay, if there's anybody in the room that, or actually virtually as well, that hasn't been sworn, please rise now, raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. Thank you. You give me one quick, true house clean moment. I'm gonna wipe down my keyboard.
Yeah.
Microphone. I have an extra thing of wipes if anybody who's here after me would like to do the same.
Can't have too many.
I know we're all getting a little bit fatigued from all of this, but it's still out there and it's still a pretty big deal.
That's right.
So give me a moment to, I have a presentation, but I'm going to go through it pretty quickly in the interest of time. This is a pretty straightforward request. It's east of Balm River View Road. It's an infill site. That's a good graphic from Israel's staff report. He always has good graphics, which shows the infill nature of this site. This is the future land use map, which shows the surrounding Res 4. And it's a straightforward request. It's 20.55 acres. It's for 64 single-family homes with a minimum lot width of 40 feet. That's 3.16 dwelling units per acre, and that's 78% of the maximum density. We are providing enhanced buffering and screening on the northern boundary. That's not required by code, but we're doing that to increase compatibility with the lots to the north. We're providing 2 connection access points, and we're not proposing any impacts to wetlands. And this is just a brief graphic on the lot standards. These are some key points from the Planning Commission staff report, finding of consistency. I won't go through them. I know they'll go through them in their report, but there are several policies that are cited as supporting a consistency finding of this application. Similarly, from the Development Services report, we have findings of compatibility, and some of these are the key points, and I'll submit this into the record so you'll have it for your review. We have no objection from the Transportation Department, subject to conditions, again, providing connectivity, preserving right-of-way, making improvements, and we have an administrative variance that's deemed approvable by Public Works. And with that, I'd like to ask Steve Henry to come up and address the transportation issues.
Thank you.
Good evening, Steve.
Good evening.
Steve Henry, Links and Associates, 5023 West Laurel, Tampa 33607. Oh, if we can keep that. All right, so Links and Associates conducted the traffic analysis, and we also did the administrative variance for the project. So the first thing I want to talk about is access. This is a graphic here, shows the access locations. We were asking for a full access to Balm River View Road. It's about 800 feet from Tucker Road. And then in addition to that, we're asking for the access to 3rd Street. And in conjunction with that, we are proposing to improve 3rd Street to TS3 standards. This is the actual TS3 standard that we're proposing to improve 3rd Street to. Then as a part of the analysis, we looked at Balm River View Road, and this is a graphic that illustrates the level of service of Balm River View Road. The right side shows the AM peak hour, left side shows the AM, right side shows the PM peak hour. The green is the peak season traffic. The blue is the additional traffic that we're adding, and the line on the top of the dash line is the level of service D capacity. So as you can see, both in the AM and the PM peak hour, the roadway operates at acceptable level of service today, and then with the addition of the project traffic. Balm River View Road is considered to be a substandard road. Which is the reason we had to file the administrative variance for that. And as Ms. Corbett had said, that the county engineer has deemed it approvable. One of the things with the county is that we've only got one typical section that we use for all rural roadways in Hillsborough County, which is what's up there today, which is the TS7. So that's what we're comparing it to. One of the things I want to show you is on Balm River View Road, the north 1,000 feet of the road are actually a curb and gutter road. And then south of that, it transitions into a rural road, 2-lane roadway. And this just kind of shows you a street view of that northern section, which is the curb and gutter. And then this shows a street view of the section right adjacent to the property. This is two-lane rural roadway, sidewalks on both sides of the road. The first thing is that we had asked for the administrative variance is for the right-of-way. The TS7 has 96 feet of right-of-way. But this particular roadway, Balm Riverview Road, is on the corridor preservation as a two-lane enhanced roadway. And because the property is in the urban service area, we actually use the, I'll put it up here, we use the TS4 standard for right-of-way widths. And since it's an enhanced roadway, we add the 12 feet, which makes it a total of 76 feet is what is required under the corridor preservation. There's 66 feet out there today. So that's a 10-foot difference. We give the 5 feet. So that's where the 5 feet comes from that we're providing in the conditions of approval. Then in addition, then also we've got the TS7 has 12-foot lanes. Currently out there today, there's 11-foot lanes on Balm Riverview Road. And when you look at the Florida Design Manual, 11-foot lanes are appropriate for this type of facility. They actually provide in the design manual the different lane widths depending on the type of roadway and the speed on that roadway. And then finally, when we were doing the administrative variance, we had to look at the accident data along Balm Riverview Road. So we looked at that data from 2015 to 2019. And we did find that there were a number of accidents on the curve of Balm Riverview Road just north of Tucker Road. But the Public Works was actually aware of this. They've already started a program of improvements. One is adding flashing beacon lights just prior to the curve. In addition to that, they're adding vibratory pavement markings within the curve, hoping to eliminate or reduce the number of accidents. But if in fact, once they do those, it still doesn't work, they're prepared to do additional improvements if necessary, based on the type of accidents that may occur. So that concludes my presentation, unless you've got any questions.
I don't, but thank you for that.
Thank you.
Mr. Henry?
And this is just a quick graphic of the information that was in the staff report showing, this is in response. We received 2 emails of objection into the record. Both were discussed transportation and this blinking light at Balm Riverview and Rodine. And so staff included in their report sort of the program, this light is going to be installed, it's planned, it's funded. So they included that. There were also concerns in the emails about when the access management study was completed. It was completed in April of 2020. Our counts were completed in February 12th, 2020, and the increased number of trips is insignificant. And of course, that was pre-COVID. So there were some concerns in the email that we weren't properly capturing the impacts to traffic because the counts may have been done post-COVID. Again, as Steve said, most accidents are caused by distracted driving, which is the county is addressing. And then lastly, also the objections about school concurrency. You've heard this a number of times. The school capacity is determined at site development, specifically Land Development Code, Section 4.02.08 2B2, which says it's determined during preliminary plat review, and construction plans and subdivision plans, plats cannot be approved without capacity. Again, both staff reports are very thorough and they do a very good job of showing the consistency and compatibility of this proposed proposal, and we do not have any substantial competent evidence submitted into the record to support a denial. And with that, I'll conclude.
All right, thank you for that. Development Services.
Israel Monsanto, Development Services. The applicant seeks to rezone 2 parcels currently zoned AR to planned development. The proposed PD will be 28.5 acres in size. The site is located on the east side of Balm River Road, about 1 mile south of Boyette Road in Riverview. Future land use is Res 4 and is occupied today by a single residence. The request is to rezone the site to allow up to 65 single-family detached dwelling units. The applicant is proposing minimum lot size of 4,400 square feet with minimum lot width of 40 feet, and any lot developed with a lot width less than 50 feet will have to have at least 2-car garages, specific lot layouts for driveway width and location, as well as tree placements consistent with previously approved PDs in the county. The applicant originally requested requested 44 lots, 60 feet wide. However, the number of lots did not meet the minimum density requirements from the comprehensive plan. In order to meet that requirement, the applicant reduced the lot width and sizes to accommodate a higher number of units. Proposed PD would include a 10-foot landscape buffer along the north and east of the PD boundaries adjacent to larger single-family lots. The applicant is proposing to build public street within the subdivision and will provide interconnectivity to the north by improving Third Street to county standards from the subject property boundary north to Tucker Road. The site will have its main access from the west of Bond River Road. Per LEC Section 60606, proposed and adjacent uses would not be required to be buffered or screened against each other. However, as noted, the applicant is proposing buffers and screening to reduce impacts between proposed small lots and surrounding larger lots. An administrative variance was requested to the county engineer for Bond River Road, requesting relief to require improvements to the road between Boyette Road and project access. The county engineer found the variance approvable. As such, no improvements to that portion of the Bond River Road would be required. If this rezoning is approved, the county engineer will approve the administrative variance. Adjacent zoning districts permit residential uses today. PDs surrounding the site are currently approved for and developed with lots similar to development standards to those being proposed for this subject plan development. Residential lots along the north, while zone RSC2, are a mix of 1 acre and less than a quarter-acre lots in size. Most of these lots are separated by a 30-foot wide unimproved right-of-way named Palm Avenue. Although screening and buffer between the proposed projects, again, are not required by code, the applicant is proposing the buffer. And now, along the north, the separation of at least 40 feet would be accomplished with the proposed 10-foot buffer and the additional 30-foot right-of-way, unimproved right-of-way existing there. Also, a solid screening consisting of a 6-foot high fence will be placed along the north. The area today consists of residential uses surrounding subdivisions to the east, south, and west, currently developed with similar and compatible development standards. The only remaining large agricultural parcel in the area is the subject site. Vehicular and pedestrian connectivity is being provided north and west of the subject site. Planning Commission found the request consistent with the comprehensive plan. The proposed number of lots meets the minimum and maximum density permitted by the future land use of Res 4. No objections were received by other reviewing agencies, and the project will be subject to subdivisions regulations and school concurrency at the time of plat review. Based on all these considerations, the staff recommends approval with condition. Mr. Scarola, as Mr. Grady pointed out, there is a revised staff report with the condition 3.1 being updated. There is also a typo on condition 5.2. The condition states now that the buffer area along the north and east shall not be platted as a separate tract, but actually has to be platted as a separate tract. So that's a typo that's being corrected. And there is also on the first page when the description of the project starts, the acreage is being corrected to 20.5 acres instead of 10. And I'm available if you have any questions. Thank you.
But thank you, Mr. Monsanto. And the Planning Commission, please.
Thank you, Melissa Leinhard, Planning Commission staff. The subject property is located in the residential 4 future land use category. It is in the urban service area, and it is also located within the limits of the Riverview Community Plan and the South Shore Area-Wide Systems Plan. The application requests a rezoning from agricultural rural to planned development, allowing for 64 single-family detached residences with a minimum lot size of 4,400 square feet. The proposed planned development allowing single-family dwellings is similar to the established development pattern and is consistent with the residential 4 future land use category. The proposed site plan proposes a total of 64 dwelling units, which meets the minimum density policy 1.2 by providing for up to 75% of the allowable density under the residential 4 future land use category. Future land use element policy 1610 states that compatibility does not mean the same as, rather it refers to the sensitivity of development in maintaining the character of existing development. The applicant is providing a 10-foot landscape buffer and a 6-foot opaque fence along the northern and eastern boundary to remain sensitive to the surrounding development pattern consistent with policy direction. The proposed development is providing connectivity to the north, meeting the intent of policy 13-1.4 of the community design component, which states that communities are to be designed around a grid network of streets or a modified grid, which will improve interconnectivity between neighborhoods. The subject property is located in the urban service area where growth and development should be directed according to the future land use element focused on objective 1. The application is also consistent with the Riverview Community Plan, which encourages attractive residential development that complements the surrounding character and provides housing diversity. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the Future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services. Thank you.
All right, thank you. Is there anybody here today in support of this request? Seeing none, is there any opposition to the request? Okay, anything else from the applicant?
Yes, very briefly, if I could, Cami Corbett for the record, if I could ask Ms. Leinhardt a question. Again, earlier this evening, I heard her testify about the timing of growth within the urban service boundary, and I would just like to ask her if she could repeat those comments because it directly relates to transportation and school concurrency.
Ms. Leinhardt?
Absolutely. I can restate what I've said previously in that the comprehensive plan and the future land use element does include policies relating to the timing of growth and having adequate infrastructure in place. And we, as the Planning Commission, rely on the technical agencies and experts to give us the information, and without objections, then it's compatible with the future land use element and the timing of growth policies.
Ms. Corbett, clue me in on the reason for that.
Because objective 2.1 is being utilized as a basis for denials for rezonings. Oh, I need that back. It being used as a basis for denial. And so the timing of growth, they're saying growth is premature if there are not adequate public facilities, when reality is adequate public facilities are implemented through the land development code.
Through concurrency.
Correct.
Right, is that your point?
Right. Concurrency, exact. School concurrency and transportation is no longer considered as part of the adequate public facilities provision of the land development code because that was removed when they eliminated concurrency and went to mobility fees. So that's the relevance of that testimony.
Gotcha.
And if I could get my PowerPoint back real quick, I don't know where it went. Anyway, there are some slides that are in your packet which you can review. One of them, two of which we're going to make the point of the location of the people that sent in the emails. One of them is 4.8 miles away, and found that that person moved into their home in March of 2019. Interestingly enough, talking about the timing of development, the property was actually zoned in 2004 and wasn't platted until much later, and then just built the home in 2019. And the person who is directly adjacent to the development actually is in a development rezoned and developed by the same developer, Homes by West Bay. And that information's in the record for you. Now, with that, I'll conclude.
All right, thank you very much for that. And with that, we'll close PD 2069. The next item is agenda item D5, major mod application 20-1070. They have Ms. Craig Bazarski. The request is for a major modification of existing plan development. Tanya Chabella will provide staff recommendation after presentation by the applicant. Good evening.
Good evening. Throwing things around. Clayton Bricklemeyer Law Group, representing the applicant. This property is on the west side of 301. Yeah, I thought I was doing that. Let me see. So that, if I wanted to look that way, that's north.
Yeah.
It's between Cali Road and Big Bend. We were just here getting this approved. That blue area and actually the white area were all approved for C and uses with some conditions. We are back because right after we finished that, we were approached by a tenant who would qualify as minor auto repair, as these things tend to go. And so what we have now is neighborhood auto repair. We're asking for approval of minor auto repair. So that's why I'm back. The development services staff, I'm trying to figure out how to go fast because I'm trying to make sure we get done. Development services staff has recommended approval and we appreciate their support. The planning commission has found us not in compliance, so I am forced to run through their objectives and policies that they cited. Melissa actually just ran through some of them in support of the previous thing. Objective 1, we're in the urban service area where development should be directed. Policy 1.4, compatibility does not mean the same as that we are addressing compatibility through conditions, which we can talk about. Objective 16 / policy 16.1, and these are all, I printed these out. I have a little package for you that I'm going to submit. Is the neighborhood protection provision. We are protecting the neighborhood through the conditions that we are proposing. You'll see, I'll just talk about them now. There's an 80-foot buffer being provided between the nearest garage to just to the property boundary. So to the structure, to the residential structure to the west, from the closest garage opening on this minor auto repair, it's 80 feet to our property, a 50-foot right-of-way, and then a front yard setback. In addition to a screen provision that's at
Wait, you said 80 feet, then a 50-foot right-of-way.
Then a front yard before you get to somebody's home.
Which way were you going from the?
Sorry, from east to west. So the western edge, sorry, here, I'll use this. This home right here, or these two homes, would be, we're restricting this use to this parcel A. The nearest garage is going to be 80 feet from its door to the property line. So the actual experience of the people living back there is going to be, there's an 80-foot buffer plus the right-of-way plus the front yard setback to get to their home.
How big's the right-of-way?
I was at 50 feet in the development services the staff report. That's all I can base it on. That's what it says in the staff report.
80, 50 plus a front yard.
Correct. That's the buffer distance. The screen is called out in 3.4. It's 15 feet on center. It was negotiated with the neighbors. And so actually back to this objective 16 policy 16.1, we have support letters in the file, no objection letters. The neighborhood, I think, is a pretty good arbiter of whether or not they're being protected.
Including for the major mod?
Yes, including. And I have those are actually available as well. Yeah, we had support before. We went back to the same people. They're supporting again. They negotiated the screen and the buffer. We provided it for them. We think it's more than adequate. Policy 16.2, I wanted to talk about this one. This is that gradual transition. Oh, what makes the most sense there? From south to north, you have a transition. This V right here is a car wash. The northernmost portion of this site is a car wash. It's a CG use that's contained in a PD. We located this use, which is a CG use, next to this CG use on purpose. That transitions from a CG use, CN use up to the gas station at the corner of Cali and 301.
So Tijuana Flats is CG.
No, it's in a PD that contains this car wash use that is a CG use.
Okay.
The Tijuana Flats, I think, is a CN use. I don't, Brian. Yeah. I mean, the restaurants are CN uses. The car wash that is here, and you can maybe see it. There. That's the drive-through part of the car wash. This is a CG car wash. There's vacuums and stuff all down this side. So the idea was to put the CG use next to the CG use and provide and so as you're coming from south to north, you provide that transition.
Well, just to be clear, it's a CG zoned or it's PD? It's a CG.
It's a PD with a CG use inside of the PD. Same as we're asking for.
Yeah.
We're asking for a PD with one CG use and a bunch of CN uses, a heavily conditioned CG use. If you're talking about it from east to west, which is brought up in the Planning Commission report, this is a Sprouts Center grocery retail center and a hospital across a 6-lane highway to a heavily conditioned CG use with a gigantic buffer and a screen and then residential. The sort of unique situation with the narrowness of the block is what it is, but I think we think that that's a very reasonable transition from east to west.
You mean the narrowness of the block with respect to the fact that there's residential, right?
There's residential just to the west. It is what it is. It's very close to US 301. 16.3 is integration, which we are achieving through those conditions. 16.5, the project sits on US 301, which is a major arterial roadway. That's the requirement. We meet it. Objective 22 is locational criteria. We need a waiver. They're not recommending that we need a waiver. I have 3 things to say about that. The first is we should not need a waiver, and we wouldn't need a waiver but for the fact that it's hard to update the map that they use. They don't use the functional classification map. They use this highway cost affordable map. This road here, which is on the south side, I'll show you why I'm wide. You see the hospital there?
Yep.
Okay, so that's where we are. We're 30 feet north on the other side of the node created by this, which is Fairway Meadow Drive.
We're looking north, right?
Yeah, north is this way. So Fairway Meadow Drive sits right there on the south side of the Sprouts, north side of the hospital. And it runs all the way through here, down here, and it dead ends into a wetland here and kicks back out onto Big Bend Road. So it touches 301, it touches Big Bend Road. The map was updated in 2018, doesn't include this road. This road wasn't built in 2018. It was finished by the hospital and the Sprouts guys. I assume it's going to be on the next map, in which case we wouldn't have been asking for a locational criteria waiver because we would meet it because that's a collector road and it serves all of these homes. Now, it may be a major local roadway, and Melissa and I have spoken, and she doesn't even know if she necessarily disagrees with me. I'm going forward anyway because I don't know if this is 500 homes, and I didn't want to continue and find out it's 475 homes, so I don't qualify for major local roadway. It doesn't matter. I think we should get the waiver anyway, but my number one argument against it is it wouldn't be occurring if the map was updated properly or there was an easier way. Any fair map would not require this site because that is obviously a node. I just don't think anybody can argue that. Secondly, we actually got the location waiver criteria on the previous rezoning, and the only change is one heavily conditioned CG use at the southern end abutting a CG use. So the previous zoning when I was here, we got the waiver criteria. Third is policy 25.3 is commercial infill, and I have it printed out, but the basic point is there is a block. And if more than 50% of the land on your block, and our block is established by Crowley to the north and Summerfield Lane or something to the south, if more than 50% of that is developed with commercial, you can do commercial infill. It's like 100% on our block. The Planning Commission, I think I'm not 100% following their argument here. I think they're saying there's some claim that because there's existing permitted commercial uses on the site, it doesn't qualify for that exception. I don't get that one. The second is that I have a hard time even characterizing that it's too intense to qualify. The policy 25.3, and I printed it out and it's in there. It's in my little evidence package, says that you have to put comparable intensities. So we couldn't drop a concrete plant or something. I would argue that a CG use next to a CG use is comparable. I don't see how it's not. And therefore we should qualify for the commercial infill exception.
Is it the CN uses to the north of the problem?
I guess so. I think that's the argument is they're trying to only look at RPD and say, oh, well, you just approved a PD and it's only CN and therefore it's not comparable because you're adding a CG use. Well, there's another CG use there. And even at CN, I would say the grocery retail, the center across the street is surrounding properties for purposes of that policy. And it is more intense, I would argue, than what we are proposing, which we've got conditioned down to the point that we've got the elevations are in the file. Riverview Community Plan, we're providing appropriate and compatible buffers. Therefore, I think we satisfy that. The summary is we have an approved PD. The only thing we are changing is this. We are taking an oil change place and making it eligible to be a tire store. In order to do that, we've specified the location of that tire store, the It put in a huge buffer, a thick screen, all negotiated with the neighbors who are affected by it. We put architectural restrictions in place to the point that there is actually an exhibit to the conditions, the elevations. And we've limited the hours, and we've done the orientation of the garages north and south. So the garages don't face the residential or 301. They face the car wash and the CN uses to the north.
It's a single building that's oriented.
That building is a single building. I mean, there will be other buildings. We're not doing a big strip of retail. It's a freestanding tire store. So the summary of the Planning Commission report is that it's just too intense. They just make a conclusory that it's too intense. There's no real, I can't even really answer any criticism there because it just makes this statement that it's too intense. I don't know how that it's a tire change place is less intense for traffic purposes. It's got the elevations, it's got all the extra buffering and whatnot. So I would argue that in some ways it's less intense. So that's all I have on the Planning Commission. There are a couple condition changes that I think Tanya's going to read in, and I don't know if Brian spoke to her yet, but there is a condition 3.4 that's actually written in there twice in the staff report. The more restrictive has the evergreen trees 15 feet on center, which is actually the original condition, all the way along the Western Road buffering. And that's the one, we're going to strike the one that says 20 feet on center. We're keeping the more intense one. And I'm available for questions. And so I have the civil and the traffic.
All right, I'm good for now. Thank you.
Thank you.
And the development services.
Development Services. Good evening. My name is Tanya Chapela. I am presenting a revised report. Mr. Grady, in my recollection, he was going to present that report to you. I would like Mr. Grady to confirm that is correct.
The revised report has been handed out.
Okay, thank you. The applicant is seeking a major modification to a plan development 20-0182 to allow for motor vehicle repair minor land use. The site is located at US Highway 301 and Stelling Drive. The applicant has requested an administrative variance to the requirement to improve Lakeland Road between Stelling Drive and Coley Road to current county standards to develop it to current county standards. A second variance for the project's access spacing on Stelling Drive has also been requested. A new condition number 1 has been added to add certification requirements. The building elevation shall be part of the site plan file. A note shall be included to the site plan making reference to the elevations and to restrict the motor vehicle repair minor development to those building elevations. Condition number 2 has been amended to allow for motor vehicle repair minor on parcel A. This condition also includes mitigation provisions related to the new use, such as structure orientation, hours of operation, and distance separation between the western boundary of parcel A and garage door locations. A new subsection number 2.2 is added to specify hours of operation for motor vehicle repair neighborhood serving uses. A new subsection 4.5 is added to require the tree planting and screening on parcel A along the western boundary. A row of evergreen shade trees which are not less than 10 feet high at the time of planting, a minimum of 2-inch caliper, and are spaced no more than 20 feet apart. The trees are to be planted within 10 feet of the property line. Condition number 5 has been amended to exclude the motor vehicle repair minor building from the design provisions. Subsection 5.1 has been amended to limit the pitch roof requirements to the office buildings only. A new condition number 13 is added to address transportation comments. And then conditions 1 to 13 have been amended to accommodate the new numerical order. So the site is located on a commercial corridor in the Riverview community. Property to the north is zone CN and is occupied by a gas station, a convenience store, and a food truck. The site is separated from the RSC6 and the RSC9 mobile home parcels by a developed right-of-way of approximately 50 feet in width. So to the west of the site is US Highway 301 and the Summerfield development, permitting office and commercial uses along the corridor. Several properties within the area are zone PD and CG, allowing for CG uses. Those properties have been developed with mini warehouses, personal services, retail, shopping centers, and restaurants. Additionally, the adjacent property, Zone PD 18-0174, allows for a full-service car wash, a permitted use in the CG zoning. To enhance the project for compatibility with surrounding residential uses, the applicant has proposed the following to create a motor vehicle repair minor project. Restricting the motor vehicle repair minor project to Parcel A, offering hours of operation for the minor auto repair project, agreeing to comply with an improvement building design requirement to maintain the existing development elements such as height, scale, mass, and bulk of structures and architecture. Provision of buffering and screening along the western boundary, which is not currently required by the Land Development Code. Provision of an 80-foot separation between the building and the western boundary of Parcel A, preventing noise and other impacts. Based on those considerations, Development Services staff has determined that the use is compatible with the area. Planning Commission staff finds the proposed major modification inconsistent with the comprehensive plan for an unincorporated Hillsborough County. A waiver to commercial location criteria is required, and it is not recommended for approval by Planning Commission staff. No objections were received from other agencies. Staff has determined that the use is compatible with the area. Staff finds this request is approvable, subject to conditions. This concludes my presentation. Thank you.
Mr. Bell, just a quick question.
Mr. Squirrel, I was going to clarify again, as noted by the applicant, they're committing to the tree plantings of 15 feet apart as opposed to 20 feet apart. So we'll reflect that more restrictive commitment.
Yeah, so my question was about that, but it was whether this new staff report has already included that, or that has to still be.
That still needs to be corrected, because yeah.
Okay, so I can look for a corrected staff report at some point.
Yeah.
That's all.
Yeah, that's all. Yeah.
Thank you. And the Planning Commission.
Thank you, Melissa Leinhardt, Planning Commission staff. The subject property is located in the Residential 6 Future Land Use category. It is in the urban service area, and it is also located within the limits of the Riverview Community Plan and the South Shore Area-Wide Systems Plan. The application requests a rezoning on approximately 4 acres located on the west side of US Highway 301, south of Cowley Road, and on both sides of Stelling Drive, from agricultural single-family conventional 1 to planned development, allowing for commercial neighborhood uses with restrictions. The application is currently approved for commercial neighborhood zoning district uses, with the exception of minor and major auto repair, convenience stores with gas pumps, drive-through restaurants, car wash, gas stations, and sexually oriented businesses. Motor vehicle auto repair is limited to neighborhood serving auto repair. The application requests to modify the planned development to allow for minor auto repair. The subject site does not meet locational criteria. Commercial locational criteria is based on the land use category of the property and the classification of the intersection of roadways as shown on the 2040 Highway Cost Affordable Plan. Roadways listed in the table as 2 or 4 lane roadways must be shown on this map. Panther Trace Boulevard and US Highway 301, and then Big Bend and US Highway 301 are 2 qualifying intersections, but the site is not located within 900 feet of either intersection. Summerfield Crossing is a major local roadway. A major local roadway must connect at least 2 or more collectors or higher roadways, and or be primarily the access road to at least 500 dwelling units 500 dwelling units from a collector or arterial roadway. Due to Summerfield Crossing being a major local roadway, Summerfield Crossing and US Highway 301 is also a qualifying intersection. Per future land use element policy 22.2, commercial uses need to be located within 300 feet of this intersection to qualify for commercial locational criteria. Major mod 20-1070 is located more than 300 feet outside of this node, and consequently the site does not meet commercial locational criteria, and a waiver was required. A waiver request has been provided to staff for review. The waiver states that the request is justified by the unique location of the project parcel, which is on the south side of the T intersection of US 301 and Stelling Drive. At this location, US Highway 301 is a 6-lane high-volume highway that includes motor vehicle repair minor uses such as Mavis Tires and Brakes 2 streets, which is about 1,500 feet south of the subject parcel. In addition, the project is bordered by non-residential and commercial zonings to the north, south, and east that include a gas station and mini storage warehouses to the north, a Sprouts anchored shopping center immediately to the east, and numerous other commercial uses on the south along US Highway 301. The waiver also states that well over 50% and nearly 100% of the block from Summerview Circle to Stelling Drive is already zoned or used for commercial uses, allowing for consideration for commercial infill development in accordance with policy 25.3. The parcel's location and surrounding uses provide for compatibility and consistency under the request. However, to mitigate any concerns with this request, the applicant has proposed site plan enhancements and additional conditions. This includes at a minimum all restrictions provided in the abutting car wash, PD 18-0174. The applicant has also proposed conditions to minimize the impacts to nearby residential development, which includes placing the motor vehicle repair to the south, limiting store hours from 7 a.m. to 7 p.m., maintaining an FAR of 0.13, and moving the building closer to US Highway 301. Staff recognizes that the applicant has agreed to utilize site planning and mitigation techniques to better mitigate for the adjacent single-family residential lots. Planning Commission staff also acknowledges that the proposed site fronts Highway 301, which is an arterial roadway. Numerous commercial uses are located along this highway within the general vicinity of the subject site. However, the subject site also has access to Stelling Drive, which is a local roadway and is adjacent to single-family residential lots. New development must demonstrate the gradual transition of intensities between different land uses through the use of professional site planning, buffering, and screening techniques, and control of specific land uses per policy 16.2 of the future land use element. Development and redevelopment are also required to be integrated with adjacent land uses through the creation of like uses, the creation of complementary uses, or the mitigation of adverse impacts. The proposed modification does not complement the surrounding area and is too intense of a land use. The subject site is zoned planned development and is currently approved for some CN uses. The applicant seeks to add motor vehicle repair minor as a permitted use. Minor auto repair neighborhood is one of the uses currently approved for the site. Policy 25.3, as cited in the applicant's waiver request, requires that the intensity of the new zoning district should be comparable to the intensity of the zoning and development to the surrounding parcels. The proposed modification would not provide a gradual transition from the subject site to the residential uses to the west. The modification would result in a more intense use in close proximity to single-family residential accessing Stelling Drive, which is a local roadway. Since commercial is currently permitted on site and the proposed minor auto repair use is too intense for the site, the proposed modification does not qualify to be considered for the commercial infill exception per policy 23.5 of the future land use element. The addition of a more intense auto repair use would undermine the intent of future land use element policies 16.1, 16.2, 16.3, and 16.5 with regard to compatibility. Planning Commission staff recommends that the Board of County Commissioners not approve the waiver to locational criteria. Major Mod 18-0174, which allows for a car wash located immediately to the south of the subject site, was found consistent with the comprehensive plan, even though it does not meet commercial locational criteria. It should be noted that this major modification does not have access to a local street and does not undermine the intent of policy 16.5 of the future land use element. The proposed modification would also undermine the Riverview Community Plan, which requires the provision of appropriate and compatible buffers and transitions to existing adjacent land uses. The proposed modification would not provide an appropriate and compatible transition to the adjacent single-family neighborhood uses to the west of the site. Consequently, the modification request is not consistent with the Riverview Community Plan. Based upon those considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Melissa, a couple of questions for you. And I'm not sure exactly the roadway name, but I believe it might be Fairway Meadow Drive. Can you comment on that and its consideration for locational criteria?
I can certainly speak to that. That roadway is across eastward, across US Highway 301, and it is not located on the cost affordable map and is therefore either, if it's not considered a major local roadway, it is not a qualifying intersection. I did speak with Mr. Brickelmeyer today, and we did discuss the possibility of the site of that roadway having 500 or more homes, which we were unable to verify as of today. And I did also let him know that even if the site was determined to be meeting locational criteria, I'm not sure that that would get us to a consistency finding today.
Okay. And then could you also comment, and I think you did actually as you're reading, but there was a lot of information there on the intensity of the PD to the south and its car wash use directly adjacent to the proposed use.
Yes. That analysis was included in the staff report, and that major modification 18-0174 that does allow for a car wash use and was found consistent with the plan. But again, that did not have access to a local roadway like this application does.
So they weren't taking access off of
Snelling Drive. Snelling.
Could you repeat that, Melissa?
I'm sorry. Yes, that major modification was not taking access from a local roadway like this application is, which is Stelling Drive.
Stelling Drive, that's the one.
Yes.
Okay. All right, thank you, Melissa.
Thank you, sir.
All right. Is there anybody here in support of this request? Seeing none, is there any opposition to the request? Mr. Brickelmeyer.
Just briefly, since you asked, I wanted to hit on Stelling if I can get the Elmo. Try to push it so that it's north. Their map is probably the easiest one to see it. Stelling Drive runs from 301, 2 blocks and dead ends, or 1 block and dead ends right there. That's it. I think it's pretty disingenuous to calling this taking access off a local road. There's not a single driveway on this road. We have support letters from people up and down Lackland Road, which runs north and south right there. Lackland Road and whatever that Lucinda, whatever the road is up there, go directly to Cowley. To try to frame this as a local access is, I'm not for that. I've neglected to mention.
What would you consider it?
Well, I mean, so technically it takes access off, but it's, to me, that's a distinction without a difference. It sits on 301. And in fact, if you look at their policies on strip commercial, which is what we purport to be trying to avoid, they're trying to cut down on the number of curb cuts. So the alternative to this would be that we put a curb cut in front, we put multiple curb cuts on 301, which nobody wants and FDOT wouldn't approve anyway. So in effect, we're actually helping with that. And then it's being held against us. it's on 301. There's not, the time spent on Stelling is a very small amount of time that we've had to make that so that it's the turn. I did just want to hit real quick, and then I'm happy to answer questions. The FAR for this project is right around half what's allowed in Res 6. It's a 0.13 and a 0.25. Brian did the 3.4. Actually, that's it. Do you have any questions? Yeah.
Nope, I think I'm good.
All right.
All right, with that, we'll close Major Mod 201070.
The final item is agenda item D6, rezoning PD 20-1150, the Athens Bridgeview Apartments. The request is a rezone from CG and PD to a planned development. Israel Monsanto will provide staff recommendation after presentation by the applicant.
Okay. Good evening.
Good evening. Elise Batza with Stearns Weaver. Can you put up the presentation, please? Thank you. The property is located on Hillsborough Avenue, and it contains approximately 30.4 acres. It is west of the International Airport. It is part of the Hillsborough Avenue Overlay District and within the urban service area. Surrounding zonings are CG, to the west, CG and RSC9. There's also wetlands and a church and a school. To the south is Berkeley Prep, a school campus, and to the east, CG and RMC 20. The future land use, as you can see, is a portion is in R20 and a portion is OC 20. Those are also the surrounding future land use designations for other parcels. So this was originally, if you look to the original 1984 plan there, the entire boundary was once approved for 820 multifamily development. That includes everything within and without the red. So approximately half of this property was at some point removed to the south and is now Berkeley Prep. You can see to the baseball fields and where that's been developed. So currently what is left within the red outline is 29.3 acres developed with 348 residential units. The request is to add, and this is a little bit of an awkward graphic, but at the very north end of the property, we just want to add in 1.4 acres to what was already the PD. Currently, that's a Pep Boys commercial use. We would get rid of that Pep Boys, and we would take the existing entitlements that are still left that were never developed as part of that original PD, and we'd spread them over that additional acreage. So we are not asking for any additional increase in intensity or density. We are just asking to spread that onto new property. Very quickly, 53 multifamily units would be developed on the new parcel, existing entitlements. There's existing ingress and egress on West Hillsborough. There is an interconnection on Reflections Club Drive. That is the very small drive that goes up to Hillsborough. Right now, PEP, that 1.1 acre parcel, has its own ingress and egress on Hillsborough. That would be closed off and they would share one access point. From a compatibility standpoint, it is compatible with the surrounding uses. Zoning districts in the immediate area consist of already multifamily residential support, and commercial uses. And this would take away some commercial property, intense commercial, and put residential on that property. There are some connectivity constraints. As you can see, Hillsborough Avenue, which is on the right of your screen, the yellow is where this site currently accesses. The red, of course, is the new property. There will be an interconnection there, but because the creek bounds on one side and everything else around it is already existing, interconnectivity with adjacent land uses is difficult, if not impossible. It is consistent with the comprehensive plan. I'm sure Planning Commission will talk more about that, but we have listed some of the policies and objectives. I won't go over those tonight in the interest of time. In conclusion, Planning Commission staff and Development Services staff have found this project consistent with the comprehensive plan, compatible with existing and surrounding uses. We would ask for your recommendation of approval, and we're here with our consultants as well to answer questions. Thank you, sir.
Thank you. And with that, how about development services?
Good evening, Israel Monsanto Development Services. The applicant intends to expand the acreage of an existing apartment complex zone PD in order to construct 2 new buildings. The site is located on the south side of Hillsborough Avenue, 500 feet east of Hanley Road in Tampa. Most of the site has a future land use designation of Res 20, while portions along Hillsborough Avenue are designated under the office commercial, OC 20 future land use classification. Total acres of the project is 30 acres. The request for a PD is to add again land to the existing PD and redevelop the newly added acreage with multifamily residential. Specifically, the applicant is requesting to add more or less 1.1 acres of CG zone property to an existing 29.3 acres apartment complex. That apartment complex is zoned today PDH 840320. The combination of the 2 parcels would allow the spread of unused available density, as stated by the applicant, currently permitted under the PD, across the additional acres provided by the CG zone parcel. That parcel contains a closed Pep Boys Auto Service Center with direct frontage on Hillsborough Avenue in an area of strip commercial development. As the applicant stated, the original PD was approved for 820 multifamily units over an area more than 60 acres in size. The PD included 35 multifamily buildings and a clubhouse. Before the PD was fully developed, it was modified in 2001, and approximately half of the property of that original PD was removed, portions south of the Sweetwater Creek, and added to a private school site to the south, the Berkeley Prep. Today, the remaining area of the PD, which is 29.3 acres, is permitted for multifamily development at a density of 13.64 units per the acre, which represents the original density of the PD. The multifamily units are distributed in multiple buildings with access on Hillsborough Avenue. The PD currently is developed with 348 units, total of 17 buildings and a clubhouse. The density of 13.64 dwelling units per the acre over the existing PD acreage of 29.3 acres would allow for the redevelopment of a total of 399 multifamily units. The project is within the Hillsborough Avenue Overlay District, regulated by Land Development Code Part 31500, and this overlay provides for building placement along Hillsborough Avenue frontages and parking placement requirements. Since the CG parcel being incorporated into the PDs located along this road, future improvements of the project will be subject to the overlay requirements and development standards. The proposed general site plan shows the new multifamily units within buildings located along Hillsborough Avenue north of the project. Zoning districts in the immediate area of the subject site consist of multifamily residential support such as schools and churches, and commercial uses. Proposed PD is only adding acreage to expand an existing multifamily project, and the overall density is being maintained as the originally approved PD. The project could potentially be developed with a density of up to 20 dwelling units per the acre. However, maximum density proposed is below 14. Future multifamily buildings along Hillsborough Avenue will be constructed in accordance with the Hillsborough Avenue overlay regulations, and all other standards will be as approved by the PD zone portion, including wetland setbacks, screening, and buffers. New development will provide parking as required by code, and building height for the future multifamily buildings will be consistent with surrounding zoning, allowing structures with similar height. No objections were received from reviewing agencies, and based on all these considerations, staff recommends approval with conditions. We have provided a revised staff report, removing 2 conditions, number 9 and 10, that were part of the original rezoning conditions from 1984. These conditions pertain to drainage easements that were required to be dedicated to the county when the apartment complex was rezoned and built, and according to the county real estate department, these easements have been dedicated already and the conditions have been satisfied. So staff does not object to the removal from the proposed conditions, and you will have the revised staff report. And I'm available if you have any questions. Thanks.
But thank you, Mr. Monsanto. And the Planning Commission, please.
Thank you. Melissa Leinhardt, Planning Commission staff. The subject property is located in the residential 20 and office commercial 20 future land use categories. It is in the urban service area and also within the limits of the Town and Country Community Plan. The applicant proposes incorporation of the commercial general parcel into the overall plan development and utilization of the additional space provided by the CG parcel to construct 51 additional multifamily units with their associated parking. The plan development already permits 53 multifamily units. Since the additional units are already permitted, the result of the project, if approved, would be to relinquish the intensity allowed by the CG parcel, relinquish 2 dwelling units allowed by the PD, and spread the density of the plan development among the additional acreage of the commercial general parcel, such that the final density of the project would be 13.12 dwelling units per acre. According to the application, the additional land also will include improvements to the overall access to the property and improved visibility for the development. The intent of the residential 20 future land use category is to have high-density residential development, as well as urban-scale neighborhood commercial, office, multi-purpose projects, and mixed-use developments. The intent of the office commercial 20 category is to recognize existing commercial and office centers and provide for future development opportunities. The site is surrounded by the following uses: light and heavy commercial, light industrial, public quasi-public, single and multifamily, and a school. The request to add land to an existing plan development and develop 51 previously permitted multifamily dwelling units is consistent with both future land use categories and will not disrupt the development pattern in the area. The request is also consistent with the Town and Country Community Plan. The plan recognizes Hanley Road at Waters Avenue as a secondary town center and encourages redevelopment of existing commercial sites within designated town centers. The request will result in the redevelopment of a commercial site that is no longer in use into a multifamily residential unit or into units with a designated town center. The proposed plan development is consistent with and facilitates the vision and the goals of the Town and Country Community Plan. And based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by the Development Services Department. Thank you.
Thank you, Melissa. And so is anybody here tonight in support of this request? Seeing none, is there any opposition to the request? Anything else from the applicant? With that, we'll close rezoning PD 201150, and that'll do it for the evening. Thanks, everybody, for your assistance.
Paralegal will get mad if I don't bring it back. I always forget.